Good morning. Yes, good morning, everyone. We'll start in 3 minutes. There's a slight confusion, multiple agendas going on. I don't know, mine said 9, but Randa said 9:15 and she's the boss. So it's 9:15, everybody. So just give us a few minutes, okay?
It will give my laptop a chance.
Okay, so it's gonna be Randa, Julie, okay, and then Lisa.
And this is this.
Hello. Oh, yes. Okay, good morning, everybody. It's wonderful to see you all again as we start day 2 for a very important panel where we're looking at gender justice for Palestine. I personally wanted to hold this panel. I think we're all very acutely aware of what is happening today in occupied Palestine. And I also believe that this community has a particular role to play if we're looking at international criminal law and gender justice. We have to admit that traditionally, this community has not given sufficient attention to the situation of Palestine. That's not only since the war began, but even in the past. So I urge you all to have the courage to speak out and talk about the situation of Palestine, which should have been happening for decades, at least when the war began, and as we continue. Certainly at Legal Action Worldwide, we reached out to this community when we gave a diplomatic briefing 1 month after the war started to alert that the indicators of genocide were there. That is what we have the warnings for. And we urged individuals in this community to support us and to act. Insufficient numbers stood up for the situation of Palestine and looking at what is happening. But that shall not remain any longer, which is why we come together at a very important moment to look at this situation. Not only do we have a situation where we're looking at massive violations of international law, but also a failure to look at the gendered element of not only the war, but of the occupation, which is why we're here today with dear friends and very good colleagues who are on the panel. And we have Yuli. We can't see Yuli. Is Yuli there? Yuli's joining us from, can we see her? Can we have her on? We're going to get her online. Who's joining us from Tel Aviv. She couldn't travel to be with us today. At Legal Action Worldwide at Law, we have been holding roundtables where we bring together Palestinian, Israeli and international lawyers to look at these issues for more than a decade. These dialogues are important, particularly to have women having these dialogues. There's Yuli. Hi, Yuli. Good to see you.
Hey,
Thank you
good
for joining
morning.
Today. I'd also like to note, as did Alex yesterday, that we have very important colleagues and partners that have been sanctioned, Al-Haq, Al-Mazan and PCHR, and we condemn these sanctions as we do the sanctions that have been imposed on those working for the International Criminal Court. So, gender justice for Palestine, what a difficult discussion today. You'll notice that I'm talking quite a bit. I will be talking quite a bit. I'm not only the moderator, but also I'm taking the liberty to speak and to engage and to have a discussion on this panel and discussion with all of you here today as well. We want to hear your thoughts, your views as well, because as we said yesterday, it's not talking is important, but action is equally important, and that's what we need to look at in this situation. I'm going to pause there and I'm going to turn to Randa Sinara, who's the Deputy Director General for WICLAC. Randa, I've known you for a long time. Your work in this area, of course, is at the forefront. And sometimes I just wonder how people keep going. Honestly, I question that and wonder, and we're going to hear from you today, and also the particular difficulties that you face as a woman, and particularly working on these issues on gender as well. A very warm welcome, and to all of our panelists, Amrita and Yuli, I'll be introducing you in turn. Thank you. I think I have to pass is this one working as well? I don't know. Okay, I'll pass this one to you. Randa, the floor is yours.
Thank you very much. Good morning to everyone. And to Yuli from
Tel Aviv as well. Actually, the Women's Center for Legal Aid and Counseling, WICLAC, is a feminist human rights organization. We post ourselves, or we identify ourselves with the human rights community in Palestine, with always keeping the gender lens. This is the added value of WICLAC. Beside giving the individual legal aid and services to women victims of gender-based violence, and we are very much engaged as in international advocacy and in issues related to gender justice generally at the domestic level, but at the international and regional level as well. So our work for the past almost 35 years has been focused on addressing the Israeli violations, war crimes, crimes against humanity, and genocide acts against all the Palestinian people, but with focus on women and girls with a gender lens. Because as you most probably know, women are disproportionately impacted by colonial occupation, conflicts, and so on. And often their bodies are used as tools of war through the conflict-related sexual violence to which they are subjected, and which we have documented with evidence-based data. So coming to our work with the challenges that are faced, Antonia, and for everyone I'm speaking, monitoring and documentation of violations is a big challenge, especially after the 7th of October, where human rights defenders, field researchers, and our staff have been always being, challenged by getting the necessary documentation with the Israeli restrictions, and even the attempts to check on the mobiles and the movement of the people, to the extent that the people or women giving testimonies to WICLAC earlier was much easier than after the 7th of October, with the Israeli harsh policies and sanctions or arrests or even harassment of Palestinian women. And therefore, our network of field researchers have been really challenged to do the necessary documentation from a gender lens. But despite that, even in the Gaza Strip, we had the courage of these women working in the field, all the time displaced. Some of our field researchers have been displaced in the Gaza Strip twice or 3 times. And at the same time, they were continuing their work. Even one of them has been displaced more than 3 times. So despite that, they continued their work. They were trying to reflect on the gendered impact of the occupation. So unlike the other mainstream human rights organizations who rarely gave focus to the gender impact of the occupation on women, WICLAC has been able to do that and to engage with all possible international mechanisms through submissions, reports, addressing the Commission of Inquiry, providing evidence-based data in order to verify that information and include the gender lens into all the work that we do. Also, there has been a lot of challenges related to, through our individual legal aid and services that we provide on gender-based violence, on family matters, we have seen the interconnected relationship between colonial occupation policies and patriarchal structures in our society, which enforce each other. And that really exacerbates the suffering of Palestinian women and make us see other components related to, for example, I just want to give a quick example, women asking for family unification, because there's this exhibition up on the stories of women that Palestinian women married to Palestinian from the West Bank, married to Palestinian men from Jerusalem, are, if they are in the circle of violence, domestic violence, and they want to leave the marriage, they remain in they endure violence because Israeli policies of family unification and residency permits are very much connected with the husband applying. So not to lose their right to custody, to residence in Jerusalem, which is heavily dependent on the husband. and is manipulated as well within a patriarchal structure, makes women endure violence in many cases, not to lose their rights or residence, be illegally, quote unquote, living in Jerusalem. That's one example how these enforce each other and make it more difficult for women under colonial occupation. Also, many examples can be given, but I want to go to the how WICLAC tried to navigate its way through strategic litigation or using universal jurisdiction at the international level or regional level through looking at different jurisdictions. And in fact, the problem that we faced is that, especially in cases that we documented on sexual violence and rape to which women have been subjected, is the very fact that it was always challenging to allow make the women speak out or are ready to give their testimonies or file the complaints with us. And therefore, we had to look at other cases to bring in, for example, home demolition was more possible because it has a major impact on the lives of Palestinian women, but the issues related to sexual or violence or any kind of sexual related violence by the occupation in detention or the women that have been kidnapped from the Gaza Strip has been much more difficult to address. And despite that, because we are among the human rights community and due to the Israeli policies and the designation of 6 human rights organizations as being, quote unquote, terrorist organizations, with Israeli draft law being proposed to be submitted to the Israeli parliament or Knesset, where any engagement with the International Court of Criminal Court, the ICC, would incriminate organizations and individuals. And even the proposed legislation would entail that even the submission of printed material or communication to the investigating committee of the ICC on Palestine or on the occupied territory will be incriminated. That will lead to detention, to sanctions, in addition to the sanctions imposed on already 4 human rights organizations, including Ad-Damir, with Al-Haq, Al-Mizan, and PCHR, the Palestinian Center for Human Rights. Nobody is immune to these kinds of sanctions, and we are being listed somehow on we are on the queue, and any organization could expect to be on the sanctioned or incriminated only because we're abiding with international law and international criminal law and trying to provide data and information. Despite that, we work with the Commission of Inquiry, the UN Commission of Inquiry on the occupied territory and Israel. We are trying to provide connections to them to speak directly to the victims or survivors. And we are happy that we are being able at least to provide to quasi judicial bodies like the Commission of Inquiry this information. But at the same time, we think that we have a lot of opportunities if we see more solidarity and support from our partners who really believe that the gender justice component should be highlighted, because with all respect to our human rights organizations, that they are engaging with the ICC and other mechanisms, they rarely focus on the gender aspect of that and could read it with more sensitivity to gender issues. And mostly they are gender neutral or even gender blind. And therefore, it is our role always to highlight the importance of or the different way how Israeli crimes and crimes against humanity and genocidal crimes are affecting the lives of Palestinian women. Reprocide is now one of the issues that we address, especially that women are prevented from giving birth, and this is clearly stipulated in Article 2 of the Genocide Convention. And therefore, we try to highlight these crimes and bring the evidence for how women are being prevented to give birth in the group. And this is accumulates with the experiences that we need from specialized organizations within the UN system or international organizations who should support our work. I think I want to reiterate what Antonia said at the very beginning. We think we always are critical, and our community are now very critical, especially among the women's human rights organizations or women-led organizations, that they think that the international organizations working on accountability has not given enough attention to the work to highlight the gendered impact of the occupation on the lives of women and girls. And they think that much should be done on that, while we've seen the people in the in the northern part of the globe going out to the streets and supporting the Palestinian right to self-determination and to stop the unfolding genocide on Gaza. We have not seen the voices of feminist movement, especially in the northern globe, coming up strongly and supporting the work of feminist organizations. And this is an ask from us now, from me being here, and from other feminist and women-led organizations in Palestine to really work in that direction and enforce that work we are doing. Thank you very much for your tolerance and listening to me.
Thank you so much, Randa, and also for setting out so clearly the multiple layers of discrimination that women are facing throughout the war and the ongoing occupation. And I think we all admire the work that you and your colleagues are undertaking and hear your call for support. Now I'm going to move to Yuli Novak. Yuli is the Executive Director of B'Tselem. She joins us online from Tel Aviv. Yuli, it's good to see you. I hope you can hear me. Can you hear me, Yuli?
Yeah, I can hear you all very well.
She joins us online. Oh, that's strange. I'm listening to myself. Sorry, Yuli, wait a moment. Okay, I think we've...
Okay.
Yuli,
Can you hear me?
thank you again for joining us. Yuli, can you tell us about the recent reports and research you've undertaken in relation to sexual violence in detention? And can you tell us, Yuli, what is it like to be working on these issues currently living in Israel? Thank you so much, Yuli.
Yes, just to make sure you can hear me.
Yes, we can.
Okay, good.
Wi-Fi.
So thank you all, and it's good to be with you even far away. And it sounds. I'm really sorry I couldn't join yesterday, but it sounds like a very interesting getting together, an important one. So thank you for having me even from afar. So you asked basically about a report that we published a year ago about the condition in detention centers. Since then, we at B'Tselem published, had a few publications. The last one was a publication we called Our Genocide, which was published a month and a half ago. In which we try to analyze the situation in Gaza, but also in the West Bank, and the situation under the Israeli system, as we understand it, as a system that became genocidal and that conducting genocide in the Gaza Strip, but also has this element as implication on other spaces that the system is in control. And when we look at what takes place in the detention centers, Israeli detention centers, in regard to Palestinians, we think about it as part of a larger systematic action of the Israeli apparatus, of the Israeli regime. And in that sense, once we enter this world, this paradigm of genocide, and think and look on everything that takes place here through these lenses, I have to say that professionally, but also personally, things are changing. We're kind of in a new world at the moment, as professionals, as human rights activists, as lawyers, and just as the people of this land who live through genocide at the moment, either if we're part of the group that of the perpetrators, like me, I'm an Israeli Jew, or my colleagues were Palestinians, some of them were part of the group that are the victims of this genocide. So I want to speak very shortly about what takes place, what you asked about, what takes place in the detention center, but within this scope. Because the main thing that the report we published last August, we called it Welcome to Hell. And this wasn't a name that we invented. It's something that we heard from testimonies from prisoners that gave us testimonies after they got released from Israeli jails and detention centers. They said they heard the guards telling them exactly that. Bruchim habayim lagehenom, in Hebrew, welcome to hell. And in a way, that's what the Israeli detention centers became after October 7th. And in a way that I think is an example of what the Israeli system in a whole turned into since October 23. So the most basic element when we're talking about genocide, and I'm not going to go into the legal element of it, I'm sure many of the people sitting there know that, but there is something. No, genocide is not just a legal crime. It's also a political phenomena, a social phenomena, phenomena of political violence in its extreme form. And one of its basic elements is the erasure of humanity, of people. When the system itself is now oriented to erase a whole group, not because of what specific people done, but because of their being part of a group. The main goal is to make the group disappear. It doesn't mean that you have to kill each and every person. In that sense, what you have to do in this process is to completely erase the humanity of the individuals. And we see that in Gaza. Again, I'm not going to focus on that, but when we look at what takes place in Israeli detention centers, what we see is actually a network of facilities that stop being jail or oriented to lock people who did something bad and now they need to get punished, but a system of torture camps, in a sense that each and every person that enter this facility, their humanity is being erased in another way. It doesn't matter what you did. For most of them, and we're talking about thousands of people that are held just as we speak now, sit now and speak. Thousands of Palestinians were held with no trial. Most of them weren't going to be charged for nothing. They're going to be released without knowing what they have been stopped or held for. And all of them, or the vast majority of them, going to suffer from harsh torture. And that's what, in our view, turned these facilities from detention centers, from jail, into what we call torture camps. And again, it doesn't matter who you are, it doesn't matter where you're from. We're talking about Palestinians from the West Bank, from the Gaza Strip, even some of them Israeli citizens from within Israel. And again, this is one element of the genocide that takes place in another space that is inside Israel or in the West Bank, but the detention centers. When we are talking about this, how facilities become torture camps, we're talking about a holistic practices that turn them into that. So again, I'm not going to go into much details, but we're talking first and foremost about arbitrary, ongoing physical and mental abuse that is happening towards everyone. The living conditions that they are suffering is extreme. We're talking about, from what we know, between 10 to 14, sometimes 15 people held in one cell. Not everybody have beds to sleep on. Sometimes not everybody have even mattress to sleep on. They are prevented from to hold anything in the room. So the room are completely empty of anything. We're talking about people beating up daily, about people being starved. So again, the same mechanism that we see taking place in Gaza towards the whole population is taking place in a different scale inside the prisons. Deprivation of sleep, inhumanitary sanitary conditions, denial of medical treatment. Again, we can go through each and every element of the living condition that a person needs. Now, we know that because to base our report, we interviewed more than 50 people. The vast majority of them got released without any charges, being held after weeks or months of being held in these detention centers. And each and every person, and we're talking about 16 different detention centers, each and every person went through these tortures. So we understand it and coming to the understanding that we're talking about something systematic. But here I want to say something else, because we have our conclusion based on the materials and the information that we get. But there is also something that I want to mark that I think is important when we're talking about the condition in Israel-Palestine, is to see that everything that I'm telling about the detention centers is not something hidden. What we see today in Israel, both in Gaza on the ground, in the West Bank, and regarding to the detention center, is that in a sense, Israel lost even the intention or the willing to try to hide the clear actions of what they are doing. So when we're talking about the detention center, the minister that is responsible over the Israeli prison system is the Itamar Ben-Gvir, which is a name you probably all of you know, is the most right-wing hardliner politician Israel ever had in its history. And he is the person who got responsibility over the prison centers and the police way before, not way, but few months before October 7th, 23, when this government, the current government, got into place. And when he got the position, he announced this was his flag-like operation to change the conditions inside the prisons. And after October 7th, and in that sense, the horrific attack by Hamas on October 7th was and not in that only example, was an opportunity for the Israeli leadership, which is at the moment has, again, the most extreme hardliners in control. I'm talking about Ben-Gvir, I'm talking about the Bezalel Smotrich and others, to really use this moment and the collective trauma that Israel went through as an opportunity to advance an agenda that was already there and announced about before. And, you know, when you open Israeli TV, if you speak Hebrew, you see dozens, and I'm talking about dozens, of media pieces that were PR pieces that were brought through by the Israeli prison system, just like the Israeli army in other cases, that actually show us exactly the condition within those facilities. So they are very proud of what they are doing. Each and every Palestinian there is considered what in Hebrew is called Asir Bitchoni, security prisoner. Again, regardless of what you did, you're not going to see, most of them not going to see judges. So they're not going to know why they got arrested for. And once you are the security prisoner, in the Israeli discourse, usually the shortened for that will be your nukhba. You're one of those persons who got into, of those Hamas fighters who got into Israel on October 7th and committed these horrible crimes. Now, some of them might be, but not all the people that are held within not the Palestinians that are held within Israeli system, prison system are those. So I'm just giving it as an example to add another layer of this, and this is the dehumanization. The fact that the erasure of the individual, the person, also works together with the complete dehumanization of the Palestinian as a whole, as a group. And that's what allow Israel to conduct, in our understanding, what it does or part of what allow it to do what it does in the Gaza Strip, and just the same within the Israeli prisons.
Thank you. Can you hear me, Yuli?
Yes.
Thank you, Yuli, and thank you so much for joining us today. And I know there'll be questions for you. And we know how difficult it is for Palestinians to be fighting right now. But don't forget that those Israelis like Yuli who have remained in Israel and fight on behalf of the situation, not only for Palestinians, but for Israelis, for your own future society and for what's happening today. They also need our support in your courageous work. Yuli, thank you so much. Now I turn to Amrita Kapoor, who's the Secretary General of WILPF. WILPF has been one of the few feminist-led feminist organizations that has been working and speaking out on the situation of Palestine. So we're very pleased that you can join us here this morning. Amrita, the floor is yours. Thank you.
Thanks so much, Antonia, and thank you for the invitation to speak. I will start by saying that I am both incredibly privileged to speak on this panel with Randa and Yuli and WICLAC as a partner, but also incredibly humbled. I am just here very conscious as a representative of the many extraordinary Palestinian women, members and feminists who cannot be here. And I think, therefore, it's really appropriate that I start in terms of looking at what does feminist resistance look like in Palestine with a quote from a feminist leader in Gaza. She says, "Many people only heard about the siege on Gaza in recent months or after October 7th. But the truth is, this siege began decades ago. It is the longest siege in history. It is a colonial siege deliberately designed to destroy the very possibility of life. A siege with many chapters, from counting calories to counting martyrs, from bread lines to death lines, from the world's complicity to the steadfastness of Palestinians, especially women and girls, against all odds." I want to take a moment. So this quote is such a powerful example of one of the key forms of resistance that we see from Palestinian women, which is challenging the dominant narratives that render them invisible, insisting on centering the lived experiences of women, girls, as well as the full Palestinian population under occupation, the effects of militarism, settler colonialism, and the gendered forms of violence. So this quote actually comes from an event that WILPF hosted as a side event in the last week's Human Rights Council 60th session. Once again, Gaza was not on the formal agenda. And it is another form of silencing and of invisibilizing these types of experiences. So WILPF held a solidarity event entitled Voices from Gaza, Feminist Resistance Under Siege and the Cost of Complicity, which I think is a very appropriate point to start with these remarks. And this event really linked storytelling and lived testimony with accountability pressure, aiming to ensure that the gendered harms under occupation are documented and named. And so I think really my remarks here are really drawing the same links between the lived experiences of Palestinian women and girls on the ground, and how do we link that to our accountability efforts, and what do we mean by accountability? So if we look again at another form of resistance, we see that everyday choices and ways of living in Palestine are themselves a form of resistance. So the women's survival strategies in organising community care, sustaining families, ensuring education, all of these are feminist acts of resistance to militarised erasure. And here I'd like to mention another example highlighted by the Noble Women's Initiative recently on their Palestine delegation that I was privileged to join WICLAC on as well, where the title of this report is Samud as a Feminist Tactic. My presence is my defiance, as a quote taken from there. And I think, again, this is highlighting the quiet but existential resistance to erasure, even when legal and international political and legal criminal justice communities fail to intervene or fail to succeed in their efforts to intervene. And it also pushes back against the framing of resistance only as visible protest, insisting on a recognition of the deliberate choice to stay and to continue doing everything that they do as political. The next element of resistance I'd highlight is just the legal mobilisation. You've already heard this from Randa already, but the cases that have been brought to the ICC, UN treaty bodies, but also more broadly, the types of submissions circulating across the practitioner communities. Many of you will have been part of these, really highlighting both that gender-based violence must be recognised as central to the accountability framework, but also importantly building solidarity between different international criminal justice and advocacy campaigns. And here I'd mention obviously some of the solidarity between the Afghanistan and gender apartheid advocacy campaigning and strategies with the community in Palestine and the gender dimensions there that are being explored. And then finally, cross-movement solidarity, so that Palestinian feminists are linking all of these struggles, the anti-colonial, anti-militaristic, anti-patriarchal struggles, to demonstrate how women's resistance operates in this intersectoral and multifaceted way. And here we see that there are lessons, and this is where I'll draw some of the parallels to other international criminal justice struggles around the world. We see in Latin America, Argentinians, Mothers of Plaza de Mayo, Guatemala's the Cepozaca case, where the persistent truth-telling and survivor-led legal mobilization was demonstrating how feminist resistance can actually shift accountability narratives. And this is something that's not just for now, but it's for decades from now. And this is such important work that WICLAC is doing right now in the moment, despite all of the challenges to gather the evidence for this promise of accountability in the future. We see in the former Yugoslavia, we see how women's groups mobilized to ensure that sexual violence was actually prosecuted at that time. And here we see that same parallel with Palestinian feminists and legal lawyers and justice advocates working in all sorts of concerted and strategic ways around the world in national and international courts. And then finally, I'll mention South Africa, because here we see so many of the parallels which go beyond international criminal justice in terms of prosecuting individuals and looking at the limitations of this approach and the importance of dismantling structural violence and the need to ensure that we don't reduce this to criminal trials of individuals. And here I think this is where we cannot understand what is happening in Palestine today without understanding the root causes and the structural drivers of this conflict. South Africa is a powerful example of how we actually, as an international community, need to target the settler colonial genocidal state as a key to resistance. And we see that that type of mobilizing worked eventually in South Africa. And this resistance, taking that now, means action that is deeply uncomfortable for all of us. As Special Rapporteur Albanese outlined in her report on the economy of genocide, it is going to be uncomfortable, but it is also about recognizing that this is not just international criminal law, but much more around the structural drivers and the preconditions for this. So some takeaways are that accountability must be intersectional, gendered harms must be central and a part of the root cause analysis of the structural context giving rise to militarism, occupation, apartheid and genocide. and that legal strategies and grassroots resistance are mutually reinforcing. So international criminal justice gains strength when it's anchored in women's lived experience and collective mobilization. We've learned this through the examples I've just mentioned, and we're seeing this play out in Palestine. Solidarity across context matters because this is where we build transnational feminist alliances that then enables Palestinian women's resistance to resonate globally and to pressure international mechanisms. And WILP's role has often been to connect these strands, to link that grassroots feminist resistance to international accountability fora, insisting that justice be both legal and structural. So I want to conclude here by acknowledging both the extraordinary moment we live in, where in fact international criminal law's relevance and effectiveness is not just under siege, but under threat in a way that can actually be quite existential to the future of this project, because we are seeing real-time genocide and nothing has halted its process. And so if we look to understand why this has come about, when we look at the intersecting systems of patriarchy, militarism, nationalism, colonialism, and racism, that's the only way we can see why this is happening right now. And we also see from this that international criminal law cannot continue in the same siloed way that it has. We've already stretched traditional criminal law roots from looking at individual criminal behaviour to saying, well, let's have a look at command responsibility. Let's look at the military and political structures that enable these systemic and large-scale violations. But we will actually need to continue to stretch this to be able to encompass the nature of the type of crimes that are being committed, but also to have a hope of challenging the impunity and ultimately deterring international crimes. We know that international criminal law is rooted in patriarchy. And in fact, what I'm going to leave you with is that this idea that we actually need to not just continue to be innovative in the ways in which we use international criminal law as a tool for justice, but as Yuli described, we actually need to see legal institutions and spaces as being used for this political and systematic goal. So this is what feminist movements have always done, and always done brilliantly, is to see, to name and dismantle these intersecting systems, influences and sources of oppression. So I'm going to finish with a question that echoes Randa's question, which is, at a time when gender justice is under threat, but it is also an essential tool to challenge the current regression to a trend of impunity, how can we, as practitioners or scholars, seek and bring this wisdom from feminist movements around the world into our practice of international criminal justice, more strategically, to broaden not just the scope of our potential impact, but to feed back into the broader feminist movement to achieve the goals of gender justice? Thank you.
Thank you, Amrita. We're going to open up for questions. But before we do, let's hear that call to action from Amrita, from Randa, and also from Yuli. There's so many people here from Ukraine, from people within Africa, Asia. Stand up. There are others under occupation. Stand with the Palestinians. Support Israeli colleagues who are also speaking out. Let's all have courage. That's the very least that we can do right now. And on that note, let's see if anybody would like to ask any questions or any comments that you may have. Yes, please. Do we only have one microphone? Oh, we've got two. Okay, let's take a round of questions, and then we're going to come back to some final comments to our panelists before we close.
Hi. Oh, okay. Thank you so much for all of your contributions on the panel, and Yesterday we were hearing a lot about, in terms of solidarity and networking between different activists, the idea of ideological purity and its necessity. In the context of Israel-Palestine, I think that impulse for ideological purity has been weaponized in certain contexts to say and stereotype Palestinian society as not sufficiently feminist or queer-friendly enough, and using that as a justification for the genocide. Similarly, outside of that context, this is a space politically that is already so fragmented in terms of the end goal of that activism. So I'm within the pro-Palestine movement. I'm wondering, as activists, feminist human rights activists in the space, how do you view and navigate the idea or need for ideological purity, either in terms of feminist outcomes or the political outcomes of Israel-Palestine?
Thank you. Do we have any other questions? Yeah.
Good morning, everyone, and thank you for such a powerful and necessary session. My name is Priya Gopalan, and I used to be the chair rapporteur of the UN Working Group on Arbitrary Detention. So a lot of what Yuli spoke about in terms of detention in Palestinian detention facilities is something that I'm familiar with. The working group has a long line of cases relating to detention in Palestine. And zooming out from the working group per se, but within the UN Special Procedures System, there has been a fair amount of work done in relation to the human rights violations in the OPT. Francesca Albanese, the Special Rapporteur on the OPT, released a report last year, as we all know. It was called Genocide as Colonial Erasure. Picking up on the points that some of the panelists have made on the importance of synergies across different systems of law, ICL and human rights. We saw that in the decision of the ICJ in July last year, there was significant reliance on findings of the UN Special Procedure System. So we have examples of work that has been done within the human rights system. We have some examples of synergy where there has been reliance. What I'm curious about, or the question I have, relates to the challenges that the human rights system is facing at the moment, as we all know, whether it's in terms of something as practical as funding, but also challenges to its function, how it can exist, its role. And these are the complex challenges that we face in the current context. So even if special procedures has had this role in terms of highlighting particular human rights violations, in this instance relating to Palestine, what we find is that there is a serious shrinking space in terms of the ability to conduct this work. So the question I have really to the group and to the panelists is, in this context, and bearing in mind what Antonia started with, which is the very true statement, and I think a lot of us feel a burden around this, that we have not done enough around this issue. And I'll just finish with what Amrita said. We have seen real-time genocide, but nothing has halted its progress or the process. So what is it we can do as practitioners sitting here who are obviously willing to contribute? It's a big question, I know, but I'll be curious given the expertise in the panel on this particular issue. Thank you.
Thank you very much, Priya. Good question. I think we're going to take one more, and then we're going to come back. And just while we're waiting for the microphone to be handed over, as we heard from Yuli, thousands of people are being held with no trial in detention facilities across Israel. And we represent aid workers, medical healthcare workers that are being detained, and there simply are not enough lawyers, and we'll come back to Yuli, to assist them and to represent them under a special program that we have on protecting aid workers that are under attack. Yes, please.
Good morning. Thank you so much for the brilliant panel. My name is Tamika and I'm a South African human rights lawyer. I just wanted to touch on the point on South Africa's case. Of course, it was a very bold step that they've taken in the ICJ. But looking at the very critical perspectives of gender justice in the context of Palestine, I'm wondering if those perspectives have properly been captured on the case that is already pending. And what role do we as practitioners have, and as everyone in this room, how can we contribute to ensuring that those perspectives are captured as the case progresses? Thank you.
That's a very good question. If we run out of time, everybody, we do have a panel looking at the International Court of Justice, where that question can also be fully addressed. Let's come back for some small comments and then see if we have some more questions. It's important to hear from everybody. Let's start with you, Randa, and I know you wanted to clarify something else.
Yes, thank you very much. I really maybe wanted, before, responding to the issues that have been raised, just to a bit highlight the gendered impact of sexual violence in our context, in detention and in Israeli jails and Israeli facilities. I think that sexual violence has taken a lot of forms, and because of the understanding of, our legislation, sometimes the women who were giving their evidence and information about sexual violence did not realize that this is rape. They were, for example, imposing objects in their genitals. And that for them is not rape, because rape, they think that it should be in a certain way. And even because the Jordanian law that applies, or the Palestinian law in Gaza that applies, defines rape in a different way. It should be penetration by the male organ only. And that's the misunderstanding and the cultural context which give different meaning to that. But it was rape. And they did not understand that it's rape. They were explaining how they have been searched nude, and they had to bow, and then all the female prison guards were sarcastic about their genitals, and they make them make sexual acts in front of others. Even during raids on homes and so on, they were really asking women to come in front of all the men of the family, who are blindfolded and kept in one place, and to speak about her intimate relationship with her husband and if he satisfies her or not. Not only that, but imposing all their lingerie and saying that these women are sluts and they are happy to put them on military patrols and so on. So the sexual violence has taken a little different forms. They have been also threatened with rape and raped. Actually, they were also kidnapped from Gaza and put in trucks with with men who have been nude, and their bodies were very close. They imposed on women to take out their veils and not respect how dishonoring and this not dignifying women. So it took a lot of forms at checkpoints, or for example, preventing them from the sanitary pads while they have their period and got inflammations. And this is happening in detention centers, that women are not allowed to have their hygiene kits. And therefore, these are issues that we as feminist human rights organizations can highlight. And the women feel much more free to speak about them. Now, with regard to the issue of solidarity, solidarity is needed because as we work together as feminists, no matter what is, I don't understand this ideological purity. In my opinion, nothing justifies genocide acts, no matter what they are. It's not justifiable, and it's not whether we are defined as feminist society or not is not the issue. The issue is that it's clearly these are crimes that are being committed on women, and the bodies of women are being used as a tool of humiliation and a tool of war, and are humiliating the dignity of women in our society. And by the way, the feminist leadership in the Gaza Strip, which I feel very modest in front of them, have continued working with women at the grassroots and have really tried to provide psychosocial support to women who have been released during the exchange of hostages with Palestinian prisoners. And therefore, I think the solidarity is because we have a cause as feminists and because we have the conviction that sisterhood is global. Otherwise, why don't we work together? We have to be against the deep roots, as Amarita said, of colonial occupation and decolonize our thinking and so on, and try to really move forward together with the expertise and practitioners that are filling this room. That yesterday I learned a lot. I was like an enthusiastic cat, listening to every one of you and seeing how can I navigate that and include it. You know, everything that was said was important. And knowing about all these networks, about all these international bodies working on international criminal law are important paths that we can really see how they can fit into our context to solidify our solidarity in both ways. It serves us, but it serves the whole humanity to work together as feminists towards gender justice. Finally, I just want to fully agree that all the mechanisms are important and each one feeds into the other and are important. You know, I was told that the reports that we do not stand in the court, but all the quasi-judicial and the judicial bodies that work on international accountability or international criminal law and accountability, we're saying that they are the basis because they will be conducting their investigations themselves. So it's enough that we draw the attention through the evidence that we bring. We should not necessarily do the whole job alone as feminist organizations or women-led organizations. It's enough to draw the attention of what is happening. And then those who have the expertise and are the practitioners and are authorized to conduct the investigations will do them in the right way. It's enough that we bring in the submissions to the treaty bodies, to the UPR process, which is available as well, to special procedures. And I want to really here to thank the special rapporteur on the occupied Palestinian territory, Mrs. Francesca Albanese, for her courage to speak out despite the sanctions that are being imposed on her. We need to, accredit the special rapporteur because what she did is speaking for justice, and therefore we should accredit her and really, show at least a little bit of respect and what do you call it, appreciation for all what she is doing as a practitioner and as an independent expert. Thank you very much for everything.
Thank you, Randa. Let's move to Yuli. Any comments you'd like to make to or answer any of the questions?
Yeah, I'll try to just to bring two short points. One regarding the question about the situation or the propaganda or the situation within the Palestinian society and such. I just want to bring one element. It is personal, but I think it is important into that. You know, I'm an Israeli Jew. I was born and raised in Israel. I am running an organization of Israelis and Palestinians. Half of our staff is are Palestinians from the West Bank, the Gaza Strip, and Jerusalem, and from within 48. And half of us are Israeli Jews, and we are working together. And I'm a woman. I'm a lesbian. I live with my wife and kid in Jaffa, within a colonialist framework that I was born into, right? A Zionist colonialist framework. I think when we get to the situation where we are, and I'll say something short about South Africa and the comparison, But we got to the point of genocide. And once we recognize that the society we live in, and I'm talking about the people, right? The whole thing, the 15 million people who live between the river and the sea are now living under a regime that committed genocide. This regime was before, for many, many years, an apartheid regime. It has a colonialist roots. It was militaristic. I won't go into everything that I super agree with that Marita said before about the structural conditions that got us here. But we got us here. We are here. And at the moment, I think what we think a lot and we ask ourselves a lot, what do you do in the face of genocide? As a human rights defender, as a human rights lawyer, as an activist, as a feminist. My answer is, first and foremost, we go back to the values. The struggle, and now we are in a struggle to take down a system that is hyper-militaristic, but it is also became genocidal one, a complete genocidal one. The only way to move forward, in my view, is to hold very, very strong the values that direct us. In our case, in B'Tselem case, in my personal, we're talking about human rights, and not just as a legal concept, but human rights as a value, to bring back humanity into a space, or to insist on humanity in a space where there is a system, a governmental system, a regime that works tirelessly to erase it. Now, once the humanity is being erased, like we are seeing today in Gaza, like I mentioned before, within the detention centers, but that risks all of us. I am terrified to live in a society that lost all barriers and all that basically can do anything. Because that's, in my understanding, the point where a society and a system get to once it is able to conduct a genocide. And in that sense, all of us are in risk. And I'm not trying to make a comparison between my situation and Palestinians. Of course, there are victims to this genocide. It's very clear. But everyone who live under this regime are in risk. And in that sense, the way I see this struggle is not a struggle between Israelis and Palestinians, or between Israelis, Jews and Palestinians. It's a struggle between the people of this land and the system that oppressed them. And I also live under apartheid. As an Israeli Jew, as a privileged person, as a person that this system marked for some reason as someone who deserves more than others, but I also live under this oppressive regime that I know very clearly, and today it's very clear, that can, in a minute, come after me. It's not even, it can happen now, while we're sitting and talking. And that brings me into the other question about what is our role in that moment. And yeah, we're facing tons of challenges that I think Randa mentioned. Some of them are structural. The fact that we are an Israeli organization of Israelis and Palestinians who live within this oppressive, under this oppressive system, that become more and more fascist, that become more and more undemocratic. And again, I don't mean that it was democratic before, but the kind of democratic facade of it is also being taken off. And in that sense, I think the first thing we need to do is a mental shift. And that's not only us, it's everybody who work around this issue and want to, or understand that we have an obligation as human beings to stop this system. We are not in a democratic, in any sense, we are not in a democratic setting. Today, we see no internal mechanism that Israel hold that can stop this machine, this killing machine, and this destruction machine that, again, in its most extreme form is working in the Gaza Strip. But just the same, the West Bank is on fire. We haven't got into that at all. We know very clearly that Israel just need a trigger in order for the full-on genocide to spill over into the West Bank. And also inside Israel, Palestinians are not safe, and in my view, nobody is safe. So in that sense, we don't have an internal mechanism to do that. I don't think we can count on any internal legal or other mechanism to stop it. We are way too far into this process, which, that I mentioned before, South Africa, as much as I know, and I learned a lot of my political education I've done in South Africa, never got to this stage where the hardliners took control in that sense. I mean, it wasn't apartheid, it was a very rigid apartheid regime, but the apartheid regime never spilled over into what we see today in Israel. And in that sense, we're in a much harsher situation, politically and legally and in every other aspect. And regarding the international aspect of it, yeah, I think international law is super important, and the fact that perpetrators should be brought to justice is super important, but we're now sitting and talking while a genocide is still taking place. We don't see how it is stopped, and excuse me for not counting too much about what's taking place now in the US, in DC, in the last 2 days, in the sense of helping us, the people of Palestine, the people of this land, and to stop the Israeli regime, which is, in my understanding, is definitely the most dangerous force at the moment in the region, but for sure for us, the people who live here. And in that sense, international law is very important in order to demand justice for the future. But now I think we are in a more in the political game. And in that sense, somebody asked, what can we do? And again, I don't see the faces of the people who sit there, but I think all of us need to kind of push as hard as we can into the understanding, the political leadership understanding that we are facing an illegitimate regime that has to be dismantled in order to build here a just and democratic one instead of it. Thank you.
Thank you so much. Thank you. Is this working? Is that working? Thank you, Yuli, for your courage for speaking with us right now. We're going to come to Amrita for any final comments.
Yeah. Yes, it is working. Can you hear me? It feels very quiet.
Is this one working?
That one's better. Let's do that. Yeah, let's do that to one. So I'll speak briefly, given the time, but firstly to the straightforward legal question. The answer is no. I think there are ways in which that the case can integrate gender more comprehensively. I think we could have a long technical conversation around what that could look like, but it certainly it was not absent. It's certainly been featured, but it's not something which I think has been integrated fully into the way in which the case has been described. And then on what was said, I think, Priya, what you mentioned around what can we do as practitioners, and I think speaking to this UN system and the UN special procedures versus, for example, the Human Rights Council and the state, I think this split actually is incredibly important for us to absorb, which is, as international criminal practitioners, we are seeing the limits of the impact of that reflected in this divide between what the system, the justice system, can do and what the politically motivated system or the agendas set by those who have political agendas will do. And so here what I would say is that let's reflect on that for ourselves. So from a practitioner perspective, I think is to challenge the narrative from a legal basis and not to underestimate the value of joint statements on a sound legal basis. And here I'd mention, for example, we had the recent report on sexual violence, the annual sexual violence report from the UN office on that. And of course, we saw that there was a disparity in terms of how sexual violence was characterised. So WILF actually published a submission to say this is where the standards need to be consistent across UN bodies. Use the same evidence and the same threshold to make similar conclusions rather than downgrading the conclusions. And I think that's something that lawyers around the world can do, is where you see those inconsistencies to be able to identify them. Then again, I think looking at that split between the political and the legal is to challenge the narrative where it's coming from national actors and states. Because what we've seen here is that the reason the international community has been so slow is because of where the political interests and decision makers have chosen to make their decisions, and that has been pressured over time. So in fact, we're seeing that this institutional failure is something that we as lawyers, but also we as individuals need to be challenging. So when you have statements that say we need to assess the evidence on genocide, being able to challenge that with the weight of evidence and legal analysis in a domestic sphere is critical. And finally, I think as individuals is to amplify those Palestinian feminist voices. They have identified the needs, the challenges, what the international community of lawyers and politicians and the movements can do. And this requires us all to be uncomfortable in dialogue with others, to be able to support those types of voices in spaces that they would otherwise not be heard. I'll leave it there.
Thank you. Thank you. I'm fully aware that we're over time for the timekeepers, but thank you for allowing us to continue. We've heard today, it's not just a legal crime. This is erasure of humanity, not only in Palestine, Israel, but for all of us. That requires us all to act. We were asked what to say. If a state says to you, you need to wait for the International Court of Justice to make a determination of genocide, say no, we do not. There's a Commission of Inquiry report that is out. Even if you are not agreeing with that, you have a duty and an obligation to prevent genocide and to act. And that is what we must require from them and ask of them. Speak about Palestine, speak about Palestine, speak about what is happening. Remember also our Israeli colleagues who are bravely fighting. Ask for sanctions against individuals who are committing crimes. And also the EU has tools, and they should be using those tools. They're using those tools for other situations, for Ukraine and others. They should be used them for Palestine. We don't have the luxury to despair or to be miserable. We don't have that luxury. So let's talk about Palestine and let's act. Put your hands together for an incredible panel. Thank you for everything that you're doing. Oh, sorry. Yes, I'm supposed to do housekeeping. I forgot. I was in a moment. Yes, we have a coffee break, and I know there's a really long line for coffee. We can't change that line, sorry, but we do encourage you to come back. I believe within. Do we have 10 minutes? 15 minutes? 15 minutes? I think it's not possible to come back within 10. So let's come back at 10:45, and the next there is a wellbeing space for anybody who needs it. If you like to have a quiet moment, the welfare team members are present between 10 and 3 in the coffee lounge. And also the next session, some speakers will be in Arabic. So do take the headphones that are around somewhere. We'll find them. If you don't speak Arabic, I understand it. Thank you.
Thank you very much.
Okay, yeah. Yeah. All right. Supposedly. Maybe I'll say it in my.
Hello. Excuse me. So this panel will be in Arabic. So please just a kind reminder, like to take your headset.
تعميهم في شبه انه صورنا اخذوها من اللينكد ان، انا ما طلبوا مني اخذوها من اللينكد ان. هل صورتي يعني انا هاي انه كثير قديمه يعني.
لا كان في شعري مدري شلون هيك مكياجي مدري شلون في شيء مدري شلون بحسني يعني. طيب وانا هيك عم حاول اركز افكاري ضايعين.
Yes, it's working.
sorry. And very clearly, and if it's possible to have the mic.
Where are the headsets? Okay. Welcome back, everybody, after the coffee break. We're going to restart now. There are headphones. Everybody, shall we be together? There are headphones over in this corner. Okay. If you're like me, who does not speak and understand Arabic shamelessly, even though I spent a long time living in the Middle East. Sorry, Jumana. So do take your headphones. And then we're going to begin the session. Actually, we'll just give everybody a moment, Jumana, okay? Because they're just, otherwise it's not good to start when they're still. Yeah, if you. How are you? You're good? Yes? Okay. I was going to make a joke, but I won't. Okay, everybody, let's please take our seats because we're going to begin the next panel. Do you take your headphones? The next panel is we're continuing our Middle East in focus and strategizing to support. Everybody, are we together? Are we? Yes? All right, and we're going to begin looking at Syria and strategizing to support emerging justice opportunities. Jumana, welcome. You're the chair.
Thank you so much. هذه البانل ستكون باللغة العربية بالكامل. رح نشوف نستكشف خلال ساعة من الوقت اليوم المتغيرات في سوريا والفرص أمام العدالة والفرص أمام تصميم استراتيجيات للعدالة الجندرية. مثل ما بتعرفوا سريعاً، سوريا عاشت من 1970 تحت حكم ديكتاتوري، نظام ديكتاتوري. عام 2011 خرجت الناس للشوارع مطالبة بالحرية والكرامة، كان ضمن سياق الربيع العربي وثورات الدول العربية. تواجه هذا المطالب بالحرية والكرامة بعنف شديد على مدى أكثر من 13 سنة. الناس تعرضت للبراميل العشوائية المتفجرة، الاعتقال، القتل، التهجير القسري للملايين بسوريا، واللي ما زال في أيضا أعداد كبيرة ملايين بالمخيمات اللجوء. النساء والرجال تعرضوا للعنف الجنسي في المعتقلات السورية بشكل ممنهج، وكل تبعات هاي الجرائم الدولية اللي ارتكبت بسوريا. خلال هاي الفترة المجتمع المدني السوري بالدعم المجتمعات ومنظمات الدولية والمجتمع الدولي الأوروبي حققت إنجازات لمسارات بديلة رغم انغلاق محكمة الجنايات الدولية. حققوا إنجازات عبر الولاية القضائية العالمية. صار في اعتراف بالعنف الجنسي كجريمة ضد الإنسانية في كوبلنز بجهود الجميع طبعا، وتقديم أكثر من 100 دليل على هاي الممارسات. هناك مذكرات اعتقال غيابية بحق كبار المتورطين في فرنسا، وفي محاكمات في ألمانيا ومستمرة، وفي مذكرة اعتقال بحق الرئيس يعني اللي كان بشار الأسد أثناء وجوده كرئيس، ومذكرة اعتقال كمان بحق أخوه ماهر الأسد، كبار كمان الضباط المتورطين في استخدام الكيماوي. الآن في 8 ديسمبر 2024 سقط نظام الأسد. قدم إلى الحكم مجموعات مسلحة كانت تحكم في مناطق بأجزاء من سوريا، وأصبحت الآن في الحكم وشكلت حكومة. بعض هذه المجموعات كانت مصنفة على لوائح الإرهاب، بعضها عليه عقوبات دولية. اليوم في وضع مختلف جديد بسوريا، هناك انفتاح دولي حتى باتجاه السلطة في سوريا واتجاه الحكومة. هناك وعود حثيثة بالإصلاح، تم اتخاذ خطوات واضحة باتجاه العدالة، وكانت العدالة والعدالة الانتقالية مذكورة في العديد من الوثائق التي صدرت عن الحكومة وفي الحوار الوطني وفي العديد من الخطوات. لن أطيل أكثر، ولكن هذا النقاش لنستكشف معا الفرص ولكن أيضا التحديات. زميلتنا سنة كيخيا يلي هي المديرة التنفيذية لمركز التطوير القانوني، واللي المفروض تكون معنا كانت اليوم، بس هي أرسلت لنا فيديو قصير سنشاهده عن رأيها بهذه النقاط.
Hello everyone. It's a shame not to be with you. It's a lost opportunity, but I'm also grateful for the possibility to share my inputs with the other great panelists who I'm sure will cover the talking points of this session beautifully. My name is Sana Kifia, and I'm the Executive Director of the Syrian Legal Development Program. And by the time of you watching this video, I will be attending the 3rd Syrian Civil Society Conference on Chemical Weapons. And this is the first time we are holding the conference in Syria. I would like to use the few minutes I have to touch on the gender accountability, but also the accountability work in general. I believe as a human rights and international law organization, we have been focusing a lot, and it was one of our priorities in the last few months after the fall of the Assad regime, to make sure we stay relevant to the people we serve on the ground, relevant to the causes, and relevant to the realities. Therefore, one of the main priorities on the accountability that I would like to emphasize today is changing, strategizing, adapting by changing or rethinking our strategies, rethinking our tools, rethinking our tactics, and to do this in a collaborative way with other stakeholders, especially other Syrian civil society organizations. And here I want to thank the great Syrian women leaders from other Syrian civil society, because in the last few months we have experienced a lot of changes on the ground, but together we were able to coordinate beautifully on moving things forward. And I am specifically mentioning women in the leadership because I don't know why, but little by little we started grouping in a way that we always find each other, that we are women coordinating pretty much in a very effective way to move things forward. And I would love to capitalize on this as a superpower we have, especially when it comes to very political topics like accountability and gender accountability priorities. I will not go deeper on the gender accountability, but I wanted to touch on the tactics and the re-strategizing that I believe is a priority in this transitional period. We are all going through the transitional period, not only the government, and we need really to adapt to stay relevant to our people. Thank you so much.
بشكر على هاي الإضافة، ولو أن سريعا وبلتفت للعزيزة رزان هي المديرة التنفيذية، رزان رشيدي المديرة التنفيذية لمنظمة سوريا كامبين، حملة من أجل سوريا. رزان، في متغيرات كتير بسوريا على الساحة. حكت سنة عن استراتيجيات وعن أدوات وعن نساء قياديات. أنت متابعة للوضع تماما والجهود في سياق يعني أو حول العدالة. شو رأيك بالمبادرات اللي عم تطلع؟ وين هل شايفة في فعلا ملامح أو معالم حقيقية لعدالة جندرية في سوريا ضمن هاي المبادرات؟ تفضلي.
شكرا كتير جمانة، وشكرا للجميع على الاستماع. حقيقة أول شيء بس بدي بلش أحكي كمان عن الوضع الراهن، يعني بس لقلك شو هي المبادرات الوطنية اللي هلأ عم تقوم الحكومة الانتقالية بالمبادرة فيها. بس قبل ما بلش بدي أكد كمان عن وضع النساء بشكل عام بعد ديسمبر 8 2024، لأنه منذ سقوط نظام الأسد للأسف الوضع الحالي للنساء عم يستمر بالتدهور. نحن منعيش ببلد النساء تقتل وتخطف بها إلى يومنا هذا، وهذا الشيء عم يتم بشكل ممنهج، وللأسف أخذ منحى طائفي، إن كان من المجازر اللي شاهدناها بالمناطق الساحلية أو من الحصار المستمر والإخفاء المستمر للنساء بجنوب سوريا بمناطق السويداء، واللي هي ذات أغلبية درزية بشكل أساسي. وهذا بالتالي يعني له أثر كتير كبير على فسحة الأمل إذا فينا نقول اللي والحماس اللي عشنا فيها كنسويات سوريات واللي بنتمنى إنه الهيئات اللي عم يتم إنشائها واللي أكيد أنا كشخص اشتغل على موضوع العدالة النسوية وعلى موضوع حقوق الضحايا للسنين ال15 الماضية، بيهمني عدم التكرار بشكل أساسي. وحقيقة اللي بيخليكي تشعري بالأمل هو إنه الضحايا نفسهم، العائلات الناجين، أول مطلب لهم عم بيكون عدم التكرار. نحن كنا بسوريا مع العائلات والمختفين والناجين، وكل يعني ممكن كل بتقول باللهجة العامية ما بشتهيها لعدوي، يعني I don't even wish this to happen to my enemy, worst enemy. فبحس من هذا المنطلق لازم يعني أي خطوات لها علاقة بالعدالة الانتقالية بشكل أعم والعدالة الجندرية بشكل أساسي إنه ناخذ هذا الشيء بعين الاعتبار. بصراحة هيك لجاوبك إنه عدالة جندرية، إنه بقول حلم، بقول مصطلحات كبيرة هي مانا جزء اليوم من تفكيرنا، ولكن مثل ما قالت سنة وجود نسويات وفاعلات ومجتمع مدني كتير فاعل بالسياق السوري هو اللي بيعطي أمل، هو اللي بيعطي الفرصة الحقيقية. عودة للخطوات الرسمية لنقول اللي اتخذتها الحكومة الانتقالية بمسار العدالة الانتقالية والحقيقة والإنصاف، رح أذكر منهم إنشاء الهيئة الوطنية للعدالة الانتقالية والهيئة الوطنية للمفقودين، وبدأ عملها، صدر مرسوم مؤخرا رقم 149 بتسمية أعضاء وعضوات لجنة الهيئة الوطنية للعدالة الانتقالية. وحقيقة اللي بيعطي أمل وجود أشخاص ونسويات مثل جمانة بهي الهيئات، وبعتقد انه يعني عنا واجب نحن والفاعلين هون والبراكتيشنرز الموجودين هون انه ندعم الجهود او الريسك او الخطوره اللي عم ياخذوها سيدات مثل جمانة. بس الأهم يمكن أكد أنه المجتمع المدني السوري وروابط الضحايا مثل ما لعب دور كتير كبير خلال السنوات الماضية، وحقيقة يعني وصل يعني تقنيات خلاقة إذا منقول منها إنشاء المؤسسة المحايدة المستقلة المعنية بسوريا أو المؤسسة المعنية بالمختفين. وأنا بأكد أنه أنا أعتبر كسورية أنه هدول مؤسساتي، منا مؤسسة أجنبية، منا مؤسسة متحدة برسي، هي مؤسسات سورية وما كانت رح تنجح لولا عن جد ضغط وعمل مستمر من قبل الناجين بشكل أساسي. حتى ذكرتي محاكمات كوبلنز، قديش كان صعب أنه نكون موجودين هناك. أنا شخصيا مثلا كنت موجودة مع شريكي واللي هو عطى شهادته. شهادات الناجين والضحايا هي محورية فعليا بكل الآليات العدالة الانتقالية اللي صارت، وبالتالي المجتمع المدني بشكل سريع جدا. يعني أنا بتذكر بجانوري بشهر واحد، يعني بعد أقل من 3 أسابيع من سقوط النظام، اجتمعنا 51 منظمة سورية معنية بالعدالة لا نضع رؤيتنا ونقدمها لهالحكومة الانتقالية حول العدالة الانتقالية بشكل سريع. كمان فيكم تطلعوا على هذا الشيء على موقع حملة من أجل سوريا، أو حتى على موقع المركز السوري SLDP للتطوير القانوني اللي سنة كمان بتكون بتديره. بشهر آب مؤخرا أعلنا 61 منظمة سورية معنية بالعدالة الانتقالية مثل كود اوف كوندكت أو يعني التزمنا كلنا بميثاق فعليا. حقلكم بس النقاط الأساسية حول هذا الميثاق اللي كلنا عم نلتزم فيه اليوم. نتمنى من الحكومة الانتقالية من الهيئات الوطنية إنها كمان تلتزم فيه. المعيار الأول هو الالتزام بمسار عدالة شامل وغير تمييزي، لأنه اللي بيفاجئكم أنه أنا قلت أنه في هيئة وطنية للعدالة الانتقالية، ولكنها عنيت فقط بجرائم نظام الأسد بالمانديت تبعها، وهذا الشيء بالنسبة لإلي كحدا اشتغل على ضحايا ومختطفي داعش، كحدا بشكل شخصي مشكلتي مع المجموعات المسلحة اللي غير هي نظام الأسد كتير إشكالي وتمييزي، لأنه في ضحية بحق لها اليوم تبحث عن الحقيقة، وضحية بسبب أنه الجاني هو جهة أخرى لا تبحث عن الحقيقة. المحور الثاني هو مركزية دور الضحايا وحقهم في المشاركة، وبعتقد أنه عن جد مجموعات الضحايا والناجين بسوريا، ومنها مثلا عائلات من أجل الحرية، عائلات قيصر، مجموعات مثل مجموعة ناجين صيدنايا، وحقيقة ترأسها نساء معظم هذه المبادرات. إذا ما بتعرفوا من هم عائلات من أجل الحرية أو عائلات قيصر، عن جد يعني بتمنى أنكم تتابعوا مسيرة هاي النسويات الجميلات اللي على الرغم من 14 سنة من الإحباط وما حيروح نظام الأسد وهلكتونا بأنه عم إعادة تكرير نفس الخطاب والفيكتمايزيشن، ولكن بالرغم من كل شيء دقوا على جميع الأبواب وحاولوا بكل الطرق. واليوم بعد انفتاح المساحة لنكون عن جد بالأرض، أنا عن جد متفاجئة بليفل الوعي والإرادة اللي عند كل امرأة بسوريا عم بسمعها، إن كان بمقابلة صغيرة أو فيديو أو بشكل شخصي عم أتواصل معها. مطالب العدالة، بدي حقي، بدي أعرف وين أولادي، بدي أعرف شو صار معه، بدي أسمع شو صار معه بآخر لحظة من حياته. ممكن الإيمان بخلي الأم تؤمن أنه راح لمكان أفضل أو شيء، ولكن عندها رغبة حقيقية بالمعرفة على الرغم من الوضع الاقتصادي المتدهور جدا، وعلى الرغم من أنه بعض المسؤولين بيقولوا لنا أنه هلأ السوريين فقط بدهم رخاء اقتصادي، بدهم يطلعوا من الأزمة الاقتصادية، مو وقت نحكي هلأ بالمحاسبات. لا، حقيقة الشارع عم بيقول غير هيك. الشارع عم بيقول اليوم وقت نحكي من المحاسبات وما رح نقبل إلا يكون في محاسبة لجميع المرتكبين الانتهاكات. المحور الثالث هو تأكيد قيادة النساء في مسارات العدالة الانتقالية، ونحن أكيد سعيدين بوجود جمانة بالإضافة ل4 من الزميلات بهيئة العدالة الانتقالية، وجود هيئة وطنية للمفقودين. بس كمان برجع بأكد إنه هاي الحكومة منا كومفتبل معنا كنساء، هن حكومة بتجي من ايديولوجي أو من خلفية منا مرتاحة بوجودي بالغرفة، منا مرتاحة بوجودي يعني. فما إلك أن أكون أنا قيادية، يعني هي أنا شخصي كامرأة ما أنا مرتاحة فيني، فكيف أنه يكون قيادية؟ فبعتقد أنه هون التحدي كتير كبير، وأكيد هون الدعم للنساء اللي عم ياخدوا هاي الفرونت لاين، الحدود الأولى بالعلاقة مع هاي الحكومة، هو كتير أساسي. رفض الإفلات من العقاب، واللي كمان كتير عم ينحكى فيه، واللي يعني عن جد ما بعرف كيف فينا نحكي فيه بعد جلسة فلسطين والزميلات من فلسطين. يعني بعتقد أنه كتير مهم كمان نحكي بكيف فينا كمجتمع بيشتغل على موضوع العدالة الجندرية، أنه نركز على موضوع رفض الإفلات من العقاب والتقاطعي والعبر للحدود، وإن كان بالمنطقة ولا كمان بالعالم. القيادة والملكية السورية الشاملة لمسار العدالة، وبدي أكد أنه لما عم نحكي عن التزامنا بالملكية السورية لمسارات العدالة، هذا لا يتعارض، وبالعكس هو يعني بصب بالاستفادة من تجارب الشعوب الأخرى. يعني امبارح تعرفت على زميلات هون من غواتيمالا، من أرجنتينا، وإخاضة مسارات عدالة انتقالية. حكينا اليوم كتير كمان عن سياقات أخرى، ولكن أكيد في رغبة أنه نعمل على إعادة بناء هذه التجارب بما يتوافق مع السياق السوري. ومثل ما قلت أولا، بما يعني بنظرة أنه الاستفادة من المؤسسات الدولية، إذا هيك سميناها، لأنه هي هيك بتتسمى، بمفهوم أنه هذه مؤسساتنا، هذه إلنا. Syria is in your title. يعني I think that يعني هذا كتير مهم أنه نحن كمان كسوريين وكفاعلين نشوفه. المحور الوقت، تنسيق فعال ورؤية جماعية من أجل عدالة انتقالية شاملة وشفافة. الشفافية كتير مهمة. عنا مشكلة يعني بحب أذكر لها ويمكن بدنا نحكي فيها شوي بعدين. بسوريا اليوم في مشكلة معلومات ومشاركة معلومات كتير كبيرة. يعني حتى هاي الهيئات لهلأ لليوم ما عندها تواصل بشكل مباشر مع الأرض. بتحسي إنه معظم الأشياء اللي عم تصير بسوريا هي يعني خلينا نتك ذا بوكس مثل ما بيقولوا باللغة الإنجليزية، أو نقول إنه يلا عملناها 1 2 3. ولكن أكيد برجع بأكد أنه الأمل بالأشخاص اللي هن شركات وشركاء النضال، الالتزام بحق المعرفة الحقيقية، التزام بإعادة إعمار عادل لا يكرس الانتهاكات. إذا بس تكتبوا هلأ سوريا بالجوجل وتحطوا فيديوز أو images you'll be shocked، يعني حيكون كمية الدمار اللي هو موجود. تخيلوا انه كل نافذة من هدول النوافذ اللي نحن عم نشوفها هي بيت، هي عيلة، هي امرأة، هي حكاية قبل النوم حكتها لأولادها، هي عم تشتغل ورا اللابتوب لتعيل عيلتها، هي عم تطلع كل يوم بطريق مهدم. فعنا مشكلة إعادة إعمار كتير كبيرة بهي البلد، ولكن بنفس الوقت إعادة الإعمار لا يجب أن يكرس الانتهاكات. والعدالة المكانية حقيقة هو مصطلح اليوم أنا شخصياً عم بتعلم عنه، كيف الكوميونيتيز أو المجتمعات نفسها هي ممكن تكون جزء من إعادة الإعمار، وبشكل أساسي النساء. آخر نقطة، بعتقد أنه كثير من الجالسات والجالسين بالغرفة ريليت معها أنه العدالة الانتقالية هي مسار طويل وليست لحظة عابرة. بعتقد هذا اللي كمان لازم نعززه ونأكد عليه، إن كان مع الحكومة أو مع الجهات التي تدعي أو عندها رغبة بأنها تدعم هذا المسار، إنه الموضوع مو بس بروجكت تايم لاين وبيخلص وإمتى ببلش الانترفنشن وإمتى بتخلص. لا، نحن وعيانين إنه مسار العدالة الانتقالية بشكل عام هو مسار طويل. وحقيقة إنه النساء لما لا تقوده هو التكتيك أو التكتيك الأنجع بما يقال باللغة العربية. شكرا وآسفة على الإطالة، بنرجع بنحكي بعدين.
شكرا كثير رزان، بالعكس أنا اللي آسفة على الضغط، أنا حاسة إني عم بضغطك وأنت كل شيء عم بينحكى حقيقة كثير مهم وكثير دقيق. سما سما زميلتي كمان، سما نصار، محققة بدار عدالة، باحثة في كلية لندن للاقتصاد والعلوم السياسية. سما أكيد في كتير من التحديات اللي ذكرتها رزان، بس كمان ما بعرف أنت شو عندك كمان تحديات أخرى أو شو تقييمك للوضع الحالي. تفضلي.
طيب، صباح الخير، يعطيكم ألف عافية. أول شيء قبل ما جاوب جمانة على السؤال بدي أتشكر منظمين هذا المؤتمر على اختيار المكان بشكل أساسي. بحب أحكي عن المحاسبة بلاهاي لأن هي المكان المناسب للمجرمين أنهم ياخذوا جزاءهم، وبتمنى نلاقيهم قريبا بهذا المكان. وشكرا جزيلا لكل المدخلات باليوم الماضي واليوم، كثير كانت عظيمة وتعلمت كثير أشياء كانت يعني جديدة علي، فشكرا جزيلا. بالرجع على سؤال العزيزة جمانة، أنا للأمانة مشكلتي مع المبادرات اللي القائمة حاليا بسوريا هي بتتمحور بثلاث نقاط، خليني أقول أساسية. يعني أشارت رزان ل واحدة منهم هي المرتبطة بالمندات. أنا بدي أضيف على اللي ذكرته رزان، هو موضوع إنه مو بس إنه عم نفكر بضحية من طرف تاني، لا، في الضحايا هن نفسهم، نفس السيدة أو نفس الشخص هو ضحية لعدة سلطات أمر واقع. يعني خلال 14 سنة كانت في بعض المناطق بسوريا توالت عليها سلطات. يعني بالبداية كانت النظام السوري، لاحقا الجيش أو الفصائل المعارضة، جبهة النصرة، داعش، ورجعنا النظام. هذا البقعة الجغرافية الوحدة بين النساء بهيدا المكان كانت عم تكون ضحية لكل هيدي السلطات. فوقت اللي بدنا نحكي على جرائم النظام، نظام بشار الأسد فقط، وحصر العدالة الانتقالية بمحاسبتها، فنحن عم نضيع فرص كثيرة، وهذا حيكون دافع لكثير من الضحايا والناجين انهم ينخرطوا بمسار عدالة من هذا النوع. الشيء الثاني هو موضوع الملكية. المرسوم الرئاسي اللي نتج عنه إعلان الهيئة الوطنية للعدالة الانتقالية، برأيي بتصور كتير منظمات حقوقية حكت عن الموضوع، بيفتقد لأنه إنه يشعرنا بالاستقلالية هيدي الهيئة. يفترض الهيئة الوطنية تكون نتاج أو قرار مجلس الشعب، البرلمان، أو يعني لحتى يحس الشعب إنه هذا ملكه. فموضوع إنه يكون مرسوم رئاسي، أنا بعتقد إنه في إشكالية فيه. نحن بحاجة أكيد للسلطة باعتبارها هي الجهة اللي قادرة إنه تصدر قوانين، قادرة إنه تنفذ يعني تكون يعني عم شو بيسموها، يعني تنفذ العدالة، تنفذ العدالة، تسن قوانين. إيه نحن بحاجة هيدي السلطة بهذا المحل، ولكن نحن بحاجة المجتمع المدني، عموم المجتمعات المحلية والحقوقيين والناشطين وأصحاب الشأن، أصحاب المصلحة، إنه يكونوا منخرطين بهيدي الهيئة لحتى ما تكون مسيسة وتكون ما عندنا ثقة كاملة فيها. فنحن بحاجة لشراكة أكثر من بهلا. بالشكل الحالي في إحساس بأنه هي الحكومة، هي للحكومة مو للمجتمع. فنحن بحاجة لهيدي الشراكة بين المجتمع والدولة لحتى نوثق. خاصة يعني ذكرت كمان رزان الماضي المرتبط بهيدي الحكومة والأشياء اللي صارت لاحقا. فنحن يعني هي بحاجة لكتير تشتغل لحتى تكسب ثقة الناس. ما شيء مجاني ومجرد اني قرروا يعملوا هيئة فمعناتها الناس حتوثق فيها. الشيء الثالث، هلا هو في كتير قصص يعني، بس راح بسبب الوقت ما حاحكي كتير. موضوع المشاركة الواسعة للنساء، أو يعني صح هو في نسبة حاليا، نسبة جيدة تعتبر 5 سيدات من أصل 13، ولكن نحن يعني مقتنعين، أو أنا على الأقل مقتنعة أنه وجودكم هو لأنكم أنتم بتشتغلوا بشكل كتير كبير. أنتم عليكم الشغل أصلا الأكبر مو إيمانا بأهمية دوركم، لأنهم بتشتغلوا بشكل خارق. يعني أنت وزهرة وبقية السيدات بالمجموعة، فالله يعطيكم العافية. ولكن إيه، أما بقية الأشخاص فكمان يعني المشكلة إنه الوعي الجندري، يعني حتى نحن بظن حتى هيدي الكلمة، موضوع الوعي الجندري أو العدالة الجندرية، أعتقد إنه حيكون منفكر يعني 10 مرات قبل ما نقولها قدامهم، ما عم نقول نحن قدام عموم الناس. فهي مشكلة حقيقية إنه انه يكون في تحفظات على هذا المفهوم، فما بالك بالعمل للوصول له. ففي شغل كتير بيتعلق بموضوع انه هيدون الاشخاص انطلاقا منهم، يعني يكون عندهم هي الحساسيه الجندريه، يكون موضوع العداله الجندريه اصلا هو يكون شأن وطني، يشوفوا القيمه المضافه لانه تتحقق العداله للنساء انطلاقا من قيمه الامراه بالمجتمع، فيكون موضوع وطني لحتى نوصل لاحقا لخطوات عمليه تانية. فلنوصل لهون برأيي كتير 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 في شغل لحتى تتبنى الهيئة منهج تقاطعي بيراعي مو بس الجنس، بيراعي الدين، بيراعي الطائفة، بيراعي الظروف الاقتصادية. ف لهيك بحاجة لأنه يكونوا النساء مشاركات بشكل أوسع كمان ما تكون مشاركة النساء مجرد اني نحن كمان مثل ما قالت راح استخدم نفس المصطلح انه نتك بوكس، يعني هيدي امرأة من محافظة معينة أو امرأة من خلفية معينة. لا، نحن بدنا مشاركة واسعة. وقت اللي بنقول واسعة يعني حتى تقدر عن جد تغطي كل التجارب النساء وكل الشيء اللي قطعت فيه النساء بال 14 سنة الماضية وحتى السنين اللي قبل. عموما هي اكثر اشياء بتحفظ يعني على بخصوصها، وان شاء الله يكون في فرصه انه يكون في تدريب للاشخاص ولا الاشخاص اللي رح يكونوا باللجان الثانيه عن الموضوع. هلا في شغل كثير له علاقه بتدريب المحامين والفرق اللي ممكن تكون بهيدي اللجان لحتى كمان يكون عندهم هاد الوعي. وهي لهيك بدنا النساء والمنظمات النسوية والقيادات النسائية تكون عم تشارك بالتخطيط الاستراتيجي لهيدي اللجان وهيدي المبادرات، ومو مجرد انه يعني تجينا من فوق ومن دون او حتى لما بيكون في هي الاجتماعات والاشراك للنساء مو لا بس انه جبناهم وسمعنا منهم، لا بدهم يكون في مشاركة حقيقية بالتخطيط لحتى نضمن انها تكون عم تراعي كل هيدي التجارب. في فرصة عظيمة، أو يعني أنا بشوف إنه هيدي الحكومة للأمانة هي محظوظة بالمجتمع المدني السوري اللي منفتح ومستعد يقدم كل الدعم التقني، دعم الخبرات، بكل شيء بتقدروا. نحن بس بحاجة إنه تكون هي منفتحة أكثر على إنه تتلقى هيدي الخبرة اللي نحن عم نروح على أوكرانيا ونروح على جنوب كوريا الجنوبية لحتى نحكي عن تجاربنا ونشارك خبراتنا باللي عملناه بالإنجازات. كمان بتفق كتير مع رزان، أنا بتمنى على السوريين نبطل نقول إنه وقت المبادرات تكون سورية سورية وما بدنا UN وما بدنا أنا ما بشوف إنه IIMP والتريبل IM هي UN أو هي نتاج مناصرة قام فيها المجتمع المدني وروابط العائلات والضحايا لحتى تتحقق. فهي قصة نجاح سورية وقت اللي بتكون شريكة بالعمل للوصول للعدالة. فهي نحن يعني مسؤوليتنا انه نحافظ على الطريقة اللي عم تتعاطى فيها هيدي الوكالات، انه تكون بتمثلنا، بتعكس المجتمع السوري حقيقة الواقع. ولكن من أكبر الخسارات برأيي إنه نتخلى عنها، أو إنه نحن نقول من باب إنه سوري سوري إنه نحن نرفض هيدي هذا التعاون. ف يعني أنا يعني عن جد أنت يعطيكي ألف عافية على هذا الشيء اللي عم تساويه، بس بتمنى فعلا انه تكون هيدي تكوني ناقله كمان لهيدي الرسائل، لانه الحكومه تكون منفتحه على هيدي الافكار، هيدي المقترحات، وبدورنا كمجتمع مدني كمان نكون نحن قدرانين نقدم هيدا الدعم اللي بتحتاجه بيحتاجه الواقع بسوريا حاليا يعني بالنهايه.
شكرا. شكرا جزيلا سما. يعني أنا كمان بدوري بقول لك إنه إيه اضغطوا ضلوا عم تضغطوا إنه بالنهاية هذا دور المجتمع المدني. ويمكن على المداخلتين من العزيزات إنه كمان بشوف إنه وضح بعض النقاط سريعا جدا إذا منك ماريانا. أول شيء بالنسبة لاختصاص هيئة العدالة الانتقالية، نحن يعني عم نشتغل على ملاحظات أخيرة بالنسبة للنظام الداخلي للهيئة. الاختصاص أو المنديت تبع الهيئة هو ليس فقط الجرائم التي ارتكبت من قبل النظام السوري، وإنما يعني التفسير لما ورد في المرسوم هو الجرائم التي تسبب بها النظام السوري. وبذلك تم التفسير أن كل الجرائم الدولية التي حصلت في سوريا في وقت النزاع بعد 2011 هي كانت بسبب النظام السوري، وعليه أنه الآلية أو الهيئة هي ضمن اختصاصها كل الجرائم التي ارتكبت ومن جميع الأطراف من 2011 إلى ديسمبر 2024. هي نقطة أولى. بالنسبة للاستقلالية فعلا أنا بشوف أنه في حتى عدم وضوح، ويمكن هذا سببه كمان المشكلة في التواصل يعني الكوميونيكيشنز لساتها كتير ضعيفة. وما عم نلاقي يعني لسه ما طورنا هاي الآليات بالتواصل عموما وبالإعلام وبشكل عام. أما هي واضح في مرسوم أو المرسومين لتشكيل الهيئة ولتسمية الرئيس الهيئة اللي كان كلف بتشكيلها وتسمية الأسماء، أنه الهيئة الوطنية للعدالة الانتقالية هي هيئة مستقلة لها شخصية اعتبارية، وهي مستقلة تماما ماديا وإداريا. فالمفروض أنه هذا الاستقلال يترجم بالضرورة على يعني كمان in practice يعني على أرض الواقع. والمفروض أنا أعتقد من وجهة نظري أنه المجتمع المدني أن يعي تماما هاي الجزئية وأن يعمل فيها وأن يدعمها ويعززها. أحيانا عم تكون في لبس أنه حتى المجتمع المدني عم يعتبر الهيئة هي هيئة حكومية أو مؤسسة حكومية يعني تابعة للحكومة، والمفروض أنه الهيئة مستقلة تماما، وهي يعني إما بموازاة أو أعلى من الحكومات، لأنه المفروض يجب أن يعني الوزارات أن تستجيب وبإيجابية، وأن لا ترفض طلبات حول كل المعلومات والوثائق ويعني كل ما يتعلق بمسار العدالة الانتقالية. النقطة الأخيرة أنه عن الوعي الجندري، أنا أعتقد يعني هلأ من بداية السنة عمليا أنا في سوريا قابلت محامين ومحاميات ويعني مختلف وناس وبالشارع وسائق التاكسي وكلهم. الحقيقة الوعي الجندري أو كل ما يتعلق بحقوق الإنسان والقانون الدولي وكل هذه المفاهيم وكل هذه القوانين والتي أصبحت يعني مفروغ منها، أو يعني ببلدان مثل أوروبا اللي عشنا فيها واللي كان لنا الفرصة نشتغل فيها، هي ما موجودة أساسا. يعني مانا في السياق حتى مع المحامين. يعني صار في حديث مثلا عن الاستعراض الدوري الشامل، عن آليات الأمم المتحدة، عن الهيئات اللي تشكلت. حتى المحامين من يمارسون والمفروض من يتابعون كتير معلوماتهم قليلة عن هذا الواضح. فأنا بس يعني عم بحكي عن بضيق إنه من هون واجبنا كمان كمجتمع مدني وكنساء إنه صار إلنا فرصة نطلع ونحتك ونبني هاي الخبرات، إنه واجبنا بنقلة. أكيد هن عندهم كتير من الخبرات يلي كمان كونوها بهاي الفترة، بس اللي نحن ما كنا بالواقع، يعني الخبرات الواقعية مبني على التجربة الواقعية. هذا التبادل بيناتنا هو كتير مهم. ومن هون أنا كانت فكرة إنه تأسيس المركز بسوريا، وأتمنى إنه يكون في عشرات المراكز، وسعيدة إنه كل منظمات المجتمع المدني أو الأغلبية انتقلت لتعمل تأسيس مراكز هنيك في سوريا. وأكيد مشوارنا طويل كتير ورحلتنا طويلة. ماريانا العزيزة، أنت مؤسسة شريكة لحقوقيات وبتشتغلي من أوروبا وعلى جهود العدالة القائمة حاليا والمستوى يعني الموجودة في أوروبا. كيف أنتم كمؤسسة منظمة نسوية وكمحققات نسويات كيف جهودكم أثرت على هذا العمل وهي جهود العدالة in general، وشو قدرتوا تحققوا إلى الآن، وشو تصوركم للعمل في أوروبا، استمراره للقضايا اللي تنظر والتحقيقات والمحاكمات المقبلة في أوروبا. تفضلي.
شكرا كتير جمانة، وشكرا كمان على التوضيحات اللي عملتيها كتير مهمة. كمان بالنسبة لنا بالعمل تبعنا حقوقيات نشأت من 4 سنين ونص تقريبا، وبدأت بالعمل بالتركيز على قضايا كانت مرتبطة بجرائم حصلت في مناطق الحصار، وبلشنا بجنوب دمشق بشكل أساسي. حاولنا نطلع على جرائم مرتبطة بالحواجز اللي كانت بتمسك المناطق المحاصرة بالتحديد بمنطقة جنوب دمشق، وطلعنا بوقتها على ملف اسمه وحاليا بينحكى عنه كمان كتير بالإعلام علي الوحش، اللي هي حادثة وقعت في 5/1/2014 تضمنت جرائم عدة عندما كان عم يحاولوا المدنيين والمدنيات الخروج من المناطق المحاصرة، وتم اعتقال جزء كبير منهم، قتل جزء كبير منهم على الحاجز، إخفاء قسرة لجزء كبير منهم وما إلى هنالك. الآلية اللي كنا عم نحاول نشتغل عليها هي تحقيقات بمنظور جندري، والسبب تماما اللي طرحتيه جمانة بأول حديثك اللي هو إنه المنظور الجندري حتى بالدول الأوروبية اللي كنا عم نحاول نسلم من خلال الملفات ما كان مطروح من أجندات الادعاء العام أو وحدات جرائم الحرب بشكل أساسي في بداية فتح هذا النوع من الملفات. بكوبلنز على سبيل المثال، بجهودك وبجهود زميلات BCCHR تم إدخال الجرائم ضد الإنسانية، عنف جنسي وعنف قائم على النوع الاجتماعي، ولكن ما كان هو أساس من القضية اللي انفتحت من قبل الادعاء العام بأوروبا بألمانيا بهديك الحالة. وتم كمان تحييد بعض الشهادات اللي كانت مرتبطة بالعنف الجنسي والعنف القائم على النوع الاجتماعي لأسباب عدة عطتها المحكمة بوقتها. فكان بيهمنا بعلي الوحش بالذات أول شيء نحاول نفهم مين الضحايا، مين الأشخاص اللي كانوا عم يحاولوا يطلعوا، أشخاص كانوا محاصرين، مين الأشخاص اللي قدرنا نصلهم ونتواصل معهم. بأغلب الضحايا تقريبا من 30 ل 31 شاهد أو شاهدة تواصلنا معهم، بأغلبهم كانوا نساء، لأنه اللي صار على الحاجز بوقتها هو تقسيم بين النساء والأطفال والرجال. كثير من الرجال تم اعتقالهم واخفائهم قسرا، كثير منهم ما بينوا لحد اللحظه، كثير من النساء تم اعادتهم جبرا للمناطق المحاصره، وهذا ادى لانه كثير من الشهود كانوا فعليا من النساء. كنا كمان قدرانين نشوف شو تأثير هذا النوع من الجرائم على النساء، غير الضرب أو الاعتداء الجنسي أو الاعتداء القائم على النوع الاجتماعي في الحوادث نفسها. الرجوع إلى المناطق المحاصرة اليوم من دون معيل، اليوم الامرأة هي المعيلة الوحيدة للعائلة بشكل كامل. اليوم الامرأة بحالة بحث مستمر على زوجها أو ابنها اللي تم فقدهم أو اعتقالهم بهذا المكان. هذا البعد الجندري اللي قدرنا نحاول نفهمه من هذا الملف خلانا كمان نحاول نفتح ملفات تانية مرتبطة بجرائم كمان حصلت على حواجز مثل بيت سحم على سبيل المثال، كمان جريمة حصلت ب 18/12 2013 وقتها كانوا السكان المدنيين عم يحاولوا يخرجوا، كان في باترنز جدا مشابهة لمجزرة علي الوحش. كمان اطلعنا بملف آخر على دور المجموعات المسلحة الأخرى اللي كانت موجودة بالمناطق المحاصرة، ولهيك موضوع الحصار هو موضوع فعليا بيتضمن جرائم كثيرة، إن كان من القصف على المدنيين والمدنيات، الجرائم على الحواجز خلال فترات الحصار الجزئي أو خلال محاولة المدنيين والمدنيات الخروج، أو جرائم من قبل المجموعات المسلحة واللي مسيطرة على هي المناطق واللي جزء من اليوم حاكم بسوريا بطبيعة الحال. وهذا كمان كان بيساعد لنقدر نفهم شوي شو طبيعة الجرائم اللي كانت عم ترتكب من قبلهم. بعدين بلشنا بملف مرتبط باستخدام التجويع كسلاح حرب في منطقة اليرموك بشكل أساسي، وحاولنا كمان عن طريق المنظور الجندري نفهم ليش كان كتير من النساء يروحوا على الحواجز بدل من الرجال بفترة الحصار الجزئي، الخوف من الاعتقال والإخفاء القسري، شو كانوا يتعرضوا النساء على الحواجز اللي كانوا يروحوا عليها، نقص الطعام والغذاء على النساء الحوامل شو أثر عليهم بما يتعلق بالأطفال اللي هن عم يرعوهم. هذا الملف صار له مفتوح تقريبا 1.5 سنة، واليوم نحن عم نشوف نفس الوضع عم بيصير بغزة وما في أي توقيف لهذا النوع من الجرائم، وزميلاتنا حكوا بالبانل الماضية عن الوضع بفلسطين. استراتيجيا هدفنا بأنه نضوي على جرائم ما بيتم الإضاءة عليها عادة بسبب عدم وجود أي مبادرة دولية بمحاكمة هي الجرائم. أول ملف بنحكى فيه عن هي الجرائم بالعالم كان ضد نتنياهو بما يتعلق بالجرائم المرتكبة بغزة، وإيقاف هي الجرائم، لأنه هي الجرائم كمان اللي شفناه أنه في لها أثر وبعد نفسي وجسدي على ضحاياها من النساء ومن الرجال، بيستمر معهم لسنوات. اليوم عم نحكي مع أشخاص على جريمة صارت من 10 سنين بالنسبة لهم لليوم هذا البعد مستمر. ففيني هدول يمكن الأمور اللي فيني غطيها بعد.
شكرا جزيلا مريان. بدي أرجع لك رزان. اليوم أنت بعد ما جميعا يعني حكينا التحديات، بنفس الوقت يلي بتواجه هاي الفرصة الكبيرة بسوريا، في احتياجات، في دعم، في مطلوب اليوم وبشكل مركز لسوريا، لأنه هاي الفرصة مو مستمرة يعني ومانا مفتوحة. هي مثل يا يعني فرصة محددة، يا من التقطع ومنبدأ ونقلع نمشي لقدام، يا أما للأسف بتكون ضاعت. بهالظروف وهي التحديات اللي لها علاقة كمان بالهجوم أو الحملة ضد المنظور الجندري بشكل عام، و يعني ومتطلبات العدالة في سوريا أو دفعه، وين بتشوفي إنه نحن ممكن نتحرك؟ شو بتشوفي التحديات؟ شو المطلوب من حتى من زميلاتنا، من مؤسسات النسوية الدولية بشكل عام؟
شكرا جمانة. عم نسميها شهر العسل، ده هانيمون. فيا بتزبط العلاقة يا بتخرب، يعني هيك كانوا يقولوا أمهاتنا، يعني ما بعرف. حقيقة الفرص كتير كبيرة يعني، بس يعني أنا من ناحية عملي بالذات اللي هو مانو مسارات عدالة جندرية وعدالة انتقالية تقليدية، وإنما ندعي إنها خلاقة، رح ركز على النون تراديشنال اكترز، يعني الفاعلين غير التقليديين وأهمية الانخراط معهم. يعني نحن اليوم بنعيش بزمن مختلف كتير عن التسعينات، إذا فينا نقول. كل امرأة فينا عندها موبايل، سوشيال ميديا، فيفورت بودكاست. كل امرأة، كل فاعل أو فاعلة عنده مغني مفضل، عنده فيلم بيحضره. فحقيقة نحن بالسيريا كامبين، وأنا بشكل شخصي يعني عندي شغف كتير كبير بكيف فينا نعمل علاقات تقاطعية مع الفنون، الفن، مع الميديا والسوشيال ميديا، الانفلونسرز. يعني على الرغم من يعني شو بيقولوا غضبي الهائل من بعض المؤثرين الديجيتال اونلاين اليوم بالسياق السوري، اللي للاسف عم يقوموا بنشر المعلومات المضلله، او حتى عم يقوموا بانتهاكات مباشره. ولكن العلاقة كتير مهمة مع هدول الفاعلين، هن اللي عم يوصلوا لجيل الشباب. حقيقة هن عم يوصلوا لمرت عمي اللي قاعدة كل حياتها بدمشق وعم تبعت لي مس انفورميشن كل الوقت، ان كان على كورونا ولا عن نظام الاسد، ولا هلا اليوم عن هيدا النظام او شو عم بيصير. لازم نخترق هي البوتقة، يعني البابل اللي نحن عايشين فيها. وبدي أكد أنه بالسياق السوري عن جد أنا فخورة جدا بالنساء المبدعات، اللي الفنانات بشكل أساسي، اللي اليوم عم يستخدموا الفن كوسيلة كمان للبحث عن العدالة، كجزء أساسي من البحث عن العدالة. أنا بكتب عن هذا الموضوع بشكل كثير يعني، بس هيك حابة أحكي لكم آخر حملة عملناها مع فنانة سورية، هي اكشلي ناجية من الاعتقال. عملت معرض أوريغامي، طيور الأوريغامي، عبارة عن ورقة تصنعي بها الأوريغامي، وعرضته بالمتحف الوطني في دمشق. وكان دورنا بحملة من أجل سوريا أنه جبنا بكل بساطة عائلات من الضحايا من مناطق نائية، ولا ممكن حتى الوصول إلى دمشق مكلف ماديا لهم، وحضروا المعرض وانفتحت مساحة هائلة للحوار. فبعدين كملنا بيوم الاختفاء العالمي وطلبنا منها الفنانة إنها تصنع تدرب بفيديو كيف نصنع طائر أوريغامي، وعن جد تكلفته ورقة لأنه عن التكاليف المادية كتير أساسية. وبيوم الاختفاء العالمي صرنا نشوف على الشبابيك علقوا النساء هذا الطائر. وحقيقة عم تحكي لي وحدة إنه كيف شافت بالطرف الآخر طائر عن جارتها وهي سنين لم تعرف إنه ابن جارتها كمان مختفي. كيف فينا نعمل هالعلاقة مع الفنون؟ فيكم تفوتوا على صفحة حملة من أجل سوريا The Syria Campaign on Instagram وتشوفوا كتير من الفيديو جميل. كيف فينا نخلق يعني عن جد أنا بعرف أنه Mothers of Plaza del Mayo بأرجنتينا كله عنده نموذج. أنا عايشة ببرلين بشوف كمان الماربل ستونز على الأرض. كيف فينا يعني الميموري والحقيقة يمكن هذا جزء كتير أساسي واللي بدي أكده أنه عن جد في كم هائل، ويمكن ما في حدا من الحضور ما حضر معرض أو حضر فيلم. بذكر فيلم إلى سما اللي عملته امرأة سورية عاشت الحصار وهدته لابنتها. يعني النسوية العدالة الجندرية بدون ما تكون تحت فريم ووركس وآليات أنا اليوم بشوفها غير فعالة. وبشوف أنه عن جد للأسف مع انه انا شخصيا بحاول ما اتعاطى مع السوشيال ميديا والجهاز هذه الاجهزه لاحمي نفسي، بس عن جد بشوف انه مدخلنا من خلال هذه الاجهزه ان كان للمجتمعات حتى او لصناع القرار. لانه انت هلا جاوبتيني قلتي لي انه قراءتنا كمجتمع كامل لا الهيئة الوطنية للعدالة الانتقالية واللي كلنا قرينا أنه هي للجرائم الأسد، نظام الأسد، عم تصححي لي أنه ممكن يتصحح. الضغط pressure عم يشتغل مع هذا النظام. يعني هذا اللي شايفينه اليوم، وبعتقد بسبب علاقتهم القوية كمان مع السوشيال ميديا. يعني يمكن يعني لغير السوريين من كل شيء اونلاين. الحكومة عطتنا معلومات على التليجرام قبل ما يكون في عنا يعني قناة رسمية أو إعادة تفعيل وكالة الأخبار. فيمكن هذا المنحى يعني اللي أنا شخصيا ومؤسستي بحب أكد عليه، واللي بدعي الجميع الموجودين. سألتيني شو الموجودين، وكمان هون بأكد على دور الدول الداعمة. يعني بعتقد من لهلأ ما we didn't cry enough، ما بكينا enough على موضوع lack of funding اللي عم نتعرض له كلنا كفاعلين. بس كيف فينا كمان يمكن نفكر بهذا الايكو سيستم بهي الطريقة. يعني انه مو بس انا بدي اعمل funding ل مؤسسة حقوق انسان تشتغل على العدالة الانتقالية، كيف actually funding فيلم او انه انا ادعم فيلم او ادعم معرض او ادعم مبادره دروس رقص ممكن تساهم بالبيس بيلدينج للبلدان المختلفه. ورح وقف هون، بس اكيد زميلاتي عندهم اكثر.
ثانك يو روزان. اكيد سيما عندك اضافه بخصوص التمويل، ورح ارجع لك كمان مريم.
أكيد شكرا على الفرصة للحديث. هلأ بس بدي عندي تعليق بس قبل ما أحكي عن موضوع التمويل بنص دقيقة. وقت يعني أنا شكرا جمانة على التوضيح بخصوص المندات وهيك. بس هل الضحايا اللي عم نحكي عنهم نحن باستطاعتهم يحضروا مؤتمر بلاهاي يسمعوا جمانة سيف عم تحكي عن توضيح وتفسير المرسوم التشريعي لحتى يقدروا يحددوا انه هذا المرسوم ما بيقصيهم. فيعني شكرا على التوضيح، ولكن هو ما كافي. هو في حاجة. لا يعني أنا بالنسبة لي مو أنا اللي عم ببحث عن هذا الموضوع. نحن عم همنا النساء اللي عم يدوروا على العدالة وعموم الضحايا والناجين. فبرأيي هيدي نقطة يفترض أنه يتم إصلاحها بأسرع ما يمكن. أنا بقدر أفتح تليفون حاكيكي أو حاكي زهرة أو حتى السيد عبد الباسط أو أي حدا من ولكن بقية الناس ما عندهم هذا الوصول. بخصوص التمويل، للأسف يعني كتير بينحكى على أنه اللحظة التاريخية وسقوط الأسد، وهو حقيقة هيك وأكثر من هيك. ولكن يعني اشتغلنا 14 سنة نحلم باللحظة اللي فينا ننزل على سوريا نقدم خبراتنا والشيء اللي اشتغلنا من شانه، ونساهم فعلا حقيقة بأنه يعني بالحد من الدمار اللي صاير، او نساهم بشكل او باخر بنهضه هيدي البلد اللي عن جد يعني بكتنا دم مثل ما بيقولوا خلال ال 14 سنه الماضيه. أسوأ لحظات يعني واجهنا هيدي المشاكل بالتمويل. يعني للأمانة ما عم بقدر أعرف، يعني أنا بلشت حتى يعني أفكر بنظرية المؤامرة إنه شو بدهم بهي اللحظة. هل هن مصرين على الإمعان بهيدا الدمار؟ ف إيه في كتير مشكلة، ونحن في كتير بحاجة ل تحالفات، استكشاف فرص جديدة، لنضغط نشوف وين ممكن نضغط لحتى نحفز الفاعلين الدوليين انهم يستمروا بدعمهم للمنظمات المجتمع المدني السوري، للمنظمات النسائيه والنسويه بشكل خاص، لحتى نسد هيدي الفجوات الموجوده.
شكرا سما. يعني شكرا كمان إجابة على شو ممكن الاستراتيجيات اللي تنوضع يعني للتعامل مع هذا الشرينكينج، مع هذا الشح في التمويل اللي حاصل. كمان توضيحا بالنسبة الإعلام والتعاطي بالإعلام من قبل الهيئة العدالة الانتقالية. لا بس مهم جدا. أنا مع سمة 100% إنه كل هاي المعلومات يجب أن تكون متاحة، والشفافية هي الأساس، وهذا اللي متفقين عليه. يعني التوضيح بس إنه نحن من يوم يعني التشكيل، من يوم قبلنا مهامنا، يعني من يوم صدور المرسوم إلى اليوم، نحن اليوم شهر كامل يعني واحد. فهذا ما زلنا في فترة، واجتمعنا 3 اجتماعات وحضرنا ورشة عمل وهيك، ما زلنا في فترة التحضير أو وضع الاستراتيجية أو الخطة. الجيد أنه الزميلة رند صباغ، وهي المديرة التنفيذية لشبكة صحفيات السوريات، هي مكلفة بوضع الخطة الإعلامية، وهذا كمان شيء جيد. وأكيد يجب التوضيح عن حول كل هالنقاط. ما نسعى إليه هو الشفافية التامة، أو أعلى درجات الشفافية والتوضيح والتواصل. مريانا، رح روح إليك. بعرف إنه الوقت كتير صار قصير، فملاحظاتك إذا في كمان استراتيجيات كيفية التعامل مع هذا الوضع اللي ضاغط، بالذات بمرحلة هي مثل ما قلنا مرحلة احتياجات فائقة لسوريا للتقدم إلى الأمام بالعدالة. تفضل.
شكرا جمانة. يمكن أنا فيني سريعا انتقل لسقوط النظام ودخولنا إلى سوريا ومحاولاتنا بالعمل داخل سوريا، ومنها بقدر يمكن أحكي شوي عن التحديات. فعليا بعد سقوط النظام كان عندنا فرصة تاريخية بأنه نحن الجرائم اللي عم نطلع عليها نقدر أصلا نفوت على سوريا، نشوف وين وقعت، نشوف إذا بنقدر نتواصل مع أشخاص وقعت عليهم هي الجرائم وما كان عندهم القدرة أو المساحة تحت نظام الأسد أنهم يكونوا عم بيقدموا شهاداتهم. الواقع اللي شفناه مختلف. الواقع اللي شفناه أنه كتير من النساء اللي اليوم موجودات بسوريا أو بالدول المجاورة واللي عم يحاولوا يرجعوا على سوريا غير قادرات بالمبدأ أنهم يكونوا هلأ عم بيشاركوا بهذا النوع من القضايا، لأنه هن بالنسبة لهم أنا أولويتي القوانين اللي مفروضة علي من قبل نظام الأسد، إن كان بحرية الحركة، إن كان بإعطاء جنسيتي لطفلي، من النساء المتزوجات من أجانب أو أشخاص غير سوريين، إن كان يتم تغيير هي القوانين وتعديلها بحيث بحيث إنه أقدر أرجع على بيتي، قوانين المرتبطة بالميراث، أقدر أرجع أكون مرتاحة، وبعدين أقدر شارك بهذا النوع من القضايا. وهون بتجي موضوع العدالة الجندرية وارتباطها بسوريا اليوم. لحتى نقدر نفكر بمشاركة النساء والفتيات، نحن بحاجة لنأمن القدرة، أول شيء القوانين، تعديلات قانونية بتشمل هذا النوع من الجرائم أصلا، تاني وبتركز بشكل أساسي على الجرائم الجندرية، بس تاني شيء المساحة ليقدروا النساء يشاركوا بهذا النوع من العمل. ثالث شيء التدريبات، وأنا بضم صوتي لصوتك أنت وسيما. نحن عملنا فوق 6 أو 7 تدريبات من وقت سقوط النظام لهلأ بمناطق مختلفة بسوريا، والشيء اللي بنشوفه بشكل مستمر حماس مو طبيعي عند كثير من المحاميات والمحامين والقضاة وطلاب القانون بجامعات مختلفة لتعلم هذا النوع من الآليات، وهي بالآخر آليات نحن تعلمناها لأنه كنا برا سوريا. أنا درست قانون بسوريا وما كنت بعرفها. ولكن كمان سؤال بشكل مستمر، أنا شو بدي أعمل بهالمعلومة اللي عم باخذها هلأ؟ شو بدي ساوي؟ شو بده يصير بالمستقبل؟ في عدم وضوح لكثير من الأشخاص شو بده يصير بالمستقبل. كنا عم نحاول نتواصل كمان مع الخوذ البيضاء، وتواصلنا معهم بما يتعلق بأحد المقابر الجماعية اللي كانت من ضمن تحقيقنا. كان سؤالهم بشكل مستمر، حددنا أكثر من مقبرة جماعية في سوريا. لليوم نحن عم نستنى هيئة المفقودين تعمل بروتوكول، عنا التدريبات، عنا الوسائل لنقدر نكون عم نتعامل معها. شو البروتوكول اللي بنقدر ننزل نتعامل عليه؟ كثير من النساء مثل ما قلنا لليوم هن بس بحالة مثل ما حكت رزان انتظار لأي معلومة أو معرفة عن شو عم بيصير. آخر شيء بالنسبة لي بموضوع التعاون أو كيف ممكن يصير الموضوع أفضل، هيئة المفقودين طلعت تعميم رقم 1347 بكيفية آلية التعاون مع منظمات المجتمع المدني. تعميم بحد ذاته مهم، ولكن هو بيشمل الكثير من الأمور الإدارية، مذكرات التفاهم، كيفية التعامل مع المؤسسات، كيف منظمات المجتمع المدني بتقدر تشتغل بمجال العدالة الانتقالية، منها الجنائية ومنها معرفة الحقيقة ومنها للأسف التعميم بيطرح جيت كيبينج أكثر منه تعاون. اليوم لما نحن نعرف أنه في شاب تم اعتقاله من قبل السلطات السورية، هو يعمل في أنشأ منظمة مجتمع مدني، كان معتقل من قبل نظام الأسد بسبب عدم وجود مساحة للتعاون بينه وبين الحكومة الحالية، أو بينه وبين الهيئة اللي هي المفروض تكون مستقلة عن الحكومة. ما فيه تكون الوسيلة الاعتقال. ما فينا إذا ما قدرنا نلاقي مساحة للتعاون نشتغل بشكل تعسفي ونعتقل الناس ونعرضهم لنفس التراما اللي تعرضوا لها مسبقا مرة تانية بسوريا. هي مصيبة، هي بتخلينا نحن كمجتمع مدني، إذا الهدف مثل ما قالت سيما بناء الثقة، بناء الثقة بيجي من الأشخاص اللي ماسكين الحكومة اللي هن بحد ذاتهم ارتكبوا جرائم مسبقا. بس من سنة نحن بنعرف إنه هن كانوا عم يرتكبوا جرائم، وبالتالي هذا النوع من التعامل ما ممكن يخلق ثقة. الشفافية مهمة، أمور مكتوبة بشكل واضح مهمة لنعرف. أنا حكيت مع جمانة مسبق، نحن ما بنعرف كيف ممكن نقدم الملفات اللي عنا، وبعرف إنه هذا بياخد وقت وبده جهد بس هذا كمان مهم، لأنه الضحايا تبع هي الجرائم لما عم يتم إلقاء القبض على أحد من الجنات عم يتواصلوا معنا ويقولوا لنا أنا بدي ملفي يكون عم ينفتح بسوريا، أنا بدي هذا الجاني يتم محاكمته، ما بدي يتم قتله، أنا بدي إياه يتحاكم، أنا بدي أعرف إنه في شيء عم يتحرك بهذا الاتجاه. وآخر شيء موضوع العفو، واللي هو موضوع جدا مهم وكمان عم نركز عليه بحقوقيات. ما فيها الحكومة تقرر تعطي عفو لمين ما بدها بدون أي إجراءات واضحة وإعادتهم للمناطق اللي ارتكبوا فيها الجرائم. فهذا كمان نقطة مهمة نحكي عنها. أنا آسفة على الإطالة، شكرا.
لا. شكرا كثير مريانا، أنا بوافقك على كل النقاط اللي طرحتيها، وبعرف إنه التحديات كثير كبيرة، بعرف إنه الأخطاء اللي عم ترتكب ما قليلة ما بتبني ثقة، خلينا نقول. عسى نأمل إنه يعني تتصلح كلها ونعمل جهد. بس يعني من كل الحديث، من كل الإشارات لهي النقاط بستخلص أو نستخلص إنه دور المجتمع المدني كتير مهم، دور هاي الرقابة والدعم كتير مهم، الخبرات اللي تراكمت على كل السنوات الماضية كتير مهم إنه تنوضع في مكانها وتكون هي محرك ومراقب للشغل. عنا أقل من 5 دقائق، حابة افتح إذا المجال إذا في سؤال أو في تعليق على ما ذكروه الزميلات، فيا تفضلوا.
Thank you so much. My name is Cecilia Pelosnemi. I work for the Office of the EUSR for Human Rights, and I've worked with many of you before. My question concerns, firstly, how the online space is impacting the work of feminist activists and also legal professionals in Syria, women legal professionals. And secondly, we as an office, we might have the chance to interact with the transitional authorities on the topic of transitional justice. What are the key messages of kind of concrete things that we should convey to them in this area that will help you as women working in the legal space, but also to advance transitional justice from a gender perspective? And how should we, within international organizations or governments, sort of direct our funding? What are the key areas where that funding is needed? Thank you.
Thank you so much. Please, could you give the microphone?
Hi, thanks so much for this, and I really liked, Jumana, how you made this very interactive and the debate amongst you, which I think is going to animate all of us who are, going to be by your side in this, because I think there's a lot of uncertainties and a lot of doubts and a lot of work to do. So I really appreciated the openness and, straightforwardness with which everyone shared, some of their concerns and hopes and all of that. And I think we're with you on that. To build on Cecilia's question, I also, working from the UN team of experts perspective, would like to hear a bit more about, key messages that you think that we can help. I think you are very clear in terms of the role of civil society, and I can't agree more about, making sure that everyone is kept in check. And I think we know the role that civil society plays in terms of keeping everybody in check constantly, which is quite good. But in terms of how we all work together in the ecosystem to make the best possible outcome happen, then what is the role that you see as civil society for international organizations? So Cecilia asked about the EU, I'm asking about the UN, particularly because I think, one of the things I want to point out is a question you kind of touched on or alluded to in terms of, Syrian-led versus how to work with international partners, etc. And the instrumentalization or the possible instrumentalization of it being Syrian-led, what Syrians, and who are we talking about? And so how do we ensure that it is indeed Syrian-led, but meaning representative of the whole population, and that the focus on the Syrian-led doesn't mean that those who actually are trying to support the participation and the gender and the women into that space actually results in closing the ability that we have to help you opening that space.
Thank you so much. I think we have to just to answer quickly in this question, very little. Thank you, Antonia.
Maybe we have the other,
I'm torn because we have another panel starting soon.
Yeah, maybe we'll have another later, might discuss different, in the MENA session. So just quickly, I will رزان بعطيكي انت كمان تجاوبي، بس انا اللي بدي اقول سريعا انه الهيئة الوطنية للعدالة الانتقالية هي ايضا منفتحة جدا على التعاون. هذا ما ناقشناه، منفتحة على الدور، نعرف أننا نحن بحاجة لخبرات، لا دعم تقني ولا دعم مادي، هي واقع نعرف هذا جيدا وناقشناه. الذي نريده هو فقط التنسيق، ونحن بصدد أنه وضع احتياجاتنا بالتنسيق في كل لجنة على حدة، ومن ثم نناقشها كهيئة كاملة الآن أنا وزميلتي رند صباغ عنا هاي المهمة خلال أسبوعين مبدئيا، وكل هاي يعني ما استفدناه والنقاشات وهيك كمان سنضعه. سيكون هناك لجنة وخبيرات جندريات. آمل إنه الكل يكون يعني يعني مساعد وداعم السوريين أولا، وأيضا كل الزميلات العزيزات يلي اشتغلنا معهم كل هاي الفترات الماضية، والخبيرات والمؤسسات الدولية. أيضا أنا متفائلة من هذا الجانب، متفائلة أني يعني على الأقل ردود الأفعال أنه اللي سمعتها من امبارح لليوم وقبل أنه نحن داعمين، وأنا أعتقد أنه هاي فرصة كبيرة كمان إلنا حتى نطور. تفضلي رزان. هذا ما قالت لي سيما وضح انه هذا جواب الحكومه. هي البوينت، انه يا جماعه نحن مو حكومه. انا مو حكومه، ما بحياتي ولن اكون، ما بتصور انه اكون حكومه. هي هيئه مستقله تماما، هي اقرب للمجتمع المدني بالشراكه والتعاون وكل المنفتحين. لن نكون حكومه بمعنى انه سنتلقى يعني عملنا والتعليمات من الحكومة. فأرجوكم يعني ادعموا وكونوا واضحين ومحددين بهذا المجال.
خلاص, we'll keeping you know, held accountable for this. Very quickly, I know we're running out of time to answer your question. For the UN and the European Union, I want to state that I worked for the UN in Damascus for almost all my career since, you know, young, since I got fed up and went to NGO. Just don't let this regime or any other regime dictate how you work. Just don't do what Assad taught you how to do with this new government, yani, in terms of processes. And I think that would be yani, the golden solution. Key areas, cover whatever makes this authority uncomfortable. I think in general, it's very obvious with their ideology, with everything we're telling you. If there's lack of resources, otherwise cover everything that woman, you know, a woman is presenting or telling you about. And the online spaces, like, I really hate to end up with a bad note, but online spaces are very, very toxic today. I urge you to read the Syria campaign report, The Silencing Effect of Misinformation, Disinformation, where we speak a lot about it, but you know, maybe we can touch base on this issue in the MENA session at 1 or 2 p.m. Because there's a lot of strategies, there's a lot of information that I wish I have had shared, but because of the lack of time, we can't. And thank you again, Jumana. I just want to end by saying, I know you're our moderator, but I'm your big fan that, you know, we'll be there for you and we'll keep you feeling uncomfortable. It's like today, but we'll definitely also support you as feminists and we, you know, as you know, everyone said, we welcome any collaboration. You all know who we are, hopefully from the app, and we'll continue the conversation.
Yeah. Okay, thank you so much. What an incredible panel. And you know what? Who would have thought we'd be having this discussion last year when we met together? I think we all stand behind our Syrian colleagues and organizations, and also Jumana in her new position as well. Congratulations. All right, everybody. It's not lunchtime. It's not. So bear with us. We have 2 sessions now. Okay, the one here is on the International Court of Justice and gender. So remain here. We're looking at ICJ. We're looking at different cases. And then in room 314 upstairs, it's repairing gender-based violence. And we're going to move straight into the next sessions. Thank you. Oh, that's good. Is that mine? Yes. Oh, that's good. I like that gender. Okay, I have to catch you at lunchtime, yes? Yeah. Are you saying this one? No, sexual violence.
I thought I might sit on the side so that you guys can pass the microphone easier.
Maybe we should just leave for another time.
Okay, everybody, can I encourage you to stay or leave, if I may put it that way? Very good. Have some, is it possible to get some water? Yeah. Morning, Kim.
And Natalie is.
Natalie's online.
She's online. Okay. And do we have her?
Yes, you have me. I'm not sure if you can hear me.
Thank you for your kindness. Yeah, I get it. Since morning, I didn't hear the session here. I was working on my.
What's that? So we go, Natalie, Romina, you, then we hear from
Yes.
Rahana and then Palika. Good afternoon. If I could ask you all to please have a seat if you're staying for this session. Can we get Natalie on the screen? Is that possible?
I'm not sure if you can hear me in the room.
We can hear you, Natalie. Thanks so much.
Good afternoon.
So good afternoon to everyone, and welcome to this session, Gender at the International Court of Justice. My name is Erin Farrell Rosenberg. I am the Senior Legal and Policy Advisor of the Dr. Dennis Mukwege Foundation, and it is my distinct pleasure and honor to be moderating this important discussion. Noting that we are already running a bit short on time, as well as that we are followed by lunch, so I don't think there's going to be a lot of wanting to stay long. I am going to open with very brief remarks and then, mindful of the incredible expertise that we have, turn directly to our panelists. Over the past several years, we have seen a encouraging wave of proceedings being brought to the International Court of Justice under both its contentious case and advisory jurisdictions. With respect to contentious cases, we've already heard mention of cases being brought under the Genocide Convention, the Gambia v. Myanmar, South Africa v. Israel being two that have been discussed. But as well as the Convention for the Elimination of Racial Discrimination, the Convention Against Torture, and most recently, the Prudential CEDAW case under the Convention for the Elimination of Discrimination Against Women. Under its advisory jurisdiction over the past several years, the ICJ has also issued incredibly important opinions, notably in 2024 on the legality of the Israeli occupation of the Palestinian territories, and then most recently in this past July of this year on the obligations of states in respect to climate change. This increased activity at the International Court of Justice makes it all the more timely to discuss how gender-based harms and impacts are pleaded by counsel, are addressed by the court, but outside of the court proceedings itself, how they are understood by states in terms of the obligations that the court sets out in its provisional measures orders, its advisory opinions, and its judgments. And Finally, given the state-centric nature of the International Court of Justice, we have an overarching question on how survivors themselves, who, while the subject of these crimes and violations being arbitrated before the court, are objects within the procedural rules of the court. So there's a number of questions related to gender impacts, gender harms, but also how survivors themselves feel that justice is provided through these state-centric proceedings that we are going to discuss over the next hour. So to help us delve into all of these questions, we have an incredibly impressive panel of speakers. And so without further ado, I'm now going to turn to our first panelist, Natalie Reed. I want to be clear, I'm going to give super abridged bios because it would be the whole hour if I actually told you who these people are. So very briefly, Natalie is a partner at Dubois and Plimpton LLP in the firm's International Dispute Resolution team. Recently, Natalie was involved in proceedings before the ICJ, specifically on the climate change advisory opinion proceedings. Natalie is joining us online. And Natalie, the question for you is that the ICJ's climate advisory opinion, which is, of course, was requested by the UN General Assembly, is unprecedented in scope. Participation by member states demonstrated strong engagement, but advisory opinions by the court are formally non-binding and tend to include generalized obligations. How do you see the court navigating these constraints to recognize concrete impacts, such as the disproportionate burden on women, girls, and other genders? Thank you.
Thank you very much, Erin, for the introduction, and of course to the organizers for inviting me to join this panel and the incredibly important conference. I will try to be brief for all the reasons that Erin mentioned, and will tackle that question in the course of making my brief remarks. So, as Erin mentioned, the advisory opinion that the ICJ issued earlier this year is landmark in a number of respects. I'll spend 30 seconds just on reminding us all on what the court concluded in the advisory opinion, which was the unanimous finding that states have legally binding obligations under the UN Framework Convention on Climate Change, the Kyoto Protocol, and the Paris Agreement, as well as customary international law, UNCLOS, other environmental treaties, and human rights law. And the integration of all the different aspects of international law in that as well as is particularly important when we think about the way in which gender has been and hopefully will be further incorporated in the pleadings before the ICJ and the findings that the court reaches. And ultimately, this finding in the advisory opinion was with the goal of recognizing there are these legally binding obligations to ensure the protection of the climate system and other parts of the environment from anthropogenic greenhouse gas emissions. Now, the opinion is historic, not only for this pronouncement of concrete and rigorous climate-related mitigation and adaptation obligations, but also for its recognition of the gender dynamics at play. While gender may not have been top of mind in past years in considering the international legal response to climate change, science, of course, tells us that it is relevant. The Intergovernmental Panel on Climate Change, the IPCC, concluded that there are intersectional considerations in who suffers first and worst in the climate crisis, and concluded in a finding that again was given weight by the court, that women and indigenous peoples may be more severely affected by the impacts of climate change. The court, in its opinion, then recognized the imperative that states must undertake an intersectional response to the climate crisis. With respect to gender justice, the ICJ recalled the need to ensure gender equality and empowerment of women, and recognized that climate change may impair the enjoyment of the rights of women, children, and indigenous peoples, underscoring the Paris Agreement's mandate that parties should, when taking action to address climate change, respect, promote, and consider the rights of Indigenous peoples, local communities, migrants, children, persons with disabilities, and people in vulnerable situations, as well as gender equality. The ICJ further noted the important work of the CEDAW Committee. Specifically, the court stated that the Committee on the Elimination of Discrimination Against Women has stated that mitigation and adaptation measures with respect to climate change should be designed and implemented in accordance with the human rights principles of substantive equality and non-discrimination, participation and empowerment, accountability and access to justice, transparency, and the rule of law. In her separate opinion, Judge Hilary Charlesworth, very well known to many of us for her decades of groundbreaking work in this space, recognized that the adverse effects of climate change are not evenly distributed, and that women are among the most climate vulnerable groups. She listed many of the gender-based impacts caused by climate change, such as the materials vital to the traditional crafts that women engage in have become scarcer because of climate change, thus affecting women's economic security and social engagement, or increased demands on women to prepare for and respond to the increased incidence of extreme weather events. She also urged states to recognize that they have a particular obligation to protect the human rights of vulnerable groups, and that this requires close attention to the potentially discriminatory effects of measures taken to respond to climate change. So I mentioned before the importance of the as well as approach. So that broader interpretive approach that the ICJ took to identifying the sources of law that were critical for it reaching its conclusion about the existence and the scope of states' obligations with regard to climate change. Again, for those of us who play in this space, the academic term is systemic integration, and the result is striking. That consistent with the approach taken by the International Tribunal on the Law of the Sea, for example, when you have the advisory opinion by ITLOS, by the ICJ, and the growing body of case law in this space led by the international tribunals, what you're seeing is a coherent body of climate-related obligations that span the set of treaties, the climate treaties, UNCLOS, but also customary law and human rights law. And this approach, this attempt to create a harmonized, consistent international legal regime is significant beyond the climate context because it signals, in our view, an increased sophistication and nuance and flexibility in the way in which the International Court of Justice approaches potentially or seemingly disparate fields of international law to harmoniously interpret them together. There is a coherent regime with one or more objectives. And we think that it can provide a roadmap to a more intersectional and gender-sensitive approach to cases going forward. As Erin mentioned, when you're dealing with advisory opinions, the question can also and can always arise as to the practical impact of an advisory opinion, because they are authoritative statements of law, in this case with regard to binding obligations, but they are formally non-binding. I think what history shows us is, first of all, that states, to the extent that states remain the primary actors before the ICJ, states comply with them, although it can take concerted effort from the international community. And we have seen this from as far back as the Southwest Africa case, Namibia, and the impact that it had in the approach to South Africa and the international campaign and effort to encourage South Africa to move away from its apartheid domestic regime. And we have seen it more recently in the Chagos opinion, where you have this authoritative statement of international law, which carries incredible weight in state-to-state diplomatic relations, but also provides very important entry points for continued dialogue with civil society actors. The last point that I would make here, because I recognize there are very important discussions to come to follow. I think with this audience, I perhaps don't need to say, but it is worth emphasizing that the way in which arguments are crafted and presented at the court and the receptivity with which they are heard, it matters who is in the room. It matters who is at the table. And if we think about what has happened, certainly in recent years, but perhaps most significantly in the climate change advisory proceedings, Erin touched on this, where you had near universal participation from states, but also in the final days of this incredible 2-week period, significant participation by international organizations and civil society, including those who ceded their time so that, for example, the students who had really been the driving force behind the movement that brought the advisory opinion request for the court were given time before the court to stand and address the court. A couple of observations on this score. One, a little bit personal from having been in that room myself, and the second, I think, a little bit broader. The first is, and perhaps the one way to get into this is in 2021, the then president of the ICJ, John Donoghue, in a speech, lamented that each time that she, sitting on the bench in the Peace Palace, gazed out at the delegations representing parties, she was struck that their composition bears too much resemblance to the groups of persons who gathered in 1945 to draft the Charter of the United Nations and the Statute of the Court. Very few counsel are from developing countries, and almost all, regardless of nationality, are men. That was in 2021. In 2022, there was a study that looked at the previous decade of contentious cases before the court and found that not only did you only have 38 cases appearing, but only 38 of the 229 pleadings to the court had been made by women. What we saw in the climate change advisory proceedings were many individuals, again, sort of representing states or international organizations, who had never appeared before the court before. In those proceedings, 76 women appeared before the court. And of course, we have seen on the court itself increased and improved gender parity. Representation matters, and it contributes to improved legal outcomes. One of the most significant things, again, that I've seen by sitting in the room myself, in past decades, when you had this repeat performance of the kind of folks that Judge Donoghue mentioned, what you had in the arguments before the court and in the discussions of the court was a distance, an appreciation of the facts underlying these cases in the third person. It was about them and they and what was happening over there. What we saw in the proceedings before the court in the advisory opinion, the climate change advisory opinion, and what I hope we continue to see in years going forward, is with the increased appearance of individuals who had never argued before the court before, but were arguing for their state or for their community. You had it in the first person. It was I, it was we, it was our. Let me speak to you from my own personal experience, yes, at this incredibly sophisticated, difficult question of law, but recognizing the human beings who are not just, to pick up on Erin's introduction, the objects, but the subjects of the international law being developed before the court. So I'll pause there.
Thank you very much, Natalie. I think you've given us an incredible amount to chew over and digest. I'm going to now turn to our next panel member, Momina Yari. Momina is the Deputy Director of the Afghanistan Organization for Development of Human Rights. She has a very storied and illustrious career. Just to mention a few highlights, that she served on the Loya Jirga Commission, as well as for 7 years a commissioner on the Afghanistan Independent Election Commission. Momina, Afghanistan is a party to the CEDAW Convention as well as the Convention Against Torture, both of which contain compromissory clauses which allow disputes to be referred to the ICJ. In practice, however, given the Taliban's, for example, the Taliban's non-recognition as Afghanistan's government, as well as procedural requirements of the ICJ, there are still obstacles to this avenue for the CEDAW case. One of those being, for example, where the case is currently procedurally, that states parties must negotiate before filing a case. So we know that this case, as we're referring to it, but proposed case, under the Convention for the Elimination of Discrimination Against Women isn't quite yet underway. But we want to take the opportunity to ask you, in the assumption that it moves to court proceedings, what do you hope will be the result of these proceedings with respect to addressing the systemic oppression of women and girls in Afghanistan?
Good afternoon, dear fellow justice defenders. Thank you for giving me again the opportunity to go through the awful story and situation of women and girls in Afghanistan. Definitely, it is something that the situation is awful, that requires to go over and over. And unless we have to get justice for the women and girls in Afghanistan. In August 2021, when the Taliban seized power in Afghanistan, the world witnessed the immediate and devastating rollback of women's, girls' rights. What followed was not just regression, but deliberate erasure. Should I go through my notes? It's okay. Huh? Thank you. Because I have prepared since last night. Girls were banned. Again, as I said, the story is as awful as we have to go over and over. The girls were banned from school behind certain grades. Women were stripped of the right to work, to move freely without a male guardian, to participate in public life, and even access basic health care. These are not isolated abuses. They represent systematic and calculated policy of gender apartheid in the country. This is the horrific reality for women and girls in Afghanistan since the Taliban's take over. Their assaults are making life increasingly unbearable for women. Since August 15, 2021, over 100 decrees have stripped women and girls of fundamental rights, freedoms, and legal protection in Afghanistan. These decrees forbid women from leaving their homes without a mahram or a male guardian, from showing their faces or even for speaking in public. In the past years, the situation worsened when these decrees were codified into law, making the violation a legally punishable offense. The so-called law for the promotion of virtue and preservation of vice represents the most extreme form of gender-based oppression in modern society. Afghan women's rights activists have described these laws as a form of imprisonment, driving an epidemic of suicidal thoughts. The situation is so dire that it meets the criteria of gender apartheid under international law. These actions are widely seen as violating Afghanistan's obligation under the Convention of the Elimination of All Forms of Discrimination Against Women, CEDAW, which Afghanistan ratified in 2003. In September 2004, 4 countries, fortunately, Australia, Canada, Germany, and Netherlands jointly announced their intention to hold Afghanistan accountable under international law. They signaled their readiness to bring a case against Afghanistan to the International Court of Justice, ICJ, for violation of CEDAW. This is a powerful signal. that gender-based oppression can and should be challenged through the tools of international law. Following that announcement, a 6-month window was triggered under the CEDAW dispute resolution framework. During this time, the Taliban authorities were expected to either address the concerns raised or engage in meaningful negotiation. But instead, they categorically rejected all allegations, dismissing them as propaganda and refused to comply or engage in good faith. At the same time, Afghan women's rights organizations and civil society actors have stepped forward with extraordinary courage. They have pushed for transparency in the process, demanded the inclusion of Afghan women in all accountability mechanisms, and called on other states to join and support the initiatives. Now, while the commitment for the 4 governments is clear, the legal and political landscape remains complex. First, there is the question of jurisdiction and consent under the Article 29 of CEDAW. Disputes must first go through negotiation, then arbitration. Only if these steps fail can the matter be brought to the ICJ. But with the Taliban refusing to cooperate, it's unclear how jurisdictional hurdle will be navigated, particularly in a context where international recognition of the Taliban remains contested. Second, there is the matter of evidence and attribution. The applicant states will need to show that the Taliban's policies amount to systematic state-led violations of women's rights through formal laws, official decrees, and in the enforcement mechanisms used to implement them. Unfortunately, the situation is very, as I said, awful still. And Taliban is not coming forward to the negotiation process and rejecting all the proposals by the international community or any regional communities that. And even if a judgment is eventually secured, the ICJ has no direct enforcement powers, and ruling would rely on political and diplomatic pressure, potential sanctions, and weight of global public opinions. So where does the process stand today? This is a question. As of mid-2025, there is no formal record of a case filed at the ICJ. The initiatives remains in the preparatory phase still, unfortunately, focused on consultation, evidence gathering, and meeting the procedural requirements of the territory. The 6 months negotiation period has either already expired or is about to, and if no progress is made, the next step would be arbitration, followed potentially by formal referral to the court. Meanwhile, other avenues of accountability are already in motion. The International Criminal Court, ICC, has moved forward. In January 2025, the ICC prosecutor applied for arrest warrants against Hibatullah Akhundzada and Abdul Hakim Haqqani for crimes against humanity, specifically gender persecution. definitely we not rely on gender persecution. Gender apartheid should be ratified in Afghanistan case because all clear signs or goes toward gender apartheid rather than to gender persecution. It is clear. In July 2025, the ICC issued those arrest warrants holding Taliban leaders accountable for systematic violence against women, girls, LGBTQI plus individuals and their perceived allies. Alongside these, civil society and UN human rights bodies are calling for independent accountability mechanisms and for the international community to formally recognize the situation in Afghanistan as a form of gender apartheid, not just de facto discrimination. But of course, serious obstacles remain the same. Particularly, procedurally, the steps required by CEDA or SHO and heavily depends on state cooperation. Politically, the question of who can legally represent Afghanistan at the ICJ complicates the process. The Taliban, while exercising control over the territory of Afghanistan, are not officially recognize this procedure. Yet they act as the de facto regime, and particularly in practically building a case. Requires documents, survivor testimony, legal analysis, all of which is extremely difficult to obtain in an environment where civil society is under constant threat in Afghanistan. These are not minor challenges, they are fundamental, but they are not insurmountable. Because this is not just about Afghanistan. It is about whether we, as an international community, are willing to defend the idea that women's rights are human rights and that violation of those rights are not just regrettable, but illegal under the international law. If we allow this case to stall and fade into silence, we risk normalizing the idea that gender apartheid can be politically tolerated. This is really a fact. If we are not supporting the women in Afghanistan, then it's definitely, we have to accept apartheid in Afghanistan to be continued by the Taliban brutal regime. As of now, no formal ICJ case has been filed, but the momentum is real. The pressure is building. Civil society is mobilizing. Legal teams are preparing, and the world is watching. Let us remain committed, informed, and relentless, because justice for Afghan women and girls is not a symbolic gesture. It is a legal, moral, and human imperatives. Hopefully, we will really come to a solidarity to fight against gender apartheid in Afghanistan. And we need definitely the supports of all women, human rights organizations, international community to fight against this brutal regime, to free women and girls from their imprisonment, from their inhuman and brutal rules and procedures. Thank you for your attention.
Thank you, Momina. That was an incredible call to action, reminding all of us what is at stake. And when we look at the challenges and difficulties, to not forget what it means to acquiesce, and that we need to all fight together in solidarity with the women of Afghanistan. Thank you very much. So next, I am going to turn to Antonia Mulvaney, who does not need an introduction to anyone. So I'm just going to go ahead and say Antonia. The question for you is, Legal Action Worldwide has been involved in a number of ICJ cases. Do you see the role of survivors, or how do you see the role of survivors in interstate proceedings? How can we enhance their voices, ensure meaningful participation, and ultimately, I think the real question is, ensure that the justice served in The Hague at the ICJ meets the needs of those living in these contexts, particularly women and girls?
Thank you so much, Erin. And before I continue, I want to congratulate Natalie and the team for that landmark case and the decision that we heard about. So pleased to hear from you. I'm going to focus on the Gambia versus Myanmar breach of the Genocide Convention case, and then I'm going to make a few recommendations. And the reason I want to focus on that case is for a number of reasons. But if we go back and look at what was happening now, a plethora of cases before the International Court of Justice, but this really began in 2019 with the Gambia versus Myanmar case at the ICJ. And now we have multiple cases at the court in breach of the Genocide Convention, also of a Convention Against Torture and CERD. And you asked the question, what is happening? I mean, if we look at history of ICJ cases, generally negotiations will take, can take up a year or even 18 months. So the timeline that you're describing it's slow. So that is the steps that you have would be the next step. So I'm going to go back for a moment when I was a UN investigator and I was deployed under Human Rights Council mandate to investigate the crimes that were taking place in the Rohingya, against the Rohingya, actually within all of Myanmar. But suddenly I found myself being deployed on the border of Bangladesh and Myanmar as hundreds of thousands of Rohingya were fleeing Myanmar and crossing into Bangladesh. My file was sexual violence and crimes against children. And when I spoke to, it was more than maybe 150 women and girls and children, and I asked them, what do you want? They said justice. We want justice for what's happened to us and to our families and our community. And quite frankly, at that time, I really wondered how on earth was the community going to obtain justice. And so I'm going to talk about the ICJ and exactly also what does justice mean to them. So after that evidence and information that we collected was put into the UN fact-finding mission report on Myanmar. Report was utilised by the Gambia in the case against Myanmar on the Genocide Convention. And this is important because here we see the weight that the court places on UN reports. They're very important. And we heard also from Natalie about the usage of UN reports. It moved forward for the case to the provisional measures hearing in 2019, and I was with the victims of the delegation in the ICJ, and Aung San Suu Kyi at that time was representing Myanmar. And it was visibly noticeable, her reaction, when the then Minister of Justice said, there are victims of the genocide in the court today. Many of them had suffered from sexual violence. And her face moved. It moved because until then, there's been a denial. There still is a denial. So it's very important to have the survivors, the victims present in the room for them, for themselves, for the community, and for the state party that the case is against. Since that time, we've represented hundreds of Rohingya in their quest for international justice, and including submitting hundreds of pages of witness evidence, particularly from women, and particularly from those who suffered gendered crimes, including reproductive violence, and the long-term impact that it has, not just for now, but for decades to come, and the purpose of that. Next year, and early of next year, we will move to the full hearing of this case. There will be a victims delegation that will be present, and witnesses, we hope, will give evidence about what has happened to them. It's no easy feat, I can tell you, to bring Rohingya survivors from the camps in Bangladesh all the way to The Hague. Many of them who've never even left the camp before. They hadn't used even a bed before. They didn't know how to lock the door. I mean, this is, and we work with them for ages and ages to prepare them. What's it going to be like when you come? What the impact will be. But just something else I want to flag before I go to recommendations. I'm looking at the time. Yeah. So at that time, many people said, I want punitive justice. I want them held accountable for what has happened to me. But as time has continued, it's very difficult for people to live in the camps right now, not only for the Rohingya, but for many, many people. We see this across those that we represent thousands of people across the world. Their needs change. And so we undertook a survey of Rohingya to ask them, what does justice mean to you and what do you want? And we surveyed more than 500 individuals and brought out a report. And the overwhelming thing that they want now is, one, is citizenship. They want their land and their property back. And they want reparations also in the form of compensation. And we should not be shy to ask for this for them. And we need to become better at this as a community. So we've pushed for that in terms of a Human Rights Council resolution. And thank you very much to Bangladesh and Pakistan, who pushed for language to be included in the recent Human Rights Council resolution on Myanmar that was passed in June of this year. And it includes for the first time a mention of reparations for survivors and victims. And we urge this will continue also for a GA resolution, but also in other situations, thereby laying the pathway for reparations for them in multiple legal cases. And also that we have been pushing to establish a victims trust fund with multiple ways for financial support. Okay, I know I'm running out of time. 5 things I want to say. First of all, plan ahead. Right now, you're in the situation, the negotiations. We need to plan 5 years in advance. What do you want? Let's start planning that. And how will the state, how will they respond? Syria did not attend the court. Myanmar, taking this case extremely seriously. What do we think will be the response? Secondly, victims and survivors' participation. It's extremely, extremely important, but it has a financial cost. And we need also member states to support and assist. And thank you to the UK who helped with the Rohingya delegation to travel and also to have them, to give them a voice when they're in The Hague with panels and so on. Third, reports. Yes, it's very good. Civil society like us, we brought out reports. That's good. But better if the UN can bring out reports, because I said earlier, there's more weight placed on them. It's just a fact. It's how it is. So there's ways we can work around that. But that's this. Fourth, the role of third-party states. And we're going to come on to Palika next. Get the ear of a friendly state who is either intervening on these cases or maybe leading on them. There will always be a friendly state that's ready to listen to civil society and the victims. 5, judges, it matters. We've seen incredible judgments and dissenting opinions from Hilary Charlesworth. The next elections are in November 2026. The new judges that come in will be important. Think about that if you see there's proposals for judges coming out. And 6, yes, I did have, or was I lost my numbering. Anyway, last point is the role of civil society. Yes, civil society can have a very vital role through victims and survivors, that many of them can't travel. So also to go to states to say these issues are important. And on that note, I think we have one of the Rohingya can't travel here, it's not easily, who's going to speak to us from the camp, somebody that we're working with, because we have 60 Rohingya survivors, men, women, and Hijra, who work with us across the community. It's just 2 minutes. Do we have time?
Yes, yes, yes.
Okay, thank you.
বিভিন্ন ধরনের ঝোঁকা আছে বিভিন্ন ধরনের ঝোঁকা আর মানে জিনিসটাই মানুষের মানুষ কিনা করে হাসো কোনো করে এটা ইঞ্জিন হাস দ্বারা করে তো লো মানুষ মানে লো লয় মানে জিনিসটাই মানুষ লয় বিচার করে আসিছে নিউজে তারপরে আমার মাঝে আড়ালে কিন্তু হাইগা পর জিনিসটা নিয়ে বিচার তুলে তো বিচার তুলে দেয় ভালো হইলে আড়াল যখন বিচারি আনতে হয় তখন যখন বইনে মানে আড়াই যখন শেয়ার করলে মানে এটা লো মানে আড়াই গেলে যখন লো মানে গেলে শেয়ার করে মানে যদি আর লো না করা বলতে কি হয় লয়া হাজ ধরতে পারবো Lalu budi dahai kam are hasilnya hasilnya dia RCC RCC UC double lot ara hasilnya ara mani bisa kan baik kalau bisa kan baik kalau dia pun ara lo pura kalau nak deh kalau lah mani ini juga nak kalau baik kalau lagi pura kalau masuk bahasa pun juga baik kalau dia pun ara lah hasilnya lo malah hasilnya kiki aku baru ini mani kalau mau ara bermakna sih nak kesulitan sih Nos no forara por más pum era ella para era ara বিভিন্ন ধরনের যোগ করা era ara কিন্তু তো সেবা করতো তো মানে তো ara ইনকা করতো পুরো ওটা কিন্তু মানে ওটা কিন্তু তো এখন ara lo সময় সব মূল স্পেল তো বলতে পারে era así más ara মানে কি করে এখন তিন বার তো দুই বার মানে ara ইচ্ছতে মানে নাই তো ভাই কেম ভালো হয় যে আজ যদি তো মানুষ Loro bisogna dare il laser sul lunetta, che non si può fare la cavalla, non si deve che non to, ma non si può non to, ya loro bisogna solo ya hanno solo ya che su sono di quello su te, ma non si deve decidere di alla che loro ma c'è è stato più
We're not the only ones working on the situation, but but that's how that's how they perceive it. So that also says something. So I just had to add that.
No, thank you very much. And just to say that that was Rahana, who is a member of the Hijra community, who was speaking and addressing us. Our last panelist is Palika Pasin. Palika is a diplomat with the UK's Foreign Commonwealth and Development Office, the FCDO, and a member of the international law team at the British Embassy here in The Hague. Palika, the UK, as Antonia just alluded to, has intervened in several recent ICJ proceedings, including the Gambia v. Myanmar, under the Genocide Convention. From your perspective, what strategic value does the UK see in these types of interventions? And how does the United Kingdom weigh the importance of highlighting gender when it's choosing how to form its arguments?
Thank you, Erin. So yeah, as you mentioned, the court is busier than ever, and indeed the UK's engagement with the ICJ is also at an all-time high. Specifically on this case, it was back in August 2022 when the UK announced its intention to intervene in the Gambia-Myanmar case, and then it was in November 2023 that a joint declaration was submitted by the governments of Canada, Denmark, France, Germany, the Netherlands, and the UK. There was then some further written process, and then in July 2024, the ICJ bench ruled unanimously that our joint declaration was admissible. So when answering your question on the strategic value of interventions, I think it's important to consider the legal and the wider context. So on the legal context, and I can comment only just for the UK here, the UK does not intervene in all contentious cases where it has a right to. This is different from advisory opinions. We do tend to participate in all advisory opinions as a P5 member. But on contentious cases to which we're not party, we need to see a legal value. And there is clearly a political context to all court proceedings. But the submission must be legal in nature and advance a clear legal point. So, for example, something the UK hasn't said already on the interpretation of a treaty. So advancing a legal point is a key strategic consideration. And then in this case, our joint declaration focused on what we thought was the proper construction of Article 2 of the Genocide Convention, including the actus reus and the special intent that's needed to identify genocide. And very briefly, I'll just go through our joint declaration made roughly following 5 points. So firstly, that properly construed Article 2 of the Genocide Convention makes it clear that it's not only killings by which a genocide can be committed. Secondly, that it's well established that sexual and gender-based violence may fall within the underlying acts of genocide, And sexual violence is often the cornerstone of genocidal campaigns because of the impact on victims, their families, and the whole community. Thirdly, that Article 2B of the Genocide Convention identifies acts causing serious bodily or mental harm to members of the group as one of the underlying acts. And as a matter of construction, sexual and gender-based violence is capable of falling within this provision, including because sexual and gender-based violence unquestionably causes harm. Such harm may be either bodily and or mental, and such harm is almost universally serious in nature. Fourthly, Article 2D characterizes measures intended to prevent births within the group as an underlying act of genocide. And the court has specifically recognized that rape and other forms of sexual violence can be a measure intended to prevent births within the meaning of Article 2B. And fifthly, sexual and gender-based violence can play an important role in determining specific intent. So from the UK perspective, in some ways, we're not arguing for a broader interpretation, but what we see is a proper interpretation. And then, of course, the wider context plays a role too. So the context on the ground, and as Antonia mentioned, we had the UN fact-finding missions reporting on the Myanmar armed forces engaging in a campaign of sexual violence, as well as in addition, grave violations against children. And actually the submission also brought this out. And then also part of the context was the wider policy context for the UK. So Myanmar is a country of concern in the UK's Preventing Sexual Violence in Conflict Initiative, or PSVI, due to the high rates of conflict-related sexual violence. And then also in the context, the UK is a leading donor to the Rohingya response, with I think it's over £400 million to the efforts in Bangladesh and Rakhine State as well. So for us, maintaining momentum on strengthening justice for survivors of conflict-related sexual violence, and also strengthening the international legal architecture on sexual and gender-based violence was part of fulfilling commitments made in the PSVI strategy in November 2022. So I suppose from my perspective, this case had the sort of fruitful combination of the legal point, focusing on the proper construction of Article 2, then with an extended, a sort of existing gendered policy context to it. And then, of course, sadly, the conflict conditions that made the gendered interpretation of Article 2 particularly pertinent. So I think this is all came together, and this is what made gender an important framing. And ultimately, it strengthened the submission. And perhaps in other cases where we've seen interventions, there's not such an obvious confluence of factors. But also we mentioned the time taken on ICJ cases. You know, it takes time for this to get into the sort of lifeblood. It's not very rapid, so that takes time too. And I've left it to last, but absolutely not least. The key factor was the absolutely critical role of CSOs. So Antonia has mentioned, you know, the extensive lobbying by law to get Canada, Denmark, France, Germany, Netherlands, and the UK. I should say extensive lobbying and an extensive stamina. And CSOs also consistently called for gendered interactions with this case. And then you mentioned survivors as well. And also we hope to be able to play a small part in supporting that victim and survivor presence there. And perhaps, I think if I've got 1 minute, just a personal thought to conclude, because the conference is being held in the context of widespread gender rollback. And many states are thankfully still very vocal in their stance about opposing this rollback. And I suppose I see a sort of opening for CSOs to advocate a continued gendered approach to cases, because this could form part of that wider policy context. You know, the UK has PSVI, but this is that wider context, which a lot of states have said they want to protect. And we're not necessarily asking for anything expeditionary when it comes to the Gambia-Myanmar case. You know, that for the UK was a sort of existing interpretation. And states are conservative, so that helps as well. It's existing interpretation. And I think the ICJ is another important multilateral forum to think of when we think about preserving that international consensus around gender. So thank you.
Thank you very much, Pelika, and for reminding us indeed that we need to, particularly in difficult times, look creatively and really be aware of all of the avenues that we may need to access. And the ICJ, while perhaps not the first that comes to mind, is in fact one of those forums that states hopefully will continue to engage with. I'm looking at Antonia because I know we're running late. I don't know if we have time to do any questions or.
We have 5 minutes, if that's okay for everybody.
Perfect, thank you. So I see already some questions. Maybe if we can, I hate to cut this short, but I think if we can maybe take 2.
Maybe then 1, 2.
Sure.
I guess I'll be 1 and then the 2. Okay. Hi, my name's Liz Brennan. I'm an independent international law researcher. And I know we're short on time, so I do want to direct my question to Natalie, who won't be able to join us at lunch. But I'm curious for every panelist's insight as well. In my former role before becoming a researcher, I was an attorney at a large law firm in New York as well. So and in that role, I had the opportunity to contribute to public international law projects in a pro bono capacity. And so, Natalie, I'm curious how you see the role of large private law firms in public international law, gender justice initiatives in a context generally where, by virtue of their other representations, their non-pro bono representations, large law firms may be complicit in exacerbating gender justice issues in other areas, and also specifically in the context of President Trump's targeting of large law firms this year and threatening the independence of their representations because he personally and his administration dislikes some of the clients and issues that they've taken on. Do you see large law firms shifting away from gender justice representations, or perhaps it will depend on the particular firm and whether or not they have been subject to an executive order or agreement?
Thank you. The second question.
Hi, thanks so much. My name is Natasha. I'm a student just finishing up my master's here at the ISS, and I'm also working as associate legal researcher. Thank you so much for all of your contributions. A theme that I thought really stood out was obviously the importance of centering and working with survivors and including their voices within all types of proceedings. And I was just thinking about the fact that often something that came up was quite practical restraints, especially considering like the concentration of courts, bodies, and proceedings here in The Hague. Therefore, considering like travel limitations, maybe some of the restrictions that might happen in terms of like coming forward to report instances of sexual violence or gender-based violence, and also just the very real risks of like re-traumatization within these processes, what can institutions and also other civil society organizations do to work with survivors very meaningfully in a very trauma-informed way to ensure that their perspectives are represented at up to like the highest levels, including the ICJ, beyond just a select few of those who are able to actually travel to the court? Thank you.
Thank you so much. And I'm incredibly personally just pleased to have the last question be from a student. So I'm very glad that you're here. I know that all of our panelists would have a tremendous amount to say about this, but I am going to actually direct, if I can, the first question to Natalie, who it was addressed to, and ask Antonia if she would answer the second question. Natalie?
Sure. Well, thank you very much for the question. And I will try to be both brief and direct in answering. The first is law firms, and there are a few law firms, but still very few law firms that actively participate as counsel and advocates in ICJ proceedings and also before other international courts and tribunals. We play a very important role in connecting not just the civil society organizations that, as has been mentioned, are frequently at the forefront, not just of identifying and advocating and broadening knowledge of it, but in helping to shape the cases as well with the states who may be the friendly third states, and providing I think three things that law firms are very good at. One is resources. And the ability to actually commit the resources. And it's not just money as well, right? It is the concentration of experience, not just in the subject matter, but as advocates. It's really important to actually understand how to build a case and how to present it, and understanding your different audience. And that's what law firms and litigators do very well. The second is in building that case, in linking the way in which facts are developed to and for international fora. Antonio touched on this quite a lot. The ICJ places incredible weight on particular kinds of evidence and understanding what that is and how it could not just be maximized, but also developed over the course of this sort of long period that it takes to get a dispute from crystallization to pleadings before the court. The fact that you would have a law firm that does this, in fact, all the time, sort of identifying witnesses and understanding how you actually build and create the kind of evidence that will be given weight before different tribunals is very important. And the third, and this may be the segue to the tricky issues that are touched on by your question, is law firms, particularly in certain jurisdictions like the United States and the United Kingdom, and increasingly in others, have a commitment to pro bono and what it means in sort of recognizing the literally privileged position that we're in, and the importance of contributing those resources, our time, yes, the money, and our expertise to the communities from whom we draw, not just our colleagues, but our very livelihood. And if you're lucky enough to be in a firm that identifies community very broadly, so not just where you sit or reside, but globally as well, then if you have that confluence of three factors, you can actually see very concretely the impact that our firm and others have had in cases before the ICJ and other tribunals over the years. The tricky thing is law firms are for-profit enterprises and will always have to navigate in the ways in which states, which have a number of different interests, and other actors in international law have to navigate, sort of the particular points and interests that may seem to be in tension. That's nothing new. Law firms have been doing that for a very long time, even though the current circumstances may make it more difficult than it has been in the past. You will continue to have and to see the kind of commitment that we have seen in cases both domestically and internationally.
Yes, good question. Okay, 3 points. One, I recommend that you make contact with organizations that are working on the ground, because building up trust and confidence with the victims, with the survivors over years is really important. So there are organizations in nearly all of these situations. Make contact with them. Secondly, so if you're not in that country, what could you do? You can advocate. You can advocate before member states. You can advocate to join cases or to look at specific aspects. And thirdly, if you're based in The Hague and victims delegations are coming here, then see if you could host events for them or panels. We know people are always looking for help for that. So that's what I would say. Thank you.
Thank you. And I would ask if we could all show our appreciation for the incredible panel and discussion. It's unfortunate because we could go on for much longer, but I think we do need to end and go to lunch, I believe.
Exactly. Thank you so much, everybody. It's lunchtime. But I need some guidance from colleagues if we're going to go to 2 o'clock or we're going to, because it's now 1:15. Can somebody help me here? Or a vote of hands? 2 o'clock? We should start 2 o'clock, everybody? Okay. It's a democracy. So 2 o'clock, and I understand lunch is upstairs, but it's out on the tables today. So there shouldn't be such a long queue. Thank you.
Difficult. Hi, those who are online, sorry you didn't have lunch with us. I hope you had good meals as well. It's my pleasure actually to be moderating this session. Since it is happening after lunch, we decided that we will
try as much as possible to make it as participatory. If you have worked on the MENA region, or if you have, any comments, we'll make sure that this is, a conversation rather than panelists only introducing the topic. I'm, just going to say a few words. Gender justice in the MENA region is advancing every day through the work of lawyers, activists, survivors, networks, and community organizers like the ones who are sitting in this room. And violations of international crimes are diverse, but yet innovative ways of addressing those are also diverse. This workshop, and I stress the word workshop, we're workshopping this, so please feel free to be a participant, not only a listener, creates the space for those directly engaged in this work to share strategies, build connections, and explore how different approaches interact and strengthen each other. Without further ado, I would like to ask you, Bilge, to reflect on this topic and, share with us your experiences and learning specifically around joint collaborations across borders.
Thank you so much. Good afternoon, everyone. It is a great honor to be part of this conference, listening to such amazing people, amazing practitioners, listening their insights, their experiences, and also having the opportunity to contribute to this discussion. So we have been discussing about how to achieve gender justice since yesterday, but I will try to discuss what is gender justice in the first place and whether existing frameworks are conducive to achieving such justice. And I will specifically focus on the Women, Peace and Security agenda, which we also discussed yesterday. So today I would like to share some of the key findings from a book I am co-editing together with Vanessa Newby from Monash University, which is titled Imagining Gender, Peace and Security in the MENA Region. The book has two main parts. The first looks at how the WPS agenda has been implemented across countries in the MENA region. And the second part focuses on how women's organizations reimagine and instrumentalize the WPS framework to advance their political, social, and economic goals, often going beyond the agenda itself. And I believe the latter part speaks directly to the focus of our panel today, as it highlights diverse ways of understanding gender justice and reveals different patterns of engagement with the WPS agenda, from active use and creative reinterpretation to rejection and complete disengagement. So one of the key findings is that many women's organizations across the MENA region do not view the WPS agenda as a viable framework for advancing gender justice and therefore choose simply not to engage with it. Many policymakers and women's organizations remain unfamiliar with the WPS agenda or perceive it as irrelevant to national and local challenges. For example, although Jordan and Iraq have national action plans, many grassroots organizations do not find it useful, partly because the documents use abstract language and are perceived as externally imposed, especially by the UN. Women's organizations often lack engagement, and this might also stem from the perception that it does not sufficiently address key concerns such as socioeconomic inequality and domestic violence. Given the WPS agenda's predominant focus on sexual violence crimes in armed conflict, and mainly the conflict setting itself, many women's organizations view it as disconnected from their core priorities and therefore choose not to engage with it. As a result, women in Iran, for example, mainly engage with CEDAW instead of the WPS agenda to demand legal and policy changes on education, marriage regulations, dress codes, and regulations on violence against women. Moreover, some women's organizations deliberately distance themselves from the agenda, seeing it as a militarized tool shaped by security institutions, especially by the UN Security Council, rather than a platform for transformative gender justice. So there is a very strong anti-imperialist rejection to the WPS agenda. Nevertheless, of course, there are cases where women's organizations have prioritized the WPS agenda and actively collaborated in the adoption of national action plans. It is crucial to recognize, of course, here the pluralistic nature of women's organizations in MENA countries, shaped by diverse priorities, regional context, and political orientation. Iraq especially stands out as a particularly striking case where women's organizations themselves initially led the drafting of the National Action Plan, which was later amended and adopted by the government. And this was the first National Action Plan in the MENA region. In Palestine, women's organizations were instrumental in providing data on the specific gendered nature and impact of Israel's military occupation, genocide, and settler colonialism for the National Action Plan, and in advocating and monitoring this plan's implementation. In countries like Lebanon, Jordan, Tunisia, and Morocco, women's organizations worked alongside ministries, offering input and advice to the drafting process of National Action Plan. However, while such women's organizations sought meaningful participation, their participation remained consultative rather than being seen as equal partners in development and implementation of these action plans. Throughout such types of engagements, feminist movements have fostered a diverse and evolving network that reimagines the agenda in more transformative and inclusive ways. Recognizing both its constraints and its practical use by women's organizations is essential here to understand that the WPS agenda is not just a policy, but actually a lived and adaptable tool for feminist peace and gender justice. Women's organizations in Turkey have strategically leveraged the WPS agenda to advocate for the inclusion of women in the peace processes between the PKK and the Turkish government by mobilizing women's groups across the country through workshops on WPS agenda, to talking with the policymakers using the WPS agenda as a legitimacy for why they should listen to these women, and also trying to create global solidarity by showing various examples of national action plans. Palestinian women's organizations have leveraged Resolution 1325 to connect it with other UN Security Council resolutions on Palestine, strengthening lobbying and advocacy efforts at the ICC, and amplifying global solidarity movements aimed at ending the Israeli occupation and establishing accountability. Furthermore, when women's organizations engage with the WPS agenda, they often conceptualize peace and justice in broader, more holistic terms than the conflict and security-focused framework of the WPS agenda. Feminist conceptions of peace, justice are constantly evolving, challenged, and redefined through women's everyday actions, reflecting a broad spectrum of struggles, priorities, and aspirations. Gender justice can be understood as the creation of political, economic, and social conditions that empower women to articulate and pursue visions of transformation rooted in their lived experiences of conflict and everyday insecurity. However, the constrained perspective of the WPS agenda overlooks this wider spectrum of economic, social, environmental, racial, and sexual violence. Consequently, when women's organizations engage with the WPS agenda, they constantly expand its scope, pushing for a more comprehensive interpretation that encompasses social justice, socioeconomic equality, and everyday safety, thereby contributing to a more inclusive transformation of the agenda itself as well. So they don't just use the agenda, but they actually also transform it. Yemeni women, for example, consider without economic empowerment, women remain disproportionately vulnerable, limiting their abilities to participate effectively in peace building and community leadership roles. Examples from Iraq and Turkey show how women's organizations understand peace based on everyday life at home, on the streets, at the workplace, creating an agenda against extremism, militarism, capitalism, and discrimination. To summarize, the experiences of women's organizations across the MENA region show us that gender justice is not a fixed concept, but embedded in everyday experiences. And the WPS agenda can be used as a strategic tool only when reimagined through feminist practices. Then it holds the potential to push for a more inclusive, just, and transformative vision of gender justice. I'm looking forward to hear your thoughts, but also your ideas of what gender justice means. Thank you so much.
Thank you so much, Bilge. Like, I think all of us can't wait to read your book as well. And with this, I tend to Rima. I think Bilge gave us like an overview of different context, and I'm hoping you can help us dive into more practices and with a lens focused on Palestine.
Thank you so much, because we actually decided to make this panel a bit different by making it more conversational, but we gave the first speaker because of our academia and the work that she's doing, but she actually really gave a description of everything that we want to delve into. So I want to start with this. Actually, if you look closely, this dramatic scene was painted by Rubens.
Can you come closer to the mic? So the translator.
Okay, thank you. So this dramatic scene was actually painted by Rubens almost 400 years ago. 400 years ago. Look closely, you see chaos, destruction, bodies torn apart. But at the center, you see women and children. They're pleading and crying. And also look closely at the naked women, which represents, I think, sexual violence. When I speak of gender justice, this is where I begin, because I believe gender justice is not only equality, as you just said, written on paper. It's also about transforming the structures and the narratives that reduce women to symbols of suffering or objects of violence. It's about listening to women themselves define justice, whether this means safety, whether it means dignity, recognitions, or the ability to shape their own decisions in their communities and in their countries. So my own experience in Lebanon, I can say that gender justice faces unique challenges. For example, a woman in Beirut experiences law different than a woman in Baalbek. There are other factors. If we speak about sect, class, nationality, displacement, poverty, they all overlap to either open a door or slam it shut for them. Even the Lebanese justice, and this is where we go local and tell you that there's a personal status law and that differentiates between women from different sects. So, and this unequal rights for women actually separates women and pits them, if you want, against each other. And then there's the penal code, our penal code locally, which treats men and women differently, reinforcing the inequality. And then we can add patriarchy to all of that. So can you imagine talking about penal code, that it was only 2017 when we abolished an article that allowed a rapist to marry his victim. I say victim here because she is. And doing that, all charges are dropped against him and he faces no consequences. It was hailed in Lebanon as a victory, 2017, but nobody read the small print. The small print showed a loophole where in two other articles, it was maintained when the same act is done to a minor
15-year-old or to an 18-year-old with a promise of marriage, if she was seduced with the promise of marriage. But a 15-year-old can also marry his rapist and the charges are dropped. It's still actually in the law, but we hail it as. And then rape, marital rape, it's called marital right. That's how they explain it in our language. Exactly, wifely duty, it is that. And the actual law says if a man has forced intercourse with someone other than his wife, then, okay, you can apply the law. So language in Lebanon is also a problem. And this language also becomes more of a problem when we apply the, if you want, the international terminology that is applicable in international law. So even CEDAW, which is signed in Lebanon over 28 years ago, where Lebanon, of course, made reservations. We love that. We make reservations, but we joined the international community. But 28-year-old reservations, okay? It doesn't matter, exactly doesn't matter, but we're part of it. And for 28 years, nobody moved one syllabus, if you want. But in actual fact, we are, of course, all modern. You know us Lebanese women, very modern. And of course, we can't touch it. But in CEDAW, everybody claims nationality issues. You can't give nationality. But everyone, I'm always amazed that everyone missed one article, Article 16G, okay, that says you're not allowed to choose your family name or your profession. You're not allowed to do that. But exactly, nobody noticed that because everybody, I have a profession. Allowed or not, I don't know, but I have one. But then the family name, nobody believes me when I explain that, actually, stricken by a pen. When I get married, my family status registration, I get hit sort of with a pen, stricken out of it, okay? And then I'm rewritten on my husband's marital family registration. If something happens here, and God forbid, not for me or else, but here, if her husband dies or she gets divorced, she has two choices. She's either registered as the widow of or divorcee of, because there's nowhere, where can she go back to? Here she's stricken, what can she do? So I always give an example of a lady who's educated, what have you, lots of money. She used to drive a Ferrari in Geneva, that was 50 years ago. She's 3 children, family drama and horror because she loses her son and a daughter. So she has to convert to Shia because for inheritance. But of course in Lebanon you can do that, but she still remain registered as Sunni because this is convenient for inheritance, but you don't change. So she marries a childhood sweetheart who is a minister, very powerful. But that minister falls in love with another lady, divorces her. So she wanted to go back to her maiden name. There's money and there's power. Then they told her, you only have 2 choices. Back to widow of, the previous one, or divorcee of this one. She says, no, I want to go back to my maiden name in my region. They said, but now you're a Shia. We can't register you as a Shia, and that they're Sunni majority. You'll add to the majority. So can you imagine? And this is an article in CEDAW, but no one read it. They only read the nationality for children. Anyway, we're going to discuss this because language is so important. So everything, women are treated differently, and the added layer is patriarchy. But apart from CEDAW, we're talking about rape, okay? Sorry if I add to this, international court, war, the consequences of war, 18 years of war, 200,000 victims, more of 40,000 disappeared that they don't know until now. We don't know what happened to them or where they are for closure. We never actually explored that women were victims during 18 years of war because in one lecture, and this was going to really surprise you, somebody came out and said, yeah, nothing happened to women during 18 years because in Lebanon, men respect women. And I said, oh my God, yeah. Oh my God, yes. They massacre the family, but before that, they tell you, I will take care of your wife and your child. Look what happened in Sweden or what's happening in Gaza, مثلا. They respect women. So steps in law, okay? And they start investigating and come up with a report because some women were brave enough to give testimony that they were actually either raped or everything under the sun. But the report was suppressed on the grounds that it's seditious, that it might incite sectarian conflict once again. And this in 2022. So let's go back to gender justice. Let's go back. And I'll say here about my experience in Baalbek, the region where I'm working. And my work has been shaped by this tension between women as victims and women as agents of change, of justice. When I became the director of my NGO, the first thing I did was open a center for women because the area is an underdeveloped, historically marginalized region. We opened a free reproductive health clinic based on the belief that women are agents of change. And also that the first step is teaching women, especially in our part of the world, that their bodies mattered, that they needed to take care of their bodies. But it was also another way to bring those women together because we had displaced women, we had Palestinians, Syrians because of the war, and Lebanese who were poor. But there was always, I'm better than you, even amongst women. But when they came to this free health clinic, they knew that they had same ground. And this is why we should link together and we should help each other indoors, not each one in their corner. The center became a space where all of them, women from all aspects, from all sects, met, shared, and broke down prejudices. In Baalbek, because the barriers to justice are multiplied, their poverty, conservative norms, displacement, intersectionality here is not a theory. It is daily life. A woman's experience of law, rights, and protection depends on her sect, class, nationality, and social standing. I think in all our Arab countries, we have the same challenges regarding this. Our work, reproductive health, GB prevention, legal aid, is always tied to awareness and cultural change, so that access to justice is not opening a courtroom door, it's changing the conditions that make women afraid to walk through it. Over the past 4 years, we have provided free legal services and raised awareness in vulnerable communities. Women not only learned their rights, but believed that they can claim it. One woman told us, and this I quote, "I know my husband has no right to hit me, but if I go to the police, who will protect my children when he's released the next day?" The irony in Lebanon is it's actually the police who calls the husband and tells him, "Come pick up your wife." That's Lebanon. And this sentence captures the reality of many women, the gap between law and lived experience. It is vast. So justice is not only about courts, but about dignity, safety, and survival. This work has taught me that access to justice is not an end in itself, it's a pathway to gender justice. When a woman can walk into a clinic without shame, report violence without fear, or approach a legal help desk and feel that her voice matters, we are reshaping power. Look again, if we return to Rubens, women and children, powerless, suffering. Centuries later, turn on the news and the images are the same. What we have from Gaza, from Syria, women and children remain in the place of war. But the question I want us to consider is, in 2025, are women still only victims? Look at this, the energy in this room, in this conference. Or are they also actors, decision makers, and agents of change? Gender justice will only be real when women are not just symbols of suffering, but leaders of change. This requires confronting structural discrimination in law, challenging patriarchal norms, and supporting grassroots initiatives that give women the tools, space, and agency to claim their rights. Because justice that does not reach the most vulnerable women is not justice at all. Thank you.
Thank you, Rima. Really inspiring to hear your reflections and words, and especially as you take us to a specific location in the Bekaa Valley, which is very close to Syria as well. So thank you for sharing those notes. Kifaya, I think all of us are really eager to hear from you and hear about your perspectives and, you know, get inspired as, you know, we've been doing for the past 2 days with every speaker in this conference. Go ahead.
Try to be inspiring, inshallah. Okay. Maybe I wanted to start to about what Bilga said about women in the Arab region, not thinking of the women, peace and security as a viable agenda or viable option. And to think about it, like since ever been the genocide was like conducted on Gaza, and to this day we have over 6 UN Security Council resolutions on a ceasefire that were vetoed, and you have to understand why women, like in Palestine, basically, I'm pretty sure in the MENA region as well, don't see the UN Security Council as an option. It's always something that hinders the peace process in the MENA region. This is one of the things also I wanted to talk about with the women, because the Israeli occupation for me is the biggest obstacle about us, like Arab women, being able to share our experiences and our advocacy work. I only meet women from Syria, Lebanon, Egypt, any country, any Arab country, only in Europe, I would never be able to see them in Palestine and to share our experience, those collective experiences of trying to fight the patriarchy. What gender justice looks like in Palestine is completely similar to what it is in Lebanon and Syria. I'm pretty sure we share so many things in common, but we never get to share them. And maybe this is something I wanted to highlight is in July 2023, and that was way before October 7th. And when I started working at the Women's Center in March, there was this incident that was reported by Beit Salem, the organization that we had a participant from today. And this report was documenting how Israeli forces use large dogs when they invade homes to make women completely strip naked in front of their family members, and they make them do humiliating poses and under the force and the threat of the large dogs. And when this report came out, it was quite shocking because nobody has talked about it as much before. We knew it happened, but women never came forward. And this is to highlight that this was constant ever since the election of the latest right-wing Israeli government in 2022. 2023, before October 7th, already marked the deadliest year for Palestinian children, according to OCHA. Coming to the story back in Hebron, Al-Khalil, and that's why we're trying to emphasize so much on the language and to say Al-Khalil. Yeah. The report went out. We were asked to make a comment on it as a feminist Palestinian organization. We went on a radio talk show, and our director of programs at the time was talking about how this violates international law and how horrific this is, and taking all the international law takes on it. And then they interviewed a Palestinian tribe leader, Tamimi from Ashirat al-Tamimi, which is one of the biggest tribes in Al-Khalil. And what he said was, this is a scandal. And he started blaming the organization for shaming and for exposing these women. He did not talk about anything else except for, these women, haram, you shouldn't have done this to these women, you exposed them. And this is to give you an overview of what women go through whenever they have any sort of sexual violence in Palestine. This is in addition to the fact that there was a research that was conducted on women detainees in Palestine, and it says 70% of them, they never fully regain their social relationships following their release. Also, one interesting aspect is depends on where the woman was detained or abducted by the Israeli forces from. So if you were abducted from home, you're okay, we know what you were doing. But if you were abducted barra, outside, and that's why it's quite unique. And this is what the Women, Peace and Security agenda and many other agendas fail to grasp when they tackle these issues with Palestine mainly. Speaking, for example, about many things, including the famine in Gaza right now and how it impacts women differently, and how the patriarchy and how many structures impact women differently. For example, one of the testimonies we collected is for women who were widowed after the war, and they are in the hundreds and thousands of women, and how they were approached by men for sexual exploitation. If you give me this favor, and I'll be able to provide you with more aid. This is in addition, obviously, to women not being able, and I'm sure this is similar to Lebanon and Syria as well. If you were married and then you were detained, you wouldn't talk about sexual violence because you would be afraid you'd lose the relationship. And if you were not married, you would be afraid that you would never be married if you talk about any kind of sexual violence that you endured. And this is something that the Israeli soldiers know of. And this is something we heavily documented in Jerusalem. We documented that in the West Bank and Gaza. The terminology they use when they sexually assault women shows their knowledge of the culture and shows that they know that these women are less likely to report this because they know, yes, no accountability whatsoever. This is to add also that the lack of accountability had resulted in so much arrogance that they even take pictures and they post it online with their own names. They even put it on dating apps. If you come to Palestine, I hope you all can come one day and you have dating apps. They use these pictures on their dating apps. Israeli soldiers bragging about the crimes they're committing in Gaza, wearing women lingerie, and we have documented that with pictures heavily. One of the things also that is related to the Arab culture I'd also like to highlight is whenever there's war, wherever there's any kind of unrest, women are less likely to be attacked at checkpoints than men in many instances. And that's why women carry the gold, they carry the expensive stuff, they carry the certificates and documentation, birth certificates. It's always with the woman because the men are more likely to be searched and detained. And also the Israeli soldiers knew of this, and that's why they started looting women at checkpoints in Gaza specifically. They knew women had the stuff. They would strip them naked to see if they're hiding things in their underwear, in their bras, and in their bags as well, make them throw the bags and all of their belongings because they knew women had that stuff. And it's part of our, this is the kind of things we never get to share as women, honestly. It's so interesting also. Yeah. And that's why we try at WICLAC, we understand, we try to, for example, this is one of the points Randa spoke of this morning, is our domestic laws are really outdated. Obviously, we don't have a legislative council, and it's the Penal Code of 1960, the Jordanian Penal Code applied in Palestine, in Gaza, in the West Bank. In Gaza, they have the British mandate. This is how old the law that they have, because they have never got a chance to update it, and it's so backwards. And one of the things also is the definition of sexual violence in the criminal code is so dismissive and it's so reductive. So it only talks about rape if it was only conducted by a man who is not the husband, and it has to be done through genitalia. So if it's done in any other method, or if it was done by female soldiers, women wouldn't even register it as rape. And that's one of the things we're advocating for domestically, is to have a family protection bill that will be able to identify all of these sorts of violence and women to be able to protect themselves. One of the aspects I wanted also to touch on, in addition to so many things, is the LGBTQ question in Palestine, because I'm pretty sure most of you saw comments online of people who would work with Hasbara or propaganda or anything. They would be like, if they see anyone who's queer for Palestine and all of these highly appreciated movements, you would see the comments, why don't you go try and be gay in Gaza? Let's see what's going to happen to you. You're going to be blown to pieces. That's what's going to happen to you. This question also, I need to say, in the penal code applied in Palestine, it's not criminalized at all to have any kind of relations with the same sex in Palestine. This is, it's not criminalized at all.
It's criminalized.
Oh, too bad for you.
Seriously. Large community in Lebanon.
Yeah.
If you ask anyone, but it's criminalized. Yeah.
Oh yeah, hopefully. Inshallah. لا. But yeah, so it's not criminalized, and sometimes it begs the question, should we be the perfect victims for you to have solidarity with us? I'm sorry that we did not get the chance to socially evolve as a community together when we are fractured, when we are distant from each other. And like Francesca likes to call it, it's the archipelago of Palestine. It's like little islands around each other that we never get to even celebrate together or even visit each. I've never been able to go to Randa's house because she's in Jerusalem. I would need to apply to a permit and even go see her. If she doesn't come to the West Bank, I would never be. I've never been to Gaza. I've been living in Palestine for 33 years and I've never been to Gaza. Because I could not. I have to get permits and have so many justifications to go visit Gaza. And we have not got this chance to evolve as a community and to find our own struggles and our own terminology. And this is one of the things I wanted to touch on also, is the language that is being used by some feminist organizations that making it really impossible for the change to have to see a direct impact, is the language that is usually, in most cases, even if it's translated, it does not stem from the struggle of the community. So you try to explain gender to a Bedouin woman who's trying to navigate her life through settler violence and terrorism and trying to
commute to university or schools. One last thing to touch on is the impact of this sexual violence. And in Hebron, we have over 60 checkpoints inside Al-Khalil itself, and many women have to commute through checkpoints. And schoolgirls specifically, going to school and back from school, she would have to go through checkpoints twice, and that's where Israeli soldiers take advantage of the situation. Checkpoints are usually a closed structure. It's not open for the public to see, and this is when most of the atrocities happen, like exposing their genitals and asking schoolgirls to give me a kiss. Why don't you marry me? Why don't you show me what's in your bag? And many girls have dropped out of school as a result. Many women have not, they don't have the chance to even commute to universities or to get an education for that matter, and try to explain to these women about women, peace and security. It's not going to work at this point, and that's why it's about time. I think we should think about exploring venues that are more indigenous to the MENA region. It's more Arabi, أكتر عربي. There is
language.
Yes.
Your name.
Yeah, Kifaya.
Kifaya.
My name is Kifaya, and Kifaya means, for like most of you, I'm sure, who knows Arabic, is enough. And my name used to be used back in the day when parents didn't want to have any more girls. So if they have one girl, they'd be like Kifaya. And then I'm not even joking. Oh, Teta, my grandmother, she has two sisters. She's Kifaya. Her sister is Nihaya, is the end. And her other sister is Khitam. And back in the day,
the end.
That's it. And I was named after my grandmother out of respect. I'm the firstborn daughter, so it's okay. But it was so common, and that's why when we talk about sexual violence, we don't talk about sexual violence. We talk about the Israeli soldiers and settlers exploiting the existing social stigma because they know there will never be any sort of accountability.
So actually, I'm sorry, but when she introduced
You have to
herself,
use
that was my first question. I asked her, were you the last of girls? She said.
Yeah, and it's something in common we have in the Arab culture. Thank you very much.
Thank you, Kifaya, Rima, and Bilge. I think very interesting, conversations, and it's kind of gloomy, everything you've mentioned. But I've been trying to record a couple of things, and I'm gonna go to not the crime itself, but the act afterwards. You mentioned women don't register it as rape. You said reporting this is not possible. We didn't hear about it. The dogs, in the raids, women did not speak up, lack of accountability and impunity. So maybe like with this in mind, I ask people in the audience to reflect, how can we change those verbs, like from being so passive or not possible into ways of connection, and then I'll come back to the panelists, like to hear from them. I can see your hands up, and yeah. Go ahead. Maybe a mic there, please. Yeah. Please, if you.
Hello again, everyone. Wonderful contribution from the panelist sides over the situations in the regional Arabic countries, Lebanon, Gaza, and Syria. So definitely some of the points I hear from Kifaya was we have the similar tradition in Afghanistan, like when there are 3-4 girls at home, then they said a name that Kifaya, Khatam, or Nihaya. This like Basgul in Afghanistan, we have Basgul, Bas, that stop it. Yeah. So these are the similarities, cultural similarities in all third world countries and Islamic countries. We have the same, but very, very teasing points Kifaya explained, like the teenager girls when they are going to school at the checkpoints, the Israeli soldiers teasing them and asking them for kiss or for blah, blah. So these are really very something touch my heart, really. And we as women, when we're hearing these kinds of inhuman behavior with children or with women, so these are really we have the similar situation in Afghanistan. I can say the Hazara girls are now in west part of Kabul. I received many reports from a colleague inside Afghanistan that the young Hazara girls, when they are taken away by Taliban because of the not covering correctly their bodies and bad hijab, this is called, they are taking away, keeping them for 1-2 nights in this police station, and then take them to private jails, and there they are whatever they want to do, they do with them. Sexual violence with different types, group, individual, and blah, blah. So these are very real reports that we are receiving from inside Afghanistan are happening. And also, of course, I believe in Gaza and in Syria, and also in Iraq during war with Yazidi populations, made these kinds of situations. Even in Ukraine, I heard yesterday that men are not safe even from sexual violence. So this kinds of inhuman behavior during crisis, conflicts are happening. So how to really reflect these issues and how to make a reportage on these kinds of situations to really attract the international human rights organizations to really support these kinds of situations and raise voices in favor of these vulnerable groups during conflicts. So it is very important, of course, happen these kinds of action taken, but still there are women, children, vulnerable groups are facing lots of problems and challenges during daily lives that we need to really reflect them as a human being, as a gender perspective should be included in all our reports. These gender violence or conflict in the sexual violence during the conflict in the conflict crisis areas or conflict situations, countries. So it is important. Thank you for your contribution.
Thank you very much for sharing. With Renda, please.
Thank you for all the speakers for the wonderful presentations and very lively one. I want to say that I want to focus a little bit on the, just to share an information first, that there is now an Arab feminist network, CSO and feminist network, that's trying to bring in the MENA region or the Arab states together. And therefore, this is a platform which is very important for us to show solidarity and share experiences within our region. And there's a specific working group on the women, peace and security. Of course, there are other issues related, but that is the one that I think now we're sharing a lot because we're in conflict situations, we're in transitional justice, we're in under colonial occupation, and this is a platform that's very important for us to build solidarity and think together. The second thing is the women, peace and security agenda, which is very confusing to me. And at the same time, I want to give it up. We want to give it up as Palestinian feminists. And we were hesitant because we think it did not integrate situations of colonial occupation. And that's why when we addressed it, we as Palestinian civil society, even before the development of the first national action plan of the Palestinians, it comes the second after Iraq. We were the first countries. It was the civil society who developed a plan, a strategic plan for the women, peace and security. And what we said in that, we have the three important P's that everybody speak about them. We speak about prevention, protection, and meaningful participation. But the Palestinian women speaking about the vibrant, the way how we will look at a developing document, said that look at Article 11 of the UN Resolution 1325. It addresses the issue of accountability. This should be highlighted. We want 3 P's and 1 A, okay? And that is because accountability in our context to address all these crimes that are being committed in conflict and under colonial occupation are very important. So we can really influence how we want this to be the work on the women, peace and security agenda, to direct it in that way. Also, the Palestinian women took a decision which I don't think it's right, but they decided that we leave CEDAW coalition alone and the Women, Peace and Security National Coalition alone, because we don't want them. And what we heard today is how much they are intertwined. When there is layers of oppression, whether patriarchal, cultural, social, all coming together with colonial occupation, they enforce each other, and that should be in our back, in our minds whenever we address these issues. We cannot say we want to speak about gender justice without speaking about gender equality, without speaking about women, peace and security agenda. And that's really something that we need to think about, brainstorm together, and think how we, with the similar religious, cultural, social context under which we live in our region, think about it in a more meaningful way in order to make this, we are not only talking about making women mediators and peace builders. When you see all these conflicts in the region, we don't find a place for meaningful participation in that real sense. But for example, we want to see women, not only what you said about this dichotomy between victims and agents of change. I think if we look at it as a transformative tool, then just this one, I'm not a transformative tool, then we think about how we can develop it in a way where we make women agents of change and contribute, hopefully after ceasefire, soon, for example, in our context, as Palestinians, in decision-making and setting forth the priorities of women, and in pursuing justice and accountability to perpetrators who have committed all these crimes against us. Thank you.
Thank you, Renda. Thank you very much. Natia, yeah, we'll just take one more question or comment. I'm glad to see, Natia, that you're.
Thank you.
Yeah,
I will be very
commenting.
brief. I just wanted to, thank you for all of your insights. It was very, very inspiring, and I took a lot of notes. I wanted to make also a comment on the Yazidi women's situation. I think it's quite particular in the MENA region, because as you know, the Yazidi women actually spoke about the sexual violence. And this is how, the attention also came to our cause. So women in our community really carried the cause, and men led them. And why is that the case? So we know that ISIS also attacked Christian women, Shabak, Turkmen, Shia, also Sunni women, like many, many different communities. So we had actually our religious leader, who is also a patriarchal figure, who said these women need to be welcomed. That in itself is an issue, but it allowed to open all these voices. And I wanted to also bring to your attention a law that was passed in Iraq thanks to the advocacy of these female survivors. It's called the Yazidi Female Survivors Law. It's a reparations law on CRSV that brings reparations to 4 communities: Yazidis, Turkmen, Shabak, and Christians. It has a lot of measures. I won't go into the details, but I invite you to read it. And I think it could be really useful for other contexts, because Iraq, for the past years, I know we can have many criticisms, but they actually have engaged in transitional justice with that law, with UNITAD, with exhumations of mass graves. So I think there are a lot of parallels that we can do here.
Very interesting. Thank you for shedding a light on that. Maybe Mariana, since you already have the mic there. And
thank you so much. I just have a quick question. Thank you so much for the introduction. The universal jurisdiction is now being utilized, as far as I know, Germany. It was also under, it was being looked at from the Swedish Prosecution Authority to look at criminals who have the German nationality or the Swedish nationality who committed crimes in Gaza. My question to you is whether you are following that one up. Are there any information about sexual and gender-based violence inclusion within these investigations?
One more comment question from the audience. Sorry.
You want to reply to her? It's fine.
No, maybe like you can ask and then.
Okay, I have just one comment and one question. So I'm a Lebanese human rights
Can
lawyer.
you use the
yeah.
mic closer?
I just wanted to just add to your comment that why I think these conversations are important, because people might think that we have them back home, but as she said, there's no way I can meet a Palestinian woman living in the West Bank to talk about it back home and to know what she's going through. If we're, even though I think there's so much difference in the struggles that we're going through, but there's also so much in common. And I do think that people should know this is deliberate, like the Israeli colonialism deliberately divide us and our struggles, so we do not come together and try to find solutions, even though the problem is bigger than that. And I think because they do know when we come together, like we might be stronger and find more solutions. But I do have a question specifically on the Lebanese context, and I do think it's wider. It is true that the only solution that could come is to have a unified personal status law. When back in law school, you do study 10 of the personal status law because it's different, as you said, for every sect. It is specific to our country and specific to our context, but we know that today this is not happening. Like tomorrow, we will not have a unified personal status law because the problem is wider and it is political and religious and all of that. So in the meantime, and to be able to get that, our wider advocacy will be to get a unified personal status law. But in the meantime, how can you legally protect a woman using these status law?
Clear. I think that question is clear. I'll give you, Rima, the chance to address this question, but also if you have any remarks on the other suggested question.
Can I add a teeny tiny question? Please.
She's allowed. She's allowed. She's been helping us with it.
It's just, how can we make this gender justice across MENA more inclusive? Since yesterday and today, I heard Yemen mentioned once, and the situation there is more dire to a level that if one of us is liberated, we call her, oh, you think you're Lebanese or Syrian because you have more freedom. And
Wallah,
more...
Syrians? Are we getting that?
Why Yemen is on the conversation?
Good. I think good note. Yeah, Rima, go ahead. But you have to speak to the mic so the translator can translate for you.
I can't do both. I have to use my hands, okay, as you saw. But I think we just succeeded in what we want to do, or else we started a plan to go forward. Because what I first thought, in participating in this conference, was the amazing energy and all this power that we have sitting here. But what we were missing was just linking it, as you said. And what you said, you summarized what is meant to be done. So yes, we're different. Everyone is different. Even in the family, we're all different. But as you see, when we spoke as a conversation, we all have common denominators as women, And I love what Nadia said, because their success story is for all of us. But no, we say, yeah, because they're Yazidi, they're different. They're Yazidi, they're not Shia. Al-Hazari are Shia, so we have, or what have you, ISIS is Sunni. But that's besides the point. Every success is to us a success that should be used and followed as a roadmap for us to take examples and follow through. So what we were missing, let's go back to the consequences of war. We just forgot how war starts. Divide and conquer. We're divided and they conquered because we're all on different land, Palestine. And then it becomes, which crisis now is more important, the Palestinian, the Syrian, or us Lebanese, for example? No, look at us. We're very modern and we have parties everywhere. But yes, because yeah. So what the commonality is, we still suffer from the same things. We're still women who should go to a health clinic where there's all women there. And it starts with the body, all the sexual things. It's cultural. What she said about how we treat in the international community, child marriage, okay? Child marriage is treated as if it's the only the religion that forces it. So we fight religion. But then when you see what they spoke about students going to school and being stopped. Okay, so that enough is for any family to just tell their children not to go to school because they're afraid for their daughters. And because of that culture, everybody knows. So if he stops her, even if he does nothing to her because she was stopped at a prison, even if they treated her very, very well, she'll go back home. The immediate idea is that she was stopped and detained by a stranger. So let's start by fighting the fight with things that we can do. And in Lebanon, it is not the religion. They're all at the very end, and as a result, they all practice the same patriarchal enforcement. But we have a penal code. And even so, I'm starting in the help clinic saying you have rights in religion. So maybe you should first start enforcing your rights in a marriage, which gives women a right to divorce, a right to alimony, a right to child visitation. But in Lebanon, patriarchy says she does not have any of those rights. The religious leader who for the Yazidi was an agent of change, in our country would tell her, give up all your rights for him to divorce you. So let's start somewhere where we can move forward.
Thank you, Rima. Let's hear from Kifaya.
Thank you. And I'll just get back to the CEDAW and the women, peace and security, and maybe starting by saying that even being able to be here is a privilege. Because in order for you to be able to be here, you have obviously to speak in English in Arabic societies. And if you can speak good English, then you can go places and then you can talk. And I am privileged to be here. And the question is, how do you convince people who are under a genocide for 2 years, who feel like the whole world's against them? Because obviously not even aid is going in. Women are being starved with their children, and they're being amputated and all of that. And this is in addition, obviously without mentioning the other stuff, like the complicity of Meta and social media companies in suppressing the Palestinian voices. I know of so many journalists who have lost their accounts on Instagram, on Facebook, for speaking about what's going on in Gaza. And this is obviously in addition to being targeted as journalists and having over 300 journalists being assassinated along with their families. And nothing is being done on the ground. I know there's so much solidarity in the world and it's highly appreciated, but how do you convince these people that, okay, maybe we should start an action plan to work on women, peace and security? And even as our own work in documentation, when we go to villages and when we go to these communities and we try to take their accounts on what happened, then we can take this to the Commission of Inquiry. We can talk about this and maybe universal jurisdiction. I'll get to that. How do you convince her that this is actually going to do something? They ask me, can you do something with this? And they would be genuine, like, would this change something for me? And I try to tell her that we should have faith. We should do all of that and have it all written. But at the end of the day, nothing is going to save us. When it comes to universal jurisdiction and even the work of the ICC, which is something we have been longing and thinking about working with, but with the sanctions of the US being imposed on the International Criminal Court and the special rapporteurs, it makes you wonder, am I willing to make our organization go being sanctioned and deny hundreds of women our other services? This is a very important question that many organizations have to ask in Palestine, especially that even the UN cannot protect their own at this point. Nobody can protect us from the most heavily technology advanced entity that's trying to eradicate anything that even says anything negative about it. Like, this is what's going on, and it's, we are the most surveillanced civil society with Pegasus. Like the other day, this woman from Bahrain who's an activist was talking about how she realized that she had Pegasus on her phone. And we were trying to tell her this was tested on us. We are the lab rats at this point, and that's why we always call for a two-way arm embargo, just in case. And that's why women in Palestine have tried to find different ways other than the mechanisms that we have at hand, is BDS, boycott, divest, and sanction. We boycott. We have feminist groups that do boycotting in Palestine, obviously, and outside. And this is to emphasize on the importance, because we saw that governments and member states needed political will, but we know the people don't. We believe in the people and the power of the people to change. And that's why you see Sumud Flotilla. And that's why you see so many strikes going on and demonstrations around the world. This is because Palestinian women believed in the power of the people and not the states at this point. Universal jurisdiction, it's terrifying for us to even talk about this conversation, because we might genuinely, me and Renda going back, we might not even be allowed in. So no, thank you.
Thank you, Kifaya. Bilge, any reflections on the comments or the questions? It would be lovely.
Thank you very much. And I should, I think, up my game in terms of more interactive presentation. But maybe one contribution, I'm from Turkey, a little bit the troublemaker in the region. We also say yeter to the last kid, or when we want to have enough. Yes.
Yeah.
So it's yeter.
It's never a
Yeah.
boy.
So it's something, yeah, unfortunately, we all have that. Apparently, we don't want that many girls. For the questions and the comments, I think I can say, maybe starting with the Palestine, that's exactly the beautiful thing about civil society organizations' work. As you mentioned, like looking at the agenda, okay, these are the pillars, but I think this makes more sense for us. So how we can reinterpret it, how we can create our own national action plans, local action plans, shadow action plans, right? There are so many practices on this case. So this is how we can make it useful. I think these kind of international frameworks, only how we can interpret it in our in national, local space. But also the whole thing with the WPS agenda, this whole love and hate relation. Because if we think about how the WPS agenda started, it was actually feminist civil society organizations in the beginning of 1900s, their efforts. And it was not only in this part of the world, but it was actually a global effort that led to 2000 and push for UN Security Council, the biggest militarist, masculine institution to actually accept these feminist civil society organizations kind of intervention. But of course, we see a framework in the end of the day which is co-opted and manipulated. But it doesn't mean that, I don't know, we can give up on this, because I feel like this is something that feminist legacy created. But also there are realities of how Security Council operates and how political dynamics emerge there. I mean, the last resolution, for instance, if we look at it in 2019, when the civil society organizations tried to push for a more inclusive gender definition, reproductive health rights, the biggest veto that they received was from Russia, China, and then it was the Trump's first period, and they said, if you won't take out reproductive violence, we're out. They even wanted them to take out gender from the new resolution, but that was the kind of bargaining, to take the reproductive health rights, but at least keep the gender. So the struggle still continues, but of course it still depends on what we said, so how we can trust these mechanisms. But I think still, as far as I could see from my academic work, but civil society holds a huge power to transfer this framework and actually bargain with the government, bargain with the international organizations, either to participate in a decision making or receive funding whatsoever, but they use this as a bargain chip, and it is quite powerful. In Turkey, they couldn't manage it. They tried to bargain it, but they failed. And now I was part of a kind of a movement to push the government to adopt a national action plan. But in the current situation in Turkey, we're just trying to keep what we have instead of trying to push for new agendas. But yeah, I think that's the kind of the love-hate relation with it. And the final thing about the attention, and I think it also reflects with the Yemen question, that's also unfortunate things, right? Because we're still in the very marginalized space in terms of talking about what is happening to women, what is happening to LGBTQ plus communities, what is gender, and so on. This is still such a marginal topic. And we normalize and we forget. I hope this won't happen in the Palestine case, but it happened in Syria. It happened with Yazidi women. It happened with Yemen. We forgot. It happened in Turkey. since it happened in Afghanistan, of course.
Sure.
I mean, since I born in Turkey, we are in conflict. We never accept that we are in conflict, and everybody forgot what's happening to Kurdish women. So we don't even talk about these. So unfortunately, we always need to continue fighting and bring in these issues. I don't know how else to keep the attention, unfortunately. Thank you.
Thank you very much. Really insightful, I think, final remarks, but I think we have time for one or two more comments or questions. Okay, that would be great if we can take that.
More of an observation, and good to involve our online people who are watching. Just Bola says that some of the cultural similarities with some of Africa are striking. It's a strong reminder that gender justice is a cross-border issue that requires cultural transformation. How do we address the issues of religious and cultural transformation, considering the sensitivity of these subjects? In Nigeria, for instance, religious sensitivities lead not just to sexual violence, but executions as well. It's a good observation. Any more? We're going to go until 3:15 and then take a half-hour coffee break. So I think we still have time for one or two questions, if anyone has any.
That.
I've also asked a question. This is maybe more to Rima. How much do you think that the issue of representation in political institutions is linked to the fact that the legislation in Lebanon is kind of lagging behind general public opinion? So the fact that we have, at the local level, we have a system where it's, you don't even vote in your own community because you're registered in your father's village, etc. And then we have only about 3 or 4% women in parliament. Do you think that this could actually change, legislation to be more gender responsive?
When I present my cabinet,
I'll vote for you when I get my nationality.
But yeah, actually, I
Maybe, yeah, we get the other question and.
Hi again, everybody. Thank you so much for all of your comments on the panel, especially our Palestinian colleagues. It's coming from the United States for this conference myself. It's pretty unheard of to, in the American academic environment, have such candid thoughts offered about the genocide going on. I found the panel this morning and your comments today really moving, especially offering your expertise to this audience in the context of a genocide against your people. So thank you very much for that. But I wanted to ask about the post-conflict potential in Syria and lessons from the Lebanese post-conflict society. So, and I loved your comments, Rima, about the national laws and local laws within Lebanon. My boyfriend is Lebanese, and we've talked often about like his kids, our kids will be Lebanese, but his sister's kids, because she married a non-Lebanese, will not be Lebanese or not have the nationality rights. So the local tiny laws, seemingly small laws, as expressions of patriarchal values are so interesting. But I was wondering, in the post-conflict Lebanon society, what lessons, positive or negative, in terms of incorporating gender justice perspectives in the peace-building process, and what perhaps lessons, good and bad, for your neighbor Syria as they enter post-conflict transitional justice situation?
Thank you for that question. Okay, I think we can just have the response from you, Rima, and try to wrap up.
short version or
No,
long version?
you have 5 minutes, like 4 minutes.
You know me, very rapid, but thank you both for this question because I think they both could. I told you. Where's the stand? Yeah, thank you. Because they both. There you go. They both can be merged into the one question. So we never got into post-conflict, if you want my opinion, this, because I teach conflict resolution. I'm a mediator. So one thing about conflict is that when it stops, when it ends the violence, I mean, the actual warring factors, then there's a lot of work to be done until you just end the conflict. Unfortunately, Lebanon, this part was never done because, as I said, when law came out with the consequences or the impact on women, it was suppressed because seditious, it'll reignite the war. And this fear has always been with the Lebanese, or insight insidiously done by the leaders for the Lebanese to always be afraid and never move forward. So saying that, when you ask Cecilia about the representation law, in the Constitution, both men and women are equal and they can both run. It is actually the electoral law that is being, of course, and it is the same law that is being renewed since 1962. They refuse a new law in compliance with the Constitution by fear that they will not be elected. So they need that religious idea. But at the same time, if you're talking culturally, and I love the comment from Africa, like the comment from Afghanistan, the same thing. Always look at the cultural context in Lebanon. In Lebanon, the public space is not safe. The private is. So, and this is where, let's run it through your mind, the thread in patriarchy. So the control is for the man and over the women and youth. So even the youth are not allowed to vote until they're 21, but they're allowed to drive at 18, okay? So give that to us and give me a reason, or what's the reason behind it? But women too. So, and this is why when they strike her independency from her family registration and then puts you on another, it means now you're under his agency. And given that, then you are only protected in the public space when you are under his, what you call it? Yeah, exactly, to guardianship or what have you. And it is a guardianship. And Cecilia, to go back, representation you see in women, they're the most educated. Females are the highest education, highest number statistics in working forces, in all the professions. I'm a lawyer. I mean, the majority of lawyers, engineers, everything are women. So why aren't they in politics? It's because of that. When you're in politics, if you're not, you don't have a mentor who's a man and a powerful one, then you will get, it's like the students in a bus at the checkpoint. You'll get insulted on the worst level because you do not have somebody who protects you. So I'll give example of our representatives, female representatives today, and I'll say names. One is the sister of, one is the daughter of, the other is a relative of, and the third one, a doctor and what have you, but she's in the party of.
Yeah.
Nobody dares attack them, but there's only one or two who got elected after the revolution. And these two women have been subjected to the worst kind of sexual campaigns ever. I mean, you speak to a deputy on TV, public TV, accusing her of being, the other one comes into her office in Parliament and finds back issues of Playboy and things and condoms in order best to treat her as if she's nothing. And that's what you get when you're not being pushed forward by a male mentor.
Yeah.
And that's the problem. It's not because we don't want to get into, or don't want to run. I'm going to run, and nobody would dare speak to me.
Thank you, Rima.
So
Thank you very much. Thank you, everyone. I think a lot of food for thought from this conversation. I encourage everyone.
I want to tell Turenda what she said about 1325 is extremely important. Actually, I came out to Nadia because I thought her experience was so important. I went up to the lady, she's not here, who spoke about peace and security, and asked her, please give me guidelines on what to look for, on how to push it forward, because I don't know peace and security. We're celebrating 25, and they kept sending us, what do you have? And we kept taking pictures with security forces to show that but there is no security and peace. We don't know what to do with that.
Thank you, Rima. Thank you, everyone. I just want to close by quoting Bilge and saying, like, how can we make sure those causes are not forgotten? How can we support each other also? Because you just spoke about, hate campaigns and, doxing women. We alluded a little bit about, online harm. And again, I reinforce, the great mission of the hub to support the supporters. So I guess at least we know we have, faces that are smiling, that are encouraging, and for me alone. And kifaya, I really hope that everyone and that there will be a kifaya to the violence in your country. And you will be the bidaya of a great future for Palestine, but also for every woman activist in this global justice movement, not only in the region. Thank you very much. Thank you, everyone. Thank you, Rima.
Thank you so much. I'm sorry, Rima, to have to cut you off, but she will be at the coffee break. Okay, everybody, we're moving into our last coffee break because we want to come back promptly at 3:45. We're finishing a little bit early because we notice it takes time to have coffee and speak to each other. So please come back here. And also, I have a note to tell you that there is a get together. Sorry, I have to check my information. Here we go. There is a small get together close to the conference at the Butterfly Bar, first floor at 6 p.m. Okay, I'll tell everybody later, but just to let you know that. Pardon? It says it's a butterfly bar, so I guess so.
Yeah.
Yes, it is a bar, Rima. Yes. Any other questions about that?
So next to that, that there is like a small, nice table. So that's our ISS bar. So we're going to have the drinks there.
So here.
So again, we go
Here in the building, and exactly. Good. You know where it is. I didn't, so that's helpful. And I'll repeat it again at the end. Thank you so much. What a fantastic panel. And just to say, yeah, we brought out that gendered crimes report that I think we're talking about during the Lebanese war. It was Law that investigated and brought out the report. And she's right. I was threatened. The organization was threatened. Don't bring out the report. But when we did bring out the report, we had survivors sitting next to me. People just stood up in the room and said, it happened to me, it happened to me, it happened to me, and started the conversation. That's a terrible thing I just did. So I took complete advantage of having the microphone. Okay, everybody, coffee break. Thank you.
Perfect. Good afternoon and welcome to our final panel titled Next Generation Strategies in International Criminal Law. And before we look forward, allow me to look in retrospect for a moment. It's always useful to look both ways before we cross, as the saying goes. So I won't go very far in history, just look back at this year, which has been marked by profound uncertainty, starting with the funding landscape in turmoil for gender justice work, wars and violence that dominate our consciousness and our deadlines and seem to deepen and multiply, the impact of sanctions that destabilize and deter, and technological shifts that feel almost impossible to keep pace with. And in such a context, for me personally, but I imagine for many others too, it becomes very difficult to plan and strategize and to think beyond the immediate crisis. So leaving one feeling disoriented, numb, even paralyzed to a certain extent. And of course, it's essential to acknowledge that some crises like wars, mass atrocities, genocide, are inescapable and rightly demand our full attention. But unfortunately for too many, these are not abstract disruptions, but lived realities that cannot simply be set aside in the name of looking forward. And naming this is important because any call to look forward is not meant to diminish the urgency of response where lives and communities are at stake. And I also find it important to encourage and allow ourselves to embody these feelings, the uncertainty, paralysis, the grief, and sit in their discomfort, because they tell us something very real about our world and they can be very instructive. Yet the risk is that if we remain too long in these feelings, we can get trapped and we respond, we try to defend what is under threat, but we do not imagine, reimagine, and we stop building what is needed next. So we heard about the need to reimagine yesterday in Lily Cather's intervention. the importance to make space to reimagine beyond the narrow confines of current institutional political realities. And this is because our present circumstances can be very limiting or even suffocating. And if we do not engage in the act of imagining something different, we risk accepting those limits as permanent. And this is where today's panel comes in. I feel very privileged to moderate and be in conversation with such a legendary lineup, both in person and online. Each of our speakers for this panel will push us to think beyond reaction and toward a more visionary and resilient practice of international criminal law. And as you listen, I invite you to think about your own work. What practice, policy, or tool will you take forward from these ideas? What will we learn and implement in our work to ensure that this system, this ecosystem that we share amongst each others and with others, remains relevant and resilient for generations to come? Enough from me. Our first speaker is Leila Sadat, joining us online, James Carr Professor of International Criminal Law at the Washington University School of Law. Leila will set the stage for us for this panel by exploring how the draft Crimes Against Humanity Treaty can better integrate gender perspectives. Leila, over to you.
Thank you so much. Can you hear me okay?
Yes, perfect.
All right. And I did prepare a PowerPoint, if that's okay. Am I able to share my slides?
We can try to make you co-host if you could just give us one moment.
Yeah, because I'm sending you a request now. Meanwhile, I'd really like to thank the organizers, and I'm super disappointed not to be there in person with all of you, especially given the good friends that I'm missing. And I know that the real work in this conference is going to happen over coffee and over drinks this evening. And I'm just really sorry. I was actually in Paris, and Friday I was in Strasbourg briefing the legal advisors of the Council of Europe on how to take this new convention forward. So I'm going to piggyback a little bit on those presentations to talk a little bit about how we can think about gender and gender crimes and gender competency in this new treaty. Knowing that you have so many experts there, I'm just going to offer you a few things. So hopefully you can see my screen. Is it visible?
Yes, we see it.
Okay, perfect. So this is really talking about the new treaty on crimes against humanity and how it might offer an opportunity to really enhance not only the prosecution of sexual and gender-based violence, but the prevention of that violence. And these insights come not really from me, but for all the experts that have been working on this treaty for so long. So if you don't mind, Valeria, I'm going to parachute back to move forward, and I'll be relatively brief with my comments. As many of you know, I've really worked on crimes against humanity since, well, a long time. Let's put it that way. My very first article was actually on domestic prosecutions of crimes against humanity in France, and I served the ICC prosecutor for 10 years as a special advisor on crimes against humanity. And so I've had a lot of time to think about these crimes. And in thinking about how to create the new treaty, I think we have to go back to our core values, and one of them being gender competency, obviously, but there are others. So this was a little picture from St. Louis, Missouri. I don't know if anybody here, I see Valerie. I see Valerie, we don't look any older. This was actually the initial meeting that we had in St. Louis, Missouri to talk about whether or not we needed a new convention on crimes against humanity. This is April 2009, and it was a very historic meeting. And you can see some people, one of whom is no longer with us, of course, Sharif Bassiouni. But fortunately, we haven't lost too many others. And we really got together and sort of pushed around this idea. We thought that there were really gaps in the Rome Statute system, and that was true in 2009, and I think it's even more true today. And as was expressed during the introduction, we can't really sit on our laurels in international criminal law, because the criminals don't, right? The violence doesn't, the conflicts don't. And so even while we're building the International Criminal Court, which in 2008, 2009 is a very, very young, very new institution, we nonetheless have to look forward and think about the international criminal law of the future. And one of the things that really provoked me was Bosnia versus Serbia, because in that case, if you recall, the International Court of Justice said that even though these terrible atrocities had been committed in the former Yugoslavia, 100,000 deaths, 50,000 rapes, they were, and one of the concurring opinions says, they're only crimes against humanity. They don't constitute the crime of genocide. And that infuriated me because, of course, crimes against humanity should be front and center when thinking about atrocity crimes. And so there is no state responsibility with respect to the Rome Statute. There is no interstate dispute settlement. There's no system of mutual legal assistance. It's not binding formally on non-states parties unless the Security Council intervenes. In 2009, we predicted that the ICC would probably take very few cases. And in 2025, we now know for a fact that the ICC will take very, very few cases and that it will not have the capacity to deal with the widespread criminality that we see in the world, which unfortunately is not on the decrease, it's increasing. And so we see a legal gap and we see an impunity gap. So our draft was relatively long. And the reason I'm giving this history is when we're reimagining the future of international criminal law. And at this meeting I was at Friday, this conversation already started to happen. Even progressive states and individuals that think of themselves as progressive in the field of ICL will start to sort of pull their punches, right? Well, what's reasonable? What's practical? What can we really get states to do? And I feel like that's kind of negotiating against yourself right from the outset. What you should do is really pick the language that is the best in your view, sustain it, advocate for it, and then it'll get negotiated down, because that's what'll happen during diplomatic negotiations. But I think if we start from a position of, oh, we can't possibly get this because it's not practical, we'll never get anything, right? We'll get something terrible. So our treaty was much longer than the International Law Commission draft. Our treaty included Article 27 of the Rome Statute on immunities. It had a provision prohibiting reservations. It had some provisions that a treaty monitoring body, for example. The preamble had a Martens Clause. There were various elements. But even that wasn't a finished project in a way. It was an academic offering to the international community. But through the academic work and the civil society participation that went into building that treaty, and we had 250 experts from all over the globe participating, we came up with these sort of 4 core principles that any new treaty on crimes against humanity would have to engage in normative development and enhance the normative foundations of this crime, that it would have to have a prevention dimension, which would be substantial, a punishment dimension, and it would have to help states with capacity building. And that last bit was very, very important, especially to Global South states. Why are crimes against humanity so important? And some of you have seen this slide before, but I put it up here again because it's an intuition that really came to me after studying what was going on at the ICC, because the ICC was our first time that we had a court able to operate in real time. And so this idea of a peacetime crime that you could adjudicate, that you could prevent, that you could prosecute was really quite new, because the ad hocs were always after the conflict, right? The Rwanda Tribunal, the Special Court for Sierra Leone, the Nuremberg Tribunal, the ICTY. And at the ICC, we saw in so many cases, Kenya, Venezuela, Burundi, Philippines, only crimes against humanity are being charged. And that's completely new. At the ICTY, only 1.2% of cases were crimes against humanity only cases. At the ICC, we're between 30 and 40%. So ICC is very different, and we see that the real issue in the prosecution of crimes against humanity and deciding whether to go forward is the frontier, not between war, certain atrocities that you can get under the laws of war and other atrocities that you need CAH to sort of gap fill. That's the original concept, is that crimes against humanity are gap filling in humanitarian law, but they take on their sort of own flavor in that you're really deciding whether crimes against humanity have been committed because massive human rights violations are occurring. So at the ICC in the early days, the prosecutor would ask me to do a lot of work in situations where we're sort of like, is this a human rights violation situation? Should it really be in Geneva where they're talking about what's going on? Or has it degraded into criminality? And I came up with this concept of the atrocity cascade, which is a riff on Catherine Sitking's justice cascade idea, where you're really seeing human rights violations leading to the commission, to the commission of international crimes. And often Syria is a great example. Then the parties take up arms, you're in a civil war, and then you're in a situation of outright genocide or pockets of genocide. And I think Gaza is an example of that, right? The Palestine situation where you have a human rights problem that degrades into crimes against humanity, all-out war breaks loose, and we're talking about genocide. So I think this is why the prevention and prosecution of crimes against humanity in peacetime by state and non-state actors is so important. So as you know, the International Law Commission took up, after we sort of floundered in the wilderness for a couple of years with our project, and then we got very lucky and the ILC decided to take it up. Professor Murphy had come to our last meeting at the Brookings Institution, where Patty was actually, and gave a talk as well. And the ILC then took it up, and over 6 years, the International Law Commission developed a draft. Now, very few women sit on the International Law Commission, so I won't say it was a particularly gender-sensitive draft, but nonetheless, there were comments. If you see this little thing, because when they finished in 2017, they took on comments after their first reading, and all of a sudden, organizations that focus on gender, Women's Initiative for Gender Justice, Madre, lots of groups realized that this really would be the first treaty that would have an interstate dimension that could focus on sexual and gender-based violence. And that was a revolution. And so we got a draft, I think, because of the intervention of so many amazing women and organizations from civil society focused on gender competency. We really started to get a draft that was much better. And we got the 2019 draft articles, and then the commission decided to take the draft to the General Assembly and propose that there be a new treaty. So then we had to move to New York. Some of you have sat with me in New York. Akila is in the room, I know. We've sat together many times. She's probably sitting right to my right in this picture, sitting in New York trying to figure out how to get this treaty off the ground. And most of you know that from 2019 to 2021, we just couldn't get it past the consensus principle. In 2022, Mexico and Gambia, leading a coalition of states, managed to flip the process to create a 2-year window for substantive discussion, which took place in 2023 and 2024. And then you can see state enthusiasm for the draft treaty actually continuing. And I have to give a big shout out, I always do, to my student teams who compile this data every year. You can see basically the number of states in opposition stayed completely the same, whereas the number of states who express, we can only measure states that actually express themselves, states expressing enthusiasm really grew exponentially over time. And that gave us enough of a push in December of 2024 to get it over the threshold. The dip in 2020 is the pandemic. So this is where we are right now. Kudos again to another student who did this draft, and it really shows us the pathway forward. And right now there's a huge number of conferences, meetings like the one I just went to. I'm going to another one next week, where we're really talking about what's the strategy. And this is a super important time for organizations that care about gender competency and gender justice to really be involved. Nothing's going to happen yet, so it's preparatory work, so we don't need to panic either. It's just a question of sort of thinking ahead. The formal negotiation process won't actually start till 2028 with the diplomatic conference, but the preparatory committee that will meet in January 2026 is really the opening of negotiations on the treaty. I could explain why it's a 5-year process and not a 2-year process. If we were over drinks, it would be a much better explanation, but suffice it to say, the Russian Federation stood up and made a big mess during the 6 committee meetings in November, and this is what we ended up with. And kudos to Mexico and the Gambia and all all the other states that came together to hold together a coalition. And 192 of 193 UN member states agreed by consensus to do this. The resolution was adopted by consensus, both in the Sixth Committee and the GA, with only the Russian Federation dissenting. And you can see this is kind of what we have now. So moving forward to reimagining, and do I maybe have a couple more minutes?
Yes, you do.
Yeah, okay. Moving forward to reimagining. So we have these great articles. They came out of the International Law Commission, and there are only 15 articles with a preamble and an annex on cooperation. And the International Law Commission had different preoccupations. We were civil society. We wanted the best treaty we could imagine at the time, right? You guys can make it better now, but that was the best we could do in 2009, 2010. The International Law Commission doesn't want states to stick its work on the shelf. They wanted something that would be acceptable to states, practical and effective. And fortunately, I think it's not really a lowest common denominator draft. It's quite good in many ways. I think it got more conservative over time because we moved into a Trump era, right? And we're back in a Trump era. We're back in an area of difficult geopolitical concern. But and it's not just the United States, right? It's countries like France insisting on Troika immunity or Germany, et cetera. So civil society and states during the debate in New York over 2 years had sort of 3 different kinds of proposals that were coming up. Either additions to the draft that just weren't covered because the ILC did a kind of lean draft. So there's no final clauses, nothing on adoption, amendment, entry into force, reservations, et cetera. Then there were additions that were proposed by states or members of civil society that really are based on the evolution of international criminal law since the drafting of the Rome Statute or their own preoccupations. And the Rome Statute is the centerpiece of the new treaty, and particularly in 2009, 2010, when we were drafting, and even as the ILC did its work, the core principle driving groups was do no harm to the ICC. That was very, very important because, as we know, the ICC is a fragile and young institution. So the idea was that this vertical mechanism would complement, this horizontal mechanism would complement the verticality of the ICC. Now, it's 25 years later, and so groups are starting to say, even ICC states parties, look, I think we could consider some modest improvements because ICL has evolved, or they're just new crimes that have emerged. And then there are changes that have been proposed, deletions or additions to the draft articles that might clarify or expand, or, and here's the risk, because when you open things, you could get contraction of state obligations as well. And so I'm chairing right now a study group. Some of you are in it. Patty's in it. Valerie's in it. Akila, that's looking at some of these issues and how, for the purposes of our talk today, many of them do relate to gender. So there'll be a paper on gender. There'll be areas that aren't addressed, such as some of the crimes that I'm going to talk about in a minute: forced marriage, gender apartheid, persecution, forced pregnancy. And one thing nobody ever focuses on is modes of liability. But as Patty and I know, modes of liability is the death knell of prosecuting sexual and gender-based violence. And everybody leaves it out. And that's where all these cases go to die, because you can never prove the mode of liability. And we've just seen that in Yucatan. We saw it in Al Hassan. We just keep seeing it over and over. And Katanga, we saw it. Where else do we see it, Patty? We see it everywhere. So all of these things are going to require a gender sensitive and gender competent approach. We can't just say, oh, you know, the reparations, we don't need to worry about gender there. Definition of victims, definition of, you know, even the dispute settlement clause, everything has to be looked at through this lens. And so this is really, as I said, very exciting for us. It's the first interstate criminal specialized convention applicable in peacetime as well as wartime that will include explicit provisions on sexual and gender-based violence and gender violence. It's a very exciting opportunity. And that does make it critically important to take a gender competent approach. And I think many of you have been in the forefront. I feel like I'm learning from you every day on how to do that, other than we need more women involved and people that have this in the back of their minds. But I think it's something to do. So I'm just going to talk in just one more minute of something to think about as we think about the definitions of the crimes, because a lot of civil society interest goes into definition. But as I said, during the negotiations, we have to think of all the other technical stuff because gender shows up everywhere. So what about the relationship of existing norms to the new treaty? And here I'm just going to talk about a few. Some of you might remember the North Sea Continental Shelf case from Public International Law, if you took that course a while ago. So when I teach that, that was a case in which Germany was really mad at Denmark and the Netherlands because they were kind of cheating Germany of some of its continental shelf by trying to apply a treaty provision in a convention that Germany hadn't ratified. And the 1958 Convention on the Continental Shelf. And so the case is long and I don't need to belabor it, but the court comes up with a schema that I've called the 3 C's. Sometimes when you see a provision in a new treaty, it has codified customary international law. Sometimes it's crystallizing an emerging norm of customary international law, and sometimes it's creating a new norm of customary international law. And this is explored in the case and in much of the literature. And so when we look at the gender proposals, I think it's important to recognize, are we just codifying something that's already there? And I just had a big argument when I was in Strasbourg with, I won't say who was arguing that slave trade was this huge innovation. And I'm like, you got to be kidding. This is codification of existing law. It's actually in another treaty. There's absolutely nothing controversial, in my view, about adding this from a public international law perspective. And so why wouldn't you do it? Then you have emerging norms, or norms that you're not sure if they're clearly codified or emerging, and maybe Valerie will talk about that, but forced marriage is one that 3 international courts and tribunals have now adjudicated. So it's either codified or crystallized, but it's clearly, we have elements, it should be easy. And finally, you have, in my view, new norms like gender apartheid, and we've seen other things, ecocide being proposed. Has ecocide crystallized? Is it, you know, sometimes you have frontier issues. Why does this matter as well is during the negotiations in New York, you heard some states object to adding new crimes or to using other inhumane acts because they have very strict legality principles in their national systems. And so we have to think, as we're negotiating the new treaty, we can keep using other inhumane acts to just put all this stuff in. But in some legal systems, that might be problematic, and you would lose the expressive value of naming the particular harm, right? And so sometimes I think we have to think about this kind of codification in this way. And I just throw this out. I don't have a strong view about any of them, but except slave trade. I have a very strong view about that one. And so I do think that this is something we're going to see. So I'm going to stop there. I know you have other amazing panelists. A lot of this is available on the Harris Institute website. And of course, I really wish I could be with all of you to see you in person. Thanks so much.
Thank you so much, Leila. Thank you for starting this process many years ago and for continuing to have energy for it and for driving change and nudging us about modes of liability. That's really important, I agree. And we will now turn to our second speaker, Patricia Visser-Sellers, international criminal lawyer and former special advisor to the ICC prosecutor on slavery crimes, visiting fellow at Kellogg College at Oxford University. And Patty will present on the proposed slavery crimes amendments for the Rome Statute and the enumeration of the slave trade in the draft Crimes Against Humanity Treaty. Patty, please go ahead and we'll get your slides going in a second.
Okay, thank you very much. Like Leila, I'm sorry that I can't be with you, particularly in the corridors, at the bars, maybe even in the bathroom, hanging out, not coming back in time for the next session. So I thank everyone who has come to this session. I'm going to be speaking about amendments to the Rome Statute. And there is a process that is going on right now that relates to the International Criminal Court, the Rome Statute. I would just like to correct on this first slide, thank you, is that I'm the former special advisor for slavery crimes. Like some of my fellow panelists, we were special advisors before. Could you go to the next slide, please? Sierra Leone, who is an Assembly State Parties member and also holds vice presidency of the Assembly State Parties, has proposed that the Rome Statute of the International Criminal Court be amended. And the amendments are twofold. They include the slave trade for crimes against humanity and for the war crimes provisions, and also slavery. So what I wanted to do was first tell you a little bit about what slavery and the slave trade crimes would do in the Rome Statute. And then I'd like to get to a little bit of the political dimensions and the gender dimensions that have been so much a part of your conversation during this past 2 days. Well, first of all, I want to review that Sierra Leone said that they want to place the slave trade within the Crimes Against Humanity provision of Article 7 of the Rome Statute. Now, you would look over and say, oh my goodness, why isn't the slave trade there? And then many people say, oh, there it is. It's under enslavement, trafficking. So I want to reiterate that what is in the Rome Statute under enslavement are examples of indicia of slavery. Trafficking is not the equivalent of a slave trade. So there is a legal gap under Article 7, Crimes Against Humanity provision, and that gap is the slave trade. And the slave trade, what does it do? It prohibits all acts involved in the capture, acquisition, disposal of a person to reduce that person or to maintain that person in a situation of slavery. In addition, Sierra Leone has proposed that slavery be added into the Rome Statute. And you would say, where? Well, under Article 8, which contains provisions for war crimes, both the international and non-international armed conflict, you look at that very, very long list of war crimes, and you look at it closely, and you see that it does not have the prohibition of slavery, nor the prohibition of the slave trade. So placing the slave trade or slavery within the war crimes prohibition, basically, as Ella said, that's just reiterating what's codified law, what's customary law, what is Rule 94 of the International Committee for the Red Cross's study. So what is slavery? Slavery prohibits the exercise of any or all powers attaching to the rights of ownership over a person. As a matter of fact, slavery or enslavement, sometimes it's called, is such a well-accepted international crime. It has use quotient values like the slave trade. But let's go to the next slide and let me show you a graphic that might help our understanding a bit more. Before the amendment, Crimes Against Humanity contains enslavement and we know sexual slavery, but it's missing slave trade. Slave trade is how someone is reduced to enslavement or to sexual slavery. So therefore, there is a gap, a real legal gap within the Crimes Against Humanity provision. And after the amendment, you can see the whole circle or the donut, placing the slave trade there, that gap would be filled. Can we go to the next slide, please? And this shows the same thing, but under the provision of Article 8 for war crimes. Under Article 8, what we are missing to make the donut or the circle whole is a provision for slavery under international or non-international armed conflict and the slave trade. Because right now, what exists under Article 8 is only sexual slavery. So you can imagine that the drafters of the Rome Statute might have been particular to include sexual slavery due to a lot, I think, of the lobbying of the feminist group, but slavery and the slave trade were overseen and left off, and that's impunity. Could you go to the next slide, please? In essence, the Rome Statute disrupted the framework of international law as it relates to slavery crimes. There are contemporary situations of slavery crimes that come before the ICC, but they can only try either enslavement, sexual slavery, or sexual slavery as a war crime. There's a fracture in the redress. There's a fracture in the ability to get reparations or receive convictions based upon the family of slavery crimes. There is an inability to fully characterize certain factual situations that really should be characterized as the crimes of slavery or the slave trade and not placed under other inhumane acts or cruel treatment or tried to be stuffed into enslavement. And that is what has happened in the jurisprudence. So let me take you to some of the cases where you're saying, well, where is this slavery and slave trading happening, Patty? Where did we miss it? So let's go to the next case, Lubanga. Now, Lubanga, we know, is very famous for having omitted the sexual violence. But some of the other gaps that are apparent in Lubanga is a case that dealt with child soldiers. Well, whenever we talk about abduction, capture, transportation, redistribution, militia fighters, we're really talking about child soldiers as enslaved children. And we are mischaracterizing, omitting the fact that they were also slave traded via those abductions and kidnapping. So as I said, there's a legal gap. There's an inability to charge that, which leaves us an impunity gap and also leaves us a reparations gap. Can we go to the next slide, please? Again, Ntaganda, in many ways, is lauded because finally we have same-side sexual violence via the charge of sexual slavery led to a conviction. And someone said in one of the earlier panels that, yes, we have to celebrate our victories, but we have to look at them closely and find out what do they omit. So under Ntaganda, there was factual evidence of the capture of girls, the capture of adults and children, their transportation and their distribution. But because there was no war crime prohibition of slavery or the slave trade, they had to characterize those facts under headings such as inhumane treatment or cruel treatment. The legal gap of the inability to charge really left an impunity gap and also a gap in the reparations. Let's go to the next slide, please. Again, we find the same thing occurred with Ongwen. Now, here you can see, I think as Leila presented, that crimes against humanity is a huge percentage of the charges that come before the International Criminal Court. But under the Rome Statute, we do not have slave trading as a crime against humanity. So in Ongwen, although we had evidence of abduction, kidnapping, and then a redistribution of both adults and children, sometimes the children are redistributed as child soldiers given to various militia groups, or the girls and the women who had reached puberty were delivered, redistributed to fighters so that they would have forced conjugal relationships. As a matter of fact, forced marriages, as Valerie will speak on. These are all acts of slave trading, and they contain facts that would be characterized as slavery under war crimes. But because of that legal gap, that impunity gap, there could be no charges of slave trading, even though some of the forced marriages were, in quotes, transferred, slave traded among several fighters, and some of the child soldiers moved between several units over tens of years. Can we go to the next slide, please? So I hope that you understand that the amendments to the Rome Statute that Sierra Leone is proposing really come from a treaty-based legal framework, a customary international law-based framework. And there is a sequence. As a matter of fact, slave trading, the acts, the facts, the crime of slave trading usually precedes enslavement. So persons are slave traded into slavery or enslavement, slave traded again to another situation of enslavement, slave traded again to another situation. There's a factual sequencing of these two crimes. And that is why they appear in conventions, the 1926 Slavery Convention and the 1956 Supplementary Slavery Convention together, because slave trading and slavery are related, both factually and criminally. But the Rome Statute has completely disrupted that international law framework. Can we go to the next slide, please? When we look at crimes against humanity and we understand, and I hope now you understand a bit more of what is slave trading, you can say that slave trading is a persistent means of attacking the civilian population. As I've stated, it's appeared in most of the situations in the International Criminal Court. Judges constantly have facts of slave trading before them. Also, since justice for slave trading is legally inaccessible, they cannot discuss it in the judgments. There is an interesting couple of paragraphs in Ntaganda and some other judgments where judges have said, well, the girl was transported here for sexual slavery, but I can't characterize those facts because they couldn't be charged. So there's a legal inaccessibility due to the omission of slave trade under crimes against humanity. Next slide, please. And also when we look at slavery and the slave trade under war crimes, I'd like to underscore that both of these, slavery and the slave trade, are peremptory norms. So under international law, under international criminal law, and under international human rights law, they hold the highest value. They're jus cogent peremptory norms, or the non-derogable human rights norms that could be and should be included under persecution when there's a denial of fundamental rights. You have a right to be free from slavery and from being slave trade. yet they've been left unenumerated, unaddressed. And hence, without this redress in the Rome Statute, we're unable to have complementarity come through in the jurisprudence of national courts who belong to the Rome Statute. I would like to also state, just before closing, is that there have been many discussions that I've heard throughout this conference that talked about the coloniality of international criminal law, that talked about discrimination, and that talked about the gender content. We have to look at slavery and the slave trade as being thoroughly, absolutely thoroughly gendered. There is a reason why girls are taken in to be enslaved, whether to be ting-tings or then to be forced into forced marriages, and why are boys captured in order that they can be the masculine stereotype of the male child soldier. These are gender that drives the crime. They have gender impacts. And by not having slavery and the slave trade in, there is another very important issue that's not addressed. We actually tend to separate out the facts of the reproductive violence, such as the forced pregnancy, such as the sexual violence, the forced mutilations, forced sterilization. They seem to be taken out of enslavement and taken out of the drivers of slave trading. We know very well, such as in the latest cases before the International Criminal Court, that some of the women and girls were abducted, kidnapped, i.e. slave traded, into militia groups so that they could reproduce. They were slave traded so that their procreative capacity would be used by the militia. But I also want to say we have to reimagine and be much more attentive to see that slave trading and slavery is happening in the migratory patterns that are going through Libya or through Djibouti. We also know that slavery and slave trading were essentially structured under ISIS for the Yazidi population. And so when I heard Yasa speaking, it really reminded me that both of the survivors, be they the mothers or the women or the girls or the boys who became child soldiers under ISIS, were placed in slavery and they were slave traded. As a matter of fact, ISIS is the only perpetrator group I know that named their administration the Slave Trade Administration when the enslaved had to be passed among different families. So let me go to just my last slide as I tell you, thank you for listening. But I also want to say that by including slavery in the slave trade, we're rectifying a drafting oversight. We're strengthening international criminal law, and it already has cross-regional support between the EU and the community of Latin American and Caribbean states, between the group of friends of the African states. We are talking about correcting a wrong. Why do we persistently not say the word slave trading or fear looking at the breadth of slavery? Because slave trading has colonial and racial implications. Slave trade reminds us of the harms upon which many of the Western world was built. I would say that therefore, in remembrance of those harms and of those who are harmed and their descendants, but also in solidarity for those who are enslaved today. And I would even stretch out to say, within the case of Syria, when we look at the detention where people are disappeared, we need to ask ourselves, are people exercising powers of ownership over those detainees? And as they are moved around to different detention facilities, are they being slave traded? We need to break open, see the stars of really liberty and freedom that I believe that slavery and the slave trade being amended into the Rome Statute might be able to afford us. So last slide, thank you very much for your attention, and I welcome your questions.
Thank you, Patty, for laying this out for us very comprehensively. We'll now turn to Kim. Kim Selinger is a professor at the Washington University School of Public Health, and Kim will bring in the lens of health and social sciences and how they can more substantively be included in the practice of international criminal justice, which should strengthen understanding and prosecution of gender-based crimes, and should also show us how our field can break disciplinary silos. So Kim, over to you.
Hi, thank you. It's nice to see you all. And I promise you I'm actually still a lawyer, but when I went back to the university after spending some time here in The Hague, I situated myself in our new School of Public Health, specifically because I was starting to see that there is a role for health sciences to play in building international criminal justice and strengthening, in particular, areas that we don't articulate very fully, including gender-based crimes. So it's a new place for me at the university, but it's actually very exciting. So I want to tell you a little bit more about what I'm thinking. And we know, of course, I mean, I think it's quite clear to everyone that academic research has a value and has sometimes been useful to work of practitioners, international criminal justice. We know that sometimes in cases we've looked to like anthropology for context when we try to understand local culture and history, for example. History itself is important. Political scientists can give us insight as to the dynamics of armed groups and trends over time in an armed conflict, for example. But I will focus a little bit on the health sciences, so medical and public health literature and what they specifically can give us and how that can help us articulate gender-based crimes more clearly. Because I remember, the mandate, the request of this session was to sort of think about what we want to do a little more going forward that perhaps we haven't been doing as much as we could. So I thought I would just present 5 ways that the health science literature and health sciences themselves can help us in our work. So one is simply understanding forms and impacts of gender-based crimes. I know it sounds pretty obvious, and there's some forms of gender-based crimes that we're quite familiar with. We've been talking about for a long time. We work with survivors. We understand many, many things. But so, for example, yesterday, we had an incredible session on reproductive crimes and reproductive violence. And it was very interesting to think about how we haven't articulated all of this. We're not thinking about it. And if we think about it, maybe we're limiting ourselves to the ideas of forced pregnancy or forced abortion. And we look maybe at conduct when we talk about reproductive crimes. But do we really understand what forced abortion entails in many of the contexts in which this could be charged, right? Do we understand when we are looking at populations where we're seeing recurrent spikes in requests for forced emergency contraception at different times, or increases in rates of sexually transmitted infection, or fistula? Do we know as lawyers what fistula are and what, besides early childbirth, can cause them? What kind of injuries can cause fistula? There's a lot that's happening to women in particular, but also men and folks who are non-binary in a lot of the conflicts that we work on. And we may not be recognizing the types of reproductive harms that they are suffering as a result of conduct we know how to charge, but we're not looking at the impacts, the longer term impacts. So even if, so for example, if we take forced contraception, we have cases where we know in detention, for example, women come out and they report that they were told to take vitamins. Maybe they didn't know they were contraceptive. They don't often know even what they were forced to take, right? But sometimes we'll see changes. They've lost their period. But are we asking about that? The healthcare providers they see will sometimes have a glimpse of this. But if we, in our missions, in our investigations, aren't asking about things like that because they seem quite sensitive, or we're not sure culturally how to approach these issues, we'll miss indications of things that were happening in detention, for example, that could be indicative of other crimes. Why would women in detention be forced to take contraception, right? That proves something, systematicity. It shows some knowledge, right? It shows things that perhaps we're not getting at if we're not understanding the health condition of former detainees. So this, when we talk about gender-based crimes that we already are thinking about, that's one area where we can fill in some gaps with the health literature and educating ourselves on medical science. What about other crimes that are not gendered on their face, right? We talked in the gender-based crimes policy that the OTP released in 2023 about the need to take a gendered lens to all crimes under the Rome Statute. So many crimes under the Rome Statute can be gendered in some way, whether in their motivation or their impacts, or and sometimes their form. We've been talking a lot these last 2 days about starvation, which we see not just in Gaza, but we see in parts of Sudan, and we see in parts of DRC, we see in parts of Mali. Sometimes this might be a crime under the Rome Statute, right? But, and we saw it in Tigray too, and the Physicians for Human Rights did a wonderful presentation on their recent report yesterday. And in Ukraine, that's right. But do we as lawyers and sometimes judges perhaps understand how starvation even works and how serious it is and how it affects different humans differently, depending on age, depending on gender? So since coming back and being in the School of Public Health, I've been spending some time talking with my medical and public health colleagues who focus on severe malnutrition. And so I've been educating myself because I realize I want to help educate all of us on this. Starvation, it works in very methodological and in quite well documented ways, right? First 24 hours, your body starts consuming up its glucose. And then in weeks, for the next couple of weeks, you start slowly eating your own muscle. Your body is finding its fats, it starts taking its proteins. And then throughout this process, there's weight loss, of course, but compromised immune function, organ damage, including to your livers and your kidneys. Major impacts include mortality because of the immunosuppression and not getting vitamins. You become susceptible to all sorts of infections that you wouldn't normally. You wouldn't have a couple weeks, months earlier. And this becomes the leading cause of childhood death in children who are severely malnutritious. It's infection, actually. Preventable blindness. If you don't get your vitamin A, you start losing your eyesight over time, right? And then, of course, there are brain impacts. Long-term cognitive decline or compromised function. It affects your memory. It affects your ability to learn. Age matters. Fetuses, of course, they'll be born with low birth weight. They'll be small for their age. They may be born premature, which has its own set of complications. They have compromised brain development. Young children will experience something called stunting. They'll never reach their full physical development, actually. They'll be underweight. They may be more prone to type 2 diabetes. Older adults, their existing frailty will be exacerbated. They'll have cognitive difficulties that are even worse than what they're already experiencing. And there are gendered aspects, right? Adolescence, the effect of severe malnutrition on young women who are starting to menstruate. They will lose their periods in some cases. It's amenorrhea, right? They will not have that fully function cycle. Women of all ages can have that. Pregnant, lactating women, obviously, you don't get your nutrients, your breastfeeding is compromised. That passes on, of course, to your child. Higher rates of miscarriage, as we've heard these last 2 days. Just insufficient weight gain for the mother, which has direct consequences for the child, right? There's also literature documenting impact on sperm count, which is, I think, something that might get the attention of some of our investigators and judges who don't think this has anything to do with the case or isn't serious, right? And then, of course, the intergenerational impacts of starvation. Because of the things I just mentioned, you have sometimes reduced schooling and eventual earnings in a family. It may affect decision-making about reproduction. In times of scarcity and uncertainty and insecurity, people make different decisions about whether they're ready or can reproduce now. And then there are epigenetic consequences too. Over time, the stressors, these impacts can suppress expression of certain aspects of people's DNA. And so you'll see that in the next generation. So what does this have to do with international criminal law? This is just the example of starvation. We could talk about a number of different harms that people suffer. So we have a war crime in Article 8, 2B, 25, right? We have starvation as a method of war. Fine. This means the perpetrator deprives civilians of objects indispensable to their survival, is the first element. And they intended to starve civilians as a method of warfare. It doesn't say much more than that. So we can look just at conduct, right? But if we don't understand exactly what is happening, we lose the opportunity to explain fully in a narrative and really explain to the judges that this is a deep, deep harm, and it has many different impacts that that should be accounted for. It may become relevant in sentencing recommendations. Victims' counsel can use medical and health science to articulate reparations priorities in case of conviction, right? Because sometimes we're not just looking at the harm that someone suffered that day or what's in front of them. If you know the long-term impacts of someone who is suffering this, you can think about what this person in this community will need 20 years from now. And that's important for how you think and approach reparations. So I've also been thinking about whether health science knowledge gives us exactly what Layla was talking about. Our gender-based crimes fall apart often, or we have challenges when we try to talk about motive liability. And I was trying to think, does any of this literature help us with that? And I'm still thinking about it, but one thing that occurred to me was, say, for example, you have a state actor who's committing certain crimes on one hand, and with the other hand, through their whatever system they have, they're funding research on exactly the types of harms that arise from this type of conduct, right? It doesn't quite get you to your individual accused person potentially, but you start to see that it's not plausibly deniable that a state is unaware of the consequences of certain conduct it might be engaging in. So another area where this type of knowledge, health science knowledge, can help us with is, of course, with interactions with survivors. I won't go on about how important the literature on trauma is. We've all been, I think, for the last several years talking about trauma-informed approaches and how important that is. But I was thinking about how, if in the course of investigation, we have not built out referral pathways properly, it might be useful to talk with the healthcare providers and those who work in this field about who they refer to for services, both physical and psychological. And also, are there certain medical conditions that we might anticipate in a community that makes people invisible to us? The people who are most vulnerable and can't get to us, is it because they have medical conditions, they have physical disabilities, or they've been ostracized because of incontinence due to fistula? There are health reasons that people don't become visible to us when we conduct investigations sometimes, and we have to consider that and understand what might be affecting people in a community where we work. Fourth reason that it might be useful to think about health science is, of course, in case development and evidence analysis. Obviously, sometimes health sciences can be a source of raw evidence, right? You have experts who can talk about certain types of injury or sequelae from torture. You might have forensic evidence in cases, which we don't have the opportunity to use often enough, but then medical records and analysis. Again, PHR talked about this in their study yesterday on Ethiopia, but sometimes we might be able to get access to clinic level, hospital level medical records that could be de-identified for our purposes. But do we even know what to do with them? Do we have the capacity to run that analysis? If we could, we would understand the types of injuries, the types of treatment that people in a community sought at certain times, which might correlate with troop movement or attacks that we know about. You'd see spikes in requests for HIV testing, right? You'd see spikes in other types of requests for health, which is just another brick in the wall of building the case. But this is something that we're not exploiting enough, and we don't necessarily have the expertise on our own to do that type of analysis of medical records. This is where folks from the health sciences can help. There are also studies that already exist. Many of the questions people might have about health are answered in the literature already, but lawyers and judges counsel, we're not trained to really read or understand or even find some of these articles. So there is a need to know what the questions are, how we find the answers, and convert them into a format that is usable for practitioners, right? And where an answer doesn't already exist in the literature, it is the social science folks and probably public health folks who can help devise the study to get it answered for you. So this is that was my fifth thought, that the existing research and knowledge is already useful. You just have to know how to find it, and it has to be in a format that is accessible. And then finally, institutional issues. This goes back to something Michelle had told us and reminded us of in the very beginning in your opening keynote, Michelle. She very rightly pointed out that we are producing good policies on gender-based crimes, for example, and gender strategies for our offices, even how we run our institutions. What we are lacking is implementation, right? Not for lack of will, I think, we're trying. But the challenge is lawyers and judges are also not trained in the science of implementation. And the people who are not with us in our institutions, right? This is the domain largely of public health, actually, in medicine. So how do we conduct a process evaluation? How do we conduct an impact evaluation? How do we know we're doing what we've committed to doing? We need help with that, actually. And we need to get that from outside of our offices a lot of the times. So that would be the fifth area that I would mention in terms of institutional issues. It also reminds me of, she's not here right now, but Catherine O'Rourke's comment about the WPS agenda and what that has to do with ICL. Some of that agenda, for those of you who work in the WPS space, it's based on a promise and a premise that the prosecution of conflict-related sexual violence has deterrent or preventative value, right? Maybe. We hope that's the case. It's part of why we all do it, I think. There's no empirical evidence for that at all. And part of the problem is because we're not talking about the same thing. We haven't learned to measure deterrence in the way that makes sense for this context of work. It's different than a known perpetrator in a domestic legal system, right? So if we want to bridge the gap between ICL practice and that part of the WPS agenda's promise, we have to understand, is what we're doing having true preventative value? And if so, how do we know? How would we measure that? And that is an area that is live for research in the next quarter century of the WPS agenda. So I will close because we were asked to make one recommendation actually for practice. I'm trying to keep this super concrete and practical because that's all I know how to do. I want to start a project with you all, and I want to build a machine based not just at my university, but others, where we can collect your questions about health, whatever you're thinking about, whether it's about the health violation the survivors you work with have suffered, whether it's just about how you should interact with people in a trauma-informed way. We're going to pull those questions together, and we will figure out what answers exist in the literature, and we'll get it to you in a format that you can use if you're an investigator or a judge or whatever it might be. If the answer is not in the literature, we'll think about how to design a quick study to get you the closest answer we can. But I think that is a service that I don't see yet. We don't have a way to bridge that and do that conversion exercise. So stay tuned. I know how to find you all, I think. I'm going to ask for help from Alex, I think. But that's what I'm thinking about, something to do moving forward that we haven't done yet. Thanks.
Thank you, Kim. We're very grateful to benefit from the spillover effect of your education and research. And please, everyone, do think about Kim's recommendation and do get back to her. And finally, in the true spirit of interdisciplinarity, although technology is maybe not a discipline yet, but is definitely an area and a field that requires more of our attention and it's becoming very present in our lives. So we have Valerie Osterfeld, professor and Western Research Chair in International Criminal Justice at the Western University Faculty of Law. And Valerie will guide us in understanding an area that is both urgent and complex, and in my view, underexplored in our field, and namely feminist approaches to technology and artificial intelligence. Valerie, we look forward to hearing from you about the risks, opportunities, and how to seize the possibilities of technology to strengthen justice while also ensuring that these digital tools and technology in general do not reproduce or amplify existing inequities. Thank you.
Thanks so much, Valeria. And I'll begin by saying I don't know all the answers to those questions, but I will tell you about what we've been working on. So I'll just begin by mentioning that in May of 2023, the prosecutor of the International Criminal Court stated that in order to pursue justice more effectively, new technology must be harnessed in investigations, and clearly that is happening. Technological tools are often used now to collect, to organize, and to interpret evidence in the investigation of ICL crimes, including sexual and gender-based crimes. And this includes, most often, recording survivor statements, also using digital photos, videos, audio files, scanned text satellite or drone imagery, electronic maps, 3D imaging, and voice or facial recognition programs. And databases help to manage all of this information, and artificial intelligence, or AI, is being used to identify patterns of abuse, connect perpetrators to command structures, and corroborate data. And over the last few years, I've had the real privilege of co-leading a research project, which is just wrapping up, funded by the UK's FCDO through a program called Accept, and involving an amazing team, which includes Natia Novrazov and Katerina Busol, both of whom you heard from yesterday, as well as others. And our project looked at how the use of technology in conflict-related sexual and gender-based crime investigations and documentation carries with it both risks and benefits. And we were honored to interview many of you in this room and also people from your organizations, and I want to say thank you in person. Now, what we were told is this: some progress has already been made in anticipating and responding to risks. And this includes in the areas of data protection. So, for example, to mitigate the risks to survivors that their identity or experiences will be publicly revealed through hacking or poor data management, international and domestic courts and investigative bodies have adopted rigorous data protection protocols. This is a step forward. Also, there are better protocols around informed consent these days to ensure that sexual and gender-based crime survivors understand the use to which their information will be put, and these bodies have improved their informed consent protocols, especially with respect to who they will share this information with. However, yesterday we heard from Thomas that there's room for improvement. Also, there has been improved training on technology. Courts and investigative bodies have also improved the technological training of sexual and gender-based crime investigative and documentation staff in survivor-centered and trauma-informed ways. And again, they have mentioned, though, that much more could be done in terms of this training. And also leveraging emerging technology. These bodies have also leveraged the use of emerging technologies like AI to better analyze sexual and gender-based crime information, including to spot patterns and to link ground-level perpetrators with those in the chain of command. And I don't mean ChatGPT, just to be clear, because ChatGPT is not secure, but what the investigators we talked to were referring to was proprietary AI within evidence management software. And I should mention, though, that a number of investigators with international courts and investigative bodies told us that they had to train the AI. They had to train the AI to do this because software developers tend not to pay any attention to sexual and gender-based crime investigations when they design the software. Now, we came away from these interviews with a sense of where more can be done, and I'll talk about that now. First of all, a number of experts we spoke to urged the establishment of a standardized framework or some kind of guidance for the use of technology in sexual and gender-based crime investigations that incorporates best practices, in fact, the practices many of the investigators we talked to had created, and also best practices from database managers. And this would help to ensure a common international approach and perhaps domestic approaches to how sexual and gender-based crime evidence is collected, is stored, and is used in judicial proceedings, including to preserve the narrative integrity of that evidence. Now, I'll mention here a helpful tool because we were asked to mention helpful tools. And for those working on open source information on sexual and gender-based crimes, you probably already know about the open source practitioner's guide to the MURAD code, which is in the pilot version right now. Investigators called for fit-for-purpose tools I mentioned this already. Private technology companies should, in their view, work with investigators and documenters to develop new technological applications that will improve not only sexual and gender-based crime investigations and survivor interviews. For example, a number of people talked about the need to include translation and interpretation software within the investigation technological tools, but also to assist in the capture of sexual and gender-based crime-related social media posts, and to identify indicators of sexual and gender-based crimes using AI in a safe and confidential manner. Many of the investigators also called for the creation of a universal information preservation system. For those of you who work all the time in international criminal law, this will not be a new call, but such a system, everyone felt, should be developed to allow responsible actors to ensure the long-term safety of their evidence and testimonies regarding sexual and gender-based crimes, and in fact, all evidence, and still allow controlled access to that information. This would have avoided the terrible situation that Natia mentioned yesterday with UNITAD, in which the closure and the transfer of all of the data from Iraq to the UN headquarters in New York means that reams of sexual and gender-based crime evidence is locked up and is unusable, to the dismay of all of the survivors that trusted in the process in giving their evidence. We risk the same with the Residual Special Court for Sierra Leone and the International Residual Mechanism holding the ICTY and ICTR data. In this moment of budget cutbacks and political pressures to close accountability mechanisms and lock up their data creates huge risks, including in the future historical revisionism by hostile actors who will deny in the future that sexual and gender-based crimes ever happened in those conflicts. And building on the conversation on the last MENA panel, this keeps information divided, which is always to the benefit of those who don't want gender justice. So the United Nations and states must put in place plans for long-term management of data that involves upgrading and maintaining digital systems to ensure the long-term retention and protection of that evidence and victim identities, as well as controlled access. One last point. It was very, very interesting for our team to see through all of these discussions the opposite side of the coin. How technology is being used to commit crimes against humanity, genocide, and war crimes, or deepen the impact of these crimes under international criminal law. It wasn't our original intention in doing this project to uncover this, but so many people pointed out ways in which they had come across digital evidence showing that technology was being used to commit ICL crimes. Katerina mentioned yesterday how Russian forces are using tech to create as much widespread harm as possible through recordings of sexualized torture by photographing and videotaping it. And Kifaya mentioned today how this is also happening in Palestine. And Natia can tell you how ISIS used encrypted apps and the dark web to sell Yazidi women and girls as slaves. So I think that the next step of our work together is to surface this form of sexual violence, sexual and gender-based violence, and explain the various permutations of technology-facilitated sexual and gender-based violence, because it's only going to grow and change over time. And I'll end here.
Thank you so much. So I hope together these interventions have pointed you towards a vision of our field that's more dynamic and better prepared for the future, and that you've thought not only to critique what exists, but also to build with intention the tools and treaties and practices that will be required in the future. I'm very, very sorry to deprive you of your right to ask questions. I've been instructed very strictly not to give you this right, because we're almost 20 minutes over time. But thank you so much to our speakers, and thank you for listening.
Thank you, everybody. Bye-bye.
So sorry, Patty. So sorry, Layla. Blame me. We're coming to the end of the day. I know you're desperate to ask questions. There is the butterfly bar afterwards. Okay, I'm sorry. I know, but people already started to leave, so we do need to wrap up, everybody. Yesterday, I said if you come away with just one new idea, one new alliance, and one recommitment, then we have already made a success. Change does not happen overnight. It takes time, but gender justice can't be a dream. And I think we've shown in this room over the last 2 days that if we work together and if we work with like-minded member states, we can make a difference. So let's keep talking loudly and let's keep taking strategic legal action together. I want to now put your hands together to thank some of the teams from Women's Initiatives for Gender Justice and Law. Well done them. Where are they? They're somewhere here. When they finish these conferences, they say, phew, we survived. So well done. Thank you to them. Thank you very much to all of you who've traveled so far to be with us for the last 2 days. And thank you very much for the support from all of the organizations and particularly to Australia. Thank you very, very much. And particularly to the ambassador. So let's keep fighting, everybody. Okay. What? Keep fighting, keep dreaming, take away the energy and the inspiration back to the front lines. We stand by with all the women and the men across and different genders who are fighting for gender justice. Thank you very much. And now let's hear from the amazing Michelle.
Thank you, Antonia. I mean, it's really a pleasure to be able to take just a few minutes to give you some thoughts about what's come out of this amazing 2 days of discussion. And I started by talking about the vision that we've had now for a long time, maybe even a decade, of creating a practitioner-focused discussion like the one that we've had over the past 2 days. So maybe to return to where I started, I think it is really testament to the power of speaking our vision out loud and understanding that eventually our words can create reality. And that's what we've done over the last 2 days. But of course, I have to add my thanks to the amazing team, the organising committee behind all of this. It is at the end of the day a relatively small team, and I think you can imagine what a heavy lift it's been to tame all of the moving parts, the online facility, the app, the translation. It really is an amazing effort, and I'm so grateful to you all for believing in this and helping us bring it to reality. I think we've had a lot of, I started by saying it was going to be a bit experimental this year because we are still figuring out how to have this discussion. I think it's obvious that we're trying to bring in many different audiences. We have those we know who are already converted to the idea of gender justice, but of course we also want to reach a broader community of practice as well. So we have many things to think about, to take away in that regard. But some things that I think really worked well, that where we achieved our objectives for this first discussion, were around the link between academia and practitioners, which I'm so happy about to see how that has worked in practice. We heard, of course, Louise Chappell talking about how they're going to now move forward with practical approaches to the feminist judgments methodology. We had a very, I mean, amazingly opening of a Pandora's box on the WPS agenda. We'll come back to that. And Kim, I thought your intervention just now on public health and how the research that's being done in that field could be made available to practitioners, your offer of the project to really link people asking these questions inside accountability institutions with the experts who are doing the research on this, the multidisciplinary approach as well, is exactly where we need to go. I also really liked the MENA session. We had fantastic panels on Palestine and on Syria. And then, of course, we had the strategy session on the MENA region. And it's really reaffirming, I think, to even hear some of the colleagues from the MENA region talk about the fact that they don't normally have a space among themselves to talk about these issues in a strategic way. And I think it's really obvious that this is the tip of the iceberg. It's the beginning of a conversation, but I think we've shown how effective that conversation can be and how we can make a difference. We know that we've really just started sowing seeds that need to be tended and nurtured and grown. And we really have that commitment to following up on so many of these threads as part of the Gender Justice Practitioner Hub approach. We talked a lot about reimagining. I think that word came up in many parts of the conversation. And I know for me, coming into this conference, I'd really been thinking about the state of the world and the need to reimagine humanity. And I was really touched by the session on Palestine and Yuli's comments about how can we have a version of humanity that stands by while a genocide is happening. And I think that just really underscores our need to go back to that big picture vision of what do we want to be as a world community, and how can we enlist gender justice in that project. Some of the other really touching moments for me, so many, but Momina, your comment about women in Afghanistan, and if they can resist and have resilience and keep standing up for gender justice under the conditions that they are experiencing, what is our excuse? I think is what you said. And that is definitely going to stay with me, and I think with a lot of other people. And I think about the Syrian women that I've worked with now over 8 years. It's been only a part of their journey over the past 14 years. If you think about what has happened in Syria, we heard Seema talking a little bit about the reality of government oppression, armed group oppression. We had ISIL appearing for a period of time in the midst of the conflict, more government oppression. Then natural disasters, earthquake, you name it, everything has happened in the context of Syria. And yet we saw today from the Syrian women their capacity to keep insisting on a better vision of the world and a better way forward. So we definitely pledge our solidarity and support to all of you, to all of the women who are on the front lines in all of the country contexts. We had a very valid comment today about what about Yemen? What about other countries where the conditions are really dire and we're not speaking enough about it? And we know we can't cover everything, but our commitment is that this is not going to be the end of the conversation, and we will find other ways to move forward. I did just want to mention on the note of solidarity and supporting each other. There is in the conference app, a resource which is offering, supported by the Gender Justice Practitioner Hub, an opportunity to connect with an online workshop on Monday, the 6th of October, run by two women, Vorian and Rita, who are working extensively with supporting women to influence in the face of resistance. It's a free workshop, so do feel free to have a look at that and access it if it would be helpful to you in your work. And I just want to finish by maybe getting strategic in the end. After all, that's what we are wanting to move forward on, is concrete strategies. And I think for me, what comes out of the discussions is the need for us to really start looking at the whole ecosystem that affects our prospects of justice. I think, Antonia, you mentioned it actually in the context of the ICJ cases. Like, let's get prepared. Let's have a long-term view of what the steps are going to be. How do we need the documentation to come together? Who do we need to advocate for, or what skill sets as judges on the bench of the ICJ in order to make sure we have the broad perspectives and expertise on gender. And these are things that need advanced preparation and strategizing. But I think more broadly, if we take the opportunities that are opening up in Syria right now, let's do that. Let's map what has to happen in each part of the ecosystem. Where do we need to look at the intersecting components? Legislative reform, referral pathways, of course, documentation, expertise inside the system. It's so encouraging to see people like Jemana now being in positions where we can actually have some influence for gender justice. So many things to follow up on. And I want to end by just again thanking Australia. Ambassador, thank you for being with us. And I think were it not for Australia's confidence and belief in the vision of gender justice and the fundamental tenet that we can do better with space to convene, with a strategic approach, we can improve our gender justice outcomes dramatically. So we have an opportunity, we have an opening, let's make the most of it. Thank you.
So, well, firstly, just a huge thank you on behalf of Australia to the organisers, including the team, of course, at the Gender Justice Practitioner Hub, Legal Action Worldwide, Women's Initiative for Gender Justice, and of course our hosts here at the International Institute for Social Studies, as well as everyone involved, all the panellists, practitioners, participants here. A huge thank you on behalf of Australia for creating an amazing conference and an amazing confluence of amazing people, and I have no doubt we'll see some really important ripples of hope coming out of this. And a couple of reflections from our point of view. I think over the past 2 days we've heard from the people who matter, from practitioners, from survivors, from legal experts, activists from every region, bringing unique perspectives and lived experiences. That's so important. Real people bringing their real experience to the really urgent work. We all recognise it is urgent of embedding gender justice into international accountability processes. And this conference provided the space for us to share ideas, strategies to build resilience and move beyond the rhetoric to real results and survivor-centred action. And we've seen the highlighting of the escalating attacks on the principle of gender justice. We've seen the persistence of gender insensitivity in legal frameworks and the reality that conflict and oppression continue to disproportionately harm women, girls, and gender diverse people. And we've explored how solidarity can be part of the answer there, across roles, across disciplines. We just heard from the health sector, and regions can strengthen our collective capacity to resist these negative pressures that we are seeing across the world and help to continue to drive positive change. And we really appreciate the thought that's gone into a really comprehensive and substantive agenda, including about building more gender-sensitive accountability institutions, about the horrendous challenges that we are facing in the Middle East and North Africa, issues around reproductive violence, around reparative justice, and also gender at the ICJ. And then I'd like, if you'll bear with me as an Australian, again to mention the incredible role of Judge Hilary Charlesworth. We've been talking about the importance of jurisprudence from the key international institutions and their Hilary's groundbreaking work in bringing into international discourse the gender dimensions of development, application, and interpretation of international law, starting with her seminal article back in 1991 on feminist approaches to international law and her groundbreaking book, Boundaries of International Law, a Feminist Analysis, which really brought feminist approaches to international law into mainstream thinking. It was revolutionary at the time, but now it's there. And of course, the fact that she is now a judge in the highest court in the world and applying. You can read about it now in her opinions, in the broader judgments, and we need to see more and more of that going forward. It's just the beginning, I think. It's so important. And the sessions, of course, have been very rich, very varied. We've learned about practical methods for building solidarity and bridging silos, and examined the urgent need for coordinated advocacy, and discussed how applying a gender lens can fundamentally shape better justice outcomes. And we've seen how the Women, Peace and Security Framework can help strengthen the integration of gender into international criminal law. Now, there's challenges there. There's a sense of tiredness sometimes and frustration, but we see the connections. We see the need to bring these things together. And we've also critically assessed limitations of existing international tools in local contexts and looked at strategies for adapting global resources to survivor-led and approaches that are grounded in the context, the real context in the ground. And throughout, we've provided space for critical reflection, for creative working together and forging new alliances. And we're definitely seeing that happen. And as Australians, we're glad to have supported this conference and, of course, also the Gender Justice Practitioner Hub, not least because we understand we will be more effective in preventing conflict and achieving and maintaining international peace and security when our efforts towards gender equality and a gender-sensitive approach to international criminal law are united, coordinated, and sustained. But as we look ahead, we must acknowledge that there are real roadblocks to our progress. Rights are being wound back across the world in various regions. Funding is being diverted. The voices of survivors and advocates too often are not being listened to. And so the work of this community here is all the more important when we are facing these headwinds. And for our part as Australians and as the Australian government, we recognise the need now more than ever to step up and to really work hard to give meaning to our National Action Plan and to our international gender equality strategy. We will continue to invest in women's leadership, in survivor-centred justice and partnerships that strengthen accountability for serious international crimes. So that's as a government looking outward. But I think it's always important to say that we in our own organisations, in our own groups, that we walk the walk, that we believe in what we are doing and we practice it, because only then can we really, to the world, be authentic and achieve the results we need. And to say that I, as a senior person in my organisation, cannot look you in the eye and say, I am in this role here talking to you because of my merit, because I cannot, because our organisation, and we now have the evidence through work we've done recently to show that we had a biased system that favoured men to get into senior positions. That has changed in our organisation through a very targeted women in leadership strategy, such that now I can look in the eye our junior officers and say that you have exactly the same chance as the men, which was not the case about a generation ago. So it's so important that we do this inside our institutions as well. So we need to take forward the lessons, the strategies and the connections that we've forged here. And we reaffirm that gender justice is not just an aspiration, it must be embedded in every aspect of international accountability. So look forward to moving toward together in this work. And I would mention one thing which has occurred to me as you were talking, Kim, as well, and thinking about your important role also in the gender-based crime work of the ICC. And of course, we as Australia, together with Uganda, are chairing the complementarity and gender-based crime consultation there with the states parties of the ASP, and how the work that you are doing here, we'll be doing our best to connect that work into the ICC and into the work of the states parties of the Rome Statute as we work together to improve the policies we have, and not only the policies, but as you talked about, the implementation and making it happen on the ground, not just within the court, but also throughout the world through this kind of mechanism. So looking forward to some opportunities to really connect there. And so in that spirit, thank you all for being here, for contributing to an extraordinary conference, and wishing you all the very, very, very best from Australia for your future work together. Thank you.
I'm the last, I promise. Just to add my voice to everything that was just said and share with you how energized I feel. And that was one of the things that I was very much hoping we could do over these 2 days and really find each other in this community. Thank you again, Jeff and Bilge, for hosting us. It was such a great pleasure to work with you together. Just a few quick words. There are many resources that were submitted. They are now in the app. We will also put them on the conference website that will stay online. So please, if you have any resources or any thoughts, please send them over to us so that everybody who attended this conference can benefit from them. We will also have, together with ISS again, for their series Bliss, a series of blogs coming out from this conference with some of our speakers, some of you attendants as well. So please stay tuned for that, and we will make sure to send that over to you as well. There will be a report of this conference. You can rewatch the recordings of these 2 days on our YouTube, so don't hesitate if you missed anything or you want to rewatch anything. If you want to help us recycle your lanyards, please do. You can put them at the registration desk. If you want to keep them as a souvenir, please do as well. That's also absolutely fine. A very big thank you to our interpreters for making sure that we can understand each other. And thank you. And my last words are, see you next year. See you next year. Thank you. Sorry, I forgot the most important thing. We would like to invite you all to have drinks at the Butterfly Bar on us. So please join us. The Butterfly Bar is open. It's upstairs next to the atrium. And we will have some snacks as well, some drinks, and just some relaxation. Thank you.